Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are continuing our coverage of Suni Bell shooting trial. We are into day 7. We're on verdict watch. This is day 2 of verdict watch. So appreciate you guys joining me. And let me check my audio, make sure everything's okay. All right, who is joining us today? Let's see here. We've got Kelly and Lily Wayne. Nicola, hello. Barry Adams. Mike, might we think we'll get a verdict today? I'm thinking, Mike. I think if I had to guess, I would say verdict. But you never know. There could be a couple holdouts one way or the other. Hey Joy, how are you? Good to see you. Thank you for joining us. Sharon and Shirley. Richard in the kitchen. Red Snap, good morning to you. Virtuous, good morning. Good morning. Ellen, already saved a seat. Katrina and Sherry. Oh, that was from yesterday. All right. Or did you pop in earlier? Oh, yes, you did. All right. All right, so Amy, good morning. Hope we get the verdict today. Hey, Brenda, good to see you. And Trixie, good morning. Hi, Lily Wayne. Audio is good for you. Awesome. Thank you. Thank you. Good morning, Barry. Kelly saying good morning. Nicola saying hello. How long do you think it'll be before the verdict? Well, yesterday they wanted to deliberate for 1 more hour, and then they wanted to go home. So that was at like 4:30. So they deliberated till about 5:30. 5:44 actually. So we've seen this before where, hold on just a moment. All right, so judge is going to bring in the jury, put it on the record, then send them back to deliberate. Right. All right, sorry, just reading some messages from a source. Good morning, Melissa. Woke as joke. How are you? Vivith, good morning to you. Mama C, good to see you. Good to see you. Thank you for coming in. Kitties are playing on the tree. Yes, yes, kitties on the tree. Excuse me. So we are, I guess a judge is going to come in. He's going to put them on the record. And then we'll go ahead and we'll start the verdict clock again. So I'm just keeping an eye on that. Let's see. I don't know if we'll actually see that or not. We'll have to wait and see if they actually show that. We'll see if they actually show that. But just waiting to see if they if we can get a stream that actually shows that. Let me go over to another source. Let's see here. All right, so we do have this source. Let's get over here. All right, hold on a sec. Just give me a moment. Um, all right. Sorry guys, I'm out of sorts here on this. Just give me a moment. Okay. We'll go with that for now. All right. So we'll stay on that seal for as long as they let us, or they give it to us. Trixie, your sister has 2 foster kittens, head for a photo shoot for Chewy. Wow, nice. Very cool. Hey, Kathy. Richard in the kitchen. Good to see you, Lily Wayne. Tammy, good morning. Mary, good morning to you. Jenny G, good morning, good morning. Thank you for joining us today. All right, so we're going to pick up on Verdict Watch, day 2. Let's see here. Mallory, good morning to you. Alice, thank you for joining us. So we're hoping that the judge is going to come in. He's going to put it on the record, send him back to deliberate, and we'll get the clock going again. Let me see, where's my clock? My clock is here. I'll put the clock up over here. This is where it stopped. Let's see, we'll put the clock up there. All right, we can put it up there. So they stopped at 8 hours. 8 hours and 5 minutes yesterday. All right. Did we finish day 2 of Soto? Yes, we did, Richard. We are live with Florida versus Soto Escalera. Super T, good morning to you. So we're going to start Florida versus Soto on another stream. While we're here, we're going to pop over there and pick up on day 3. So we'll be starting that in about 5 minutes. All right. In the meantime, we can get a poll going. Kenneth White, do you think the verdict is taking too long? I don't think so. I don't think so. I think 8 hours. You know, there's five defendants. 5 people's lives are on the line. They want to make sure that they get justice for Suni. They want to make sure that they get this right. So I don't know. I think a full day is fine. And you know, they have to go through the verdict forms for five people. So I don't think so. Let's see how long. Now, we took a couple polls yesterday. We did how long will they deliberate today, meaning yesterday. So 34% said 2 to 4 hours, 28% said 4 to 6 hours, 21% said 6+ hours, so you guys were correct. 17% said 0 to 2 hours. And then what will the verdict be? 71% said guilty for all 5. 20% said mixed verdict. 5% said a hung jury, and 4% said not guilty all 5. So let's go with how long will they deliberate today. Let's go with 0 to 2 hours. We'll do the same thing. 2 to 4 hours. 4 to 6 hours. Or 6+ hours. All right, so we got another poll going. New poll going, new poll. We got a new poll for you guys. New poll. If I could type, I would get this out there. All right, new poll. So after he deals with the getting the jury back in, I'll go ahead and I'll start to replay some of testimony from like day 3. I think that's where we stopped off, and we'll get the verdict clock going again. Hey Angelique, good morning to you. Good to see you. Mary Fritz, good morning to you. Kenneth, it is very complicated. I would agree with that. This is a very complicated case. We were confused often. You know, there's 3 cars involved, shell casings, 40 shell casings, but only 2 are getting charged. But we heard all about why they're not charging car 2. 4 different 9mm weapons were involved, but 2 of them go back to James, which was he was in car 3. So it's a confusing trial. I think even we had that as one of our poll questions was, will the confusion benefit? Like, who will it benefit? You know, and it's if it's confusing to us, you know, it's confusing to the jury. So they're just trying to get it right, which I respect, and we'll see where it goes. Let's see, Barry. Woke, it is not. No, it is not. Hey, Mary, good to see you. Jennifer King, hello to you. McCormick family, good morning to you. Barry, I think they're close. I was a little lost, but the prosecutor's rebuttal closing helped tie a lot together. Yeah, if you follow the state, and all right, I'm gonna have to go jump on and start another stream, so I'll be back in a second.
Jury's back. Y'all may be seated. Welcome back, ladies and gentlemen. As you may have noticed, I have waived the appearance of the attorneys, and they were allowed to waive the appearance of their clients because I only have one question for you. Were you able to follow the court's instructions that there were no issues overnight? Very good. You may now return to your jury room to continue your deliberations. Thank you.
All right,
Jury's left. Y'all may be seated. Court will be in recess until such time we have a question or a verdict.
All right, so the jury is back at it, 8:05, and we'll play some rewatch. We'll do a little rewatch action here. Let's see. I'll put him down here.
Jury's back. Y'all may be seated. Welcome back, ladies and gentlemen. I take it there were no issues. You were able to follow the court's instructions. Very good. Cross-examination may continue.
Good afternoon, or good morning, Detective.
morning, sir.
Sir, I represent Jalen Bedward, and I believe you testified on direct examination that he provided a statement, correct?
Yes, sir.
And would you agree that he was cooperative with you?
Yes. Yes, I would.
He consented to the search of his residence, correct?
Correct.
And consented to the search of his car, correct?
I guess he did.
And he obviously agreed to speak with you
Correct.
and answer your questions, correct?
Correct.
He certainly could have legally refused to do that, correct?
Correct.
It's his constitutional right to remain silent if he had chosen to do that.
Correct.
But he agreed to speak with you.
Correct.
And he answered all your questions, correct?
Yes.
And he identified himself as the driver of his vehicle, correct?
Of the Chrysler 300, correct, yes.
At the scene of the incident.
Yes, he did.
And the vehicle, when I say his vehicle, it was his car, it was registered to him, correct?
Yes.
And he admitted to possessing a firearm, correct?
He admitted to having an AR rifle, correct?
And
other guns.
But he denied ever firing it, correct?
Correct.
Okay. And you would agree with me, Mr. Bedward is not charged with discharging a firearm during this incident, correct?
I don't believe he is.
Okay, well, may I
Look at
approach?
Yes.
Sir, would you agree with me? I'm going to show you a copy of the indictment, and count 6 deals with discharging of the firearm. Would you agree that Mr. Bedward is not charged with discharging a firearm?
Count 6, I'm sorry. Yep. Correct.
Now, would you agree with me that whether someone is innocent or not, being questioned by a detective, a homicide detective, might be somewhat of a stressful situation. Would that be a fair statement?
I would say so.
Okay. And it's likely to make someone a bit apprehensive, correct?
I guess, yeah.
And Mr. Bedward, I think as you indicated earlier, misstated that he did not make a U-turn, correct?
Mr. Bedward, he never admitted to making a U-turn.
Okay.
He kept saying that he traveled east.
And Mr. Bedward was never identified at the scene as wearing any type of hood or face covering. Would that be a fair statement, a correct statement?
He had something on top of his head.
On his head?
Head kind of like
Okay.
this area, a little bit.
And we've seen photographs of the search of his residence, and we see ammunition. Is it correct to say that Mr. Bedward was never charged with illegally possessing ammunition?
Correct.
Okay. I believe you mentioned cell tower analysis. That was not part of this case, correct?
That was part of this case. And
Okay.
that was done, the records that I obtained from T-Mobile for him was given to Sergeant Van Heist so he could analyze it.
Well, cell tower analysis is to try to determine what phones are in one particular area, correct?
Correct. That was done by Sergeant Van Heist.
You can't pinpoint exactly, but you can make a general determination of whether a cell phone is in a general area, correct?
My understanding is that actually you can pinpoint it through different measurements that Detective Sergeant Van Heist is privy to and knows how to do.
But in this case, there's no dispute as to who was, for instance, with respect to Mr. Bedward, there's no dispute as to the fact that he was present, correct?
Correct. There's no, yep, he was present.
Now, I know that you're a homicide detective. What other and obviously investigate homicides. What other investigations have you conducted in the course of your employment?
Throughout my whole career? Or
Well,
with
have
the
you
Tampa Police
done, for
Department?
instance, any type of drug investigation?
I have not been part of like a drug unit, no.
And when you are, would you agree with me, sir, that when you are conducting some type of investigation that may involve a criminal conspiracy, there are some types of investigations that you can actually pinpoint someone's intent, such as through wiretaps. Would that be a fair statement?
I mean, a conspiracy could be many different ways, but yes.
Well, if someone is charged with a conspiracy, you are trying to determine whether or not that person had knowledge of illegal activity and an agreement to participate in that criminal activity. Would that be an accurate statement?
Knowledge or agreement, yes, or acting in unison or specifically targeting a vehicle. Yes, I would say that. Fair for conspiracy.
And in some criminal conspiracy investigations, you have the benefit of a wiretap where you can have the value of recorded conversations that can determine knowledge and agreement to participate. You would agree with that, sir? Sir, correct?
If there's a wiretap, or if you have a wiretap, I've never been a part of a wiretap, so I can't
Well, I
tell you
understand. A
how it
wiretap
works.
does not exist in this case, but my question is, wiretaps have the value of determining whether someone has intent, someone has knowledge, someone has an agreement to participate, correct?
I guess.
But in this case, obviously there is no wiretaps involved, correct?
There's no wiretaps now.
So any when you're talking about any evidence regarding a criminal conspiracy, it would be inferences made based on these defendants being together in different vehicles when a fatal shooting took place. Would that be an accurate statement?
You're saying like how we came up with the conspiracy? Is that what you're asking me? I feel that based off their actions, where you see Willie Brown's vehicle drive by, you see all the
Overruled, he asked the question.
There are no relevant communications between the defendant and any co-defendant before the shooting. Is that correct?
like I said, it's call detail records that we obtained, that I obtained, and like I say, you can't tell what's being said. You know, it's either a text message or a voicemail, but there was communication between them. But there was definitely communication after, and there was some between different parts, but we'd have to look at the call detail records.
You may have communications between the defendant and another co-defendant, but not the substance of the conversation, correct?
Correct.
For instance, in some cases, you can do a cell phone analysis and get text messages, correct?
That's my understanding, is when you do an extraction from a cell phone, you can get that information. Sorry.
And in some cases, you can actually extract text messages between suspects, correct?
Whatever messages are on the cell phone that you download, is my understanding.
Sure. And in some cases, you have communications with defendants that might show that there is knowledge of something that's going to happen, something illegal, correct?
You could be able to see what communication, if there
We
was
don't have that in this case, correct?
of them communicating about the homicide or conspiracy on text message. Is that
Is
what you're
there
asking me?
any text message involving Mr. Bedward that shows that he had knowledge of anything illegal about to take place?
His phone was wiped out, no.
Sir?
His phone was wiped,
Okay.
so no.
Now, you would agree with me, sir, that someone could be merely present at the scene of a crime, correct?
Somebody could, but that's not in this case.
Would you agree with me that someone can act independently even if in the company of other persons?
Yes.
Thank you, that's all I have.
Detective Slague, nice to see you again.
Good to see you.
I'll talk to you first about when you interacted with Mr. Denson on September 28th at his residence. At that point, you didn't have a basis to arrest him, correct?
Correct.
And your conversation was consensual, meaning he could have declined to speak with you.
Correct.
In an abundance of caution, you still advised him of what his rights were, right?
Correct.
And earlier when you were testifying, you mentioned Miranda warnings. So those are what we commonly see on television, where somebody has the right to the presence of an attorney prior to and during questioning, correct?
Correct.
And they can invoke that right at any time.
Correct.
And Mr. Denson spoke to you freely and voluntarily without a lawyer being present.
Correct.
And during that conversation, you asked him about his concealed weapons permit, right?
If he had one, yes. I believe Detective Barnett did, yes.
Okay, well.
Yes,
and
but during our conversation, Detective Barnett, both of us talked to him. And
you
at the
and
same
Detective Barnett were both present at the same
Correct.
time.
Correct.
And you could hear what Detective Barnett said.
Yes.
He could hear what you said,
Correct.
and you both could hear what Mr. Denson said.
Correct.
So, Mr. Denson, he told you about his concealed weapons permit, right?
Yes.
And then he was asked if he possessed any firearms, and he volunteered that he did have a 9mm, correct?
Correct.
And he also volunteered that, when asked, the 9mm had been pawned at East Tampa Pawn and Gun.
Correct. He told me he pawned it because he was down on his luck or something.
Now, that was new information to you at that point, right?
Believe it was, yeah. We knew that he had a 9mm, but we weren't aware that he had pawned it.
You can use certain databases to determine whether individuals have purchased firearms, right?
Yes.
So
I believe, yeah. I'm not sure if I have specific access to it or if it's like somebody in our department. Yes.
So prior to speaking to Mr. Denson, you did some research on it, right?
Yes.
And somebody learned that he illegally purchased a 9mm Taurus.
Correct.
And Mr. Denson, I'm assuming that if you had known that that specific firearm that he owned had been pawned prior to meeting with him, you would have gone to East Tampa Pawn and Gun prior to meeting with Mr. Denson.
Yes.
And it was not until he volunteered the information that the gun had been pawned that you went and collected that so you could have some other people analyze that firearm.
Correct.
When somebody, earlier you spoke about when somebody goes to pawn an item, they can't do it anonymously, right?
Correct.
They have to give identification.
Yes.
I assume we can't use a loyalty card from a store. It has to be a government ID.
Correct.
And they have to also provide their fingerprints.
Right thumbprint, correct.
And in your previous experience or through your training as a homicide detective, I assume you also know that there's a database that information gets entered into that law enforcement can then search to try to help them solve crimes.
To see who's pawned items, that's what you're talking about, correct?
And so we're aware there are 2 Taurus 9mm handguns that are involved in this case, right?
Correct.
And your belief is that 2 shell casings are associated with the firearm that Mr. Denson owned.
Yeah, not my belief. The analysis from FDLE showed that the 2 rounds that were on scene belonged to the gun that James Denson pawned.
And those 2 casings were found somewhat to the extreme west of the crime scene.
I'm not sure exact the location where it was found, but I know it was amongst the like 25, I think, or 9mm rounds.
Detective Alverson was the one that ended up mapping the location of all the evidence markers and where they were found, right?
Correct.
Do you know when he put that all into his summary?
I do not.
Do you know when he provided you with that information?
I don't know. I don't recall.
Would that information have played a role in your conversations with the prosecutors in whether to charge Mr. Denson?
No.
At the time you conferred with the prosecutors in charging Mr. Denson, what did you have available to you? Okay, you had, I assume, the videos that you had reviewed extensively.
Correct.
You had, let's say, conversations with individuals.
Correct.
You had the firearm and then the comparison, right?
Correct.
Is there anything that's super pertinent that I'm missing right there?
Their statements, video corroboration, vehicles traveling, Willie Brown's statement of infinities matching up to him. I mean, there's quite a few, gunshot, audios.
But all that stuff's like contained in the videos, right?
Correct.
Okay. But we don't know when the summary prepared by Detective Alverson that tells you where the shell casings pertaining to each individual are located. We don't believe that played a role in our conversation at that point, right?
Correct.
Okay. Now, talking about some of the communications between the individuals that are involved here. You mentioned earlier that there's something called Coordinated Universal Time, or UTC, and that in our area of the country, it's a -5.
Correct.
All right. Does that change depending on what time of year it is, whether we're in daylight savings or not?
I don't believe it does.
You talked about Mr. Brown and some of your charging decisions, and so he's at 45th and Hillsborough, right?
Willie Brown, you're talking about?
Willie
right?
Brown, yes, okay.
Yeah.
So at the point at 45th and Hillsborough, given everything that you know, would you agree with me based on the position of the vehicles and the persons who are occupied in those vehicles at 45th and Hillsborough that it would have been impossible for James Denson to be involved in that situation?
Yes.
And then you would also agree with me based on the position of the vehicles and the persons that were either in or around, that it would be impossible for James Denson to have fired any weapons at Willie Brown running down 45th.
Correct.
So I know Mr. Hernandez touched on this a little bit, but based on the call detail logs that you've reviewed, you cannot tell the context or the content or of any of the communications between any of the individuals that you've described here today, correct?
Based off the call detail records, correct.
So the most that this jury should take away from that is that these individuals know each other, right?
Yes, I think that's fair to say.
Because it would be silly of me to say I don't know somebody if I'm having some sort of communications with them, right?
Correct.
Okay. I'll give you an example. Detective David Alverson, do you know him?
Yes,
Do you have his cell phone number?
of course.
Any communications with Detective Alverson in the last 18 hours?
No,
All right. Detective Neitlinger, same.
correct.
Detective Wolf.
Yes, correct. I don't even know if I have his number.
Okay. Detective Cholnick.
Correct.
So you haven't been speaking to these individuals in the last 18
Correct.
hours, right? Okay. Because you guys are here for this trial and you're under oath and you're not supposed to
Correct.
converse with anybody else. But if you did have conversations with them, am I to assume that something nefarious happened, or could you guys just be discussing the Rays game losing to the White Sox last
Correct.
night?
It could be anything, right.
Okay. Thank you for your time, Detective Slayo.
Mr. Sonardi?
Morning, Detective. I am Nick Sonardi, and I represent Andrew Thompson that you've previously identified. As I understand it, you were the lead detective in this investigation. Is that correct?
Yes, sir.
And very briefly, if you would describe to the ladies and gentlemen of the jury what your function is as a lead detective.
The lead detective, like I kind of said earlier when John Terry asked me, but they are in charge of, collecting evidence, kind of overseeing the case in general, interviewing people, trying to collect videos, whatever you can do, search warrants, and then your close communication with the state attorney's office.
And besides those functions,
Delegating duties to.
besides those functions that you've just identified, you're also, if, for lack of a better term, the leader of the band. You want a crime scene tech to do this, somebody to do this, another detective to do that. Is that accurate?
Yes.
Okay. And that's what you did back in August of 2021, correct?
Yes.
And as a result of your efforts, I believe you were able to locate a number of videos, and I'm not going to go through them, the jury has seen them, but a number of videos that you believe were of evidentiary value in this incident, correct?
Correct.
And I believe they start at the Chevron station there on Hillsborough Avenue, the videos. Well, I don't necessarily mean that's chronologically how you obtained them, but the incident starts at that Chevron. Is that accurate?
Chevron and Empire Video, I think, are pretty closely intertwined.
Okay.
The pawn shop, I'm
the
sorry.
pawn shop
Did I say
behind-
Empire? I meant the East
Okay.
Tama pawn, sorry.
And without playing the video that everybody's seen 3 or 4 times, is it fair to say that you identified at least 9 individuals at that Chevron station back in August of 2021?
I identified,
Well, let me go down.
I didn't identify the driver of the second vehicle, but the other people I identified.
Well, I know that when we look at the video that's been played, and I'd have to look at the evidence number, but of the video of the outside of the Chevron station when everybody's milling around,
Correct.
which leads me to believe that was a hangout, was it not, for a number of individuals?
That was my understanding.
All right, okay. And besides the individuals that you identified on that video, there were also other individuals there in the background walking around, so there was a lot of individuals there.
Correct.
All right, at least 9 of them you identified at some point in time, correct?
I identified all the subjects that you see here and then possibly identified the other ones,
Well, that would have been,
the occupants of the second vehicle.
yeah, Maxwell Bedward, correct?
I saw
Kawani
him
Bedward?
on video earlier in the day.
All right, so you identified him, that's what I'm asking you.
If
pursuant
I
to
identified
video.
him, yes. At some point, yes, I identified him on that video at some point.
And that's Maxwell Bedward, Kawani Bedward. You also identified a Cedric Brown and I believe a Devin Sampson, correct?
I didn't identify Cedric Brown. I believe that's who it was.
All right.
So,
All right, so whether accurate or not, you identified 9 individuals, at least 9 individuals, correct?
yes.
All right. And how many vehicles did you identify that you believe to be suspect vehicles that left that Chevron station?
How many suspect vehicles? I would
Yes,
say
yeah.
that 3 suspect vehicles?
Correct, 3 suspect vehicles, correct?
Correct.
All right, and not including, obviously, the victim's vehicle, which is a 4th vehicle.
Correct. That vehicle never pulled into the Chevron. It just seen on the video. The victim's vehicle wasn't observed.
In the video.
It's in the video, but it didn't go inside the Chevron.
Correct, so
Yes.
at the Chevron, you identified 3 suspect vehicles, and then separately, the victim's vehicle that crashed into the pole.
Correct. And also from the pawn shop video.
All right, okay. And is it fair to say that one of those vehicles is identified as an Infinity, some type of an Infinity?
The first vehicle.
All right. And then the second vehicle has been previously identified as an Infinity, possibly blue, possibly black.
No, I don't think that's accurate. I said it was, possibly an Infinity, but I don't think I officially said it was. I know that
You couldn't identify that vehicle is what you're saying, correct?
I couldn't be definitive on it, correct.
All right. Can you identify the color of that vehicle?
It's like a lighter color.
It wasn't a dark blue or black?
On the video, it looks like it's a lighter colored when it leaves, so.
Well, did we see that video, did we see that vehicle in other vehicles? Did we see that vehicle in other videos?
You see it from other videos along the route, correct?
Okay. All right. And did you determine pursuant to your investigation and reviewing the videos, et cetera, that vehicle also discharged what you believe to be weapons?
It appeared that the second vehicle did possibly fire. I could be definitive on it. You could say very distant, but you can see a muzzle flash from the Bay
So in
City
your
cabinet,
opinion-
but the Bay City cabinet video, yes.
Is that yes or no? It did discharge a weapon, yes or no?
Probably.
Probably.
I can't say definitively, but yes, I believe they did.
You believe it did? Okay.
Yes.
Do you know how many times it discharged a weapon?
I do not.
And so it's clear that you're not alleging that vehicle was occupied by Andrew Thompson, correct?
No, he was in the third vehicle,
That's
the
not my
Chrysler
question. My
300.
question is, was he occupying that second vehicle?
Andrew Thompson was not in the second vehicle.
Okay. So we now agree that you believe there were shots from 3 vehicles, correct?
I believe the second vehicle was involved, but, there's not enough video evidence or evidence to bring forward charges at them at this time.
That's not my question. We've gone through this. The answer is yes, you believe there were shots from 3 vehicles.
Objection, asked and answered.
Sustained.
Now, as to the shell casings, you instructed, I believe, 2 crime scene techs, or at your direction, I believe, crime scene tech Moore collected a number of the shell casings and actually a complete bullet out there on Hillsborough Avenue, correct?
Yes, Detective Alverson and Hill were in charge of the scene there, but yes, she did collect one.
And I believe crime scene tech Covis, C-O-V-I-A-S, also processed all of those shell casings?
I believe so. I'd have to reference the report, but yes.
All right. And why would those casings be processed?
I think they were swabbed for any possible, maybe any possible DNA or touch DNA that might have been on there.
And what about fingerprints?
My understanding is that you would do either or. Either you're going to process it for fingerprints, latent prints, or you would process it for swab it.
And are you familiar as the lead detective with the results of the processing of those 40 not projectiles, but casings?
Yes, it didn't lead to any identification.
So there's nothing of evidentiary value that was gleaned from the swabbing of the 40 casings, is that correct?
From the swabbings, no.
All right, obviously then, there was no swabbings that include no DNA that connects Andrew Thompson to any of those casings, correct?
Correct.
All right. Now, as I understand it, you may or may not know, but as a lead detective, we cannot determine the caliber of the weapon that caused the death of Suni Bell, correct?
Correct.
All right. And pursuant to your investigation, did you determine at one point in time, irrespective of who it was, allegedly in the back of the, in the Chrysler, that individual wanted out of the Chrysler?
Objection, Your Honor.
Sustained.
Now, at some point in time, you ultimately had contact with Andrew Thompson, correct?
Yes, sir.
All right, and that was at his
Is it a residence?
Apartment,
yeah.
and you recall whether or not that was at 1304 Lake Lucerne Way, apartment number 303 in Brandon, Florida?
I believe that was it. I'd have to just reference it.
Your recollection?
They lived in Brandon, and it was at his apartment complex, and he lived with his girlfriend there.
Okay, and that's where you met him there, correct?
Correct.
All right, and is that where you showed him the video that you had of the interior of the Chevron gas station?
Correct.
And did he freely and voluntarily identify himself and say, Detective, yeah, that's me in that video?
Yes.
All right. Now, he was actually arrested at that apartment, correct?
I believe he was, yes.
All right. Was anything of any evidentiary value obtained from Mr. Thompson's apartment?
His cell phone, I think. But no, I don't think anything was the apartment.
Nothing from the apartment, correct?
Correct.
All right. Now, speaking of the phone records, have you previously identified the call records of all the defendant's phones were confiscated at some point in time, correct?
Correct.
All right. And you got the cell call records of each and every one of those phones, correct?
Correct.
And you could identify if one phone called another phone of those individuals because you had all the phone numbers.
Correct.
All right. And did you do that with Mr. Andrew Thompson's phone?
Yes.
I understand obviously that it was a different provider, but you still got the call records.
Correct.
And without beating the dead horse, the call records just show what number called what number and the length of time and the date, and that's about it.
Correct.
All right. Can you determine whether it's a text or a call or
And then give her back to that. But I'll need one to read some things to them.
You'll need another copy.
I need a copy sent to me.
Do you want,
And it really can just be the standard ones, because there's nothing,
I'll forward it once I
Okay.
get it.
and then my suggestion is, rather than giving them 11 new copies that are in a different order than what they have,
Just have available
taking that one,
copy.
photocopying it.
This, we want to figure out if we can use that copy right now. Today.
Christine can use it. I hate me right now. Chris went along with your suggestion. And I just tell Christine, I said, I'm afraid of her. He means I'll be with her.
Sometimes the sign of the good jail. The sign of the good jail. People are afraid of it.
I thought myself, well, I'm pretty sure that they have
Next week, we have Wednesday, big docket, big sentencing, and the long motion for severance and executive. So I don't think we can take any cases next week. We'd have to tell the jury that we can, they'd have to be here Tuesday, skip Wednesday, and come back Thursday and Friday. Whichever they do. What's that? Oh, yes, and Tuesday's a holiday. So we only have 2 days later.
Or just want to get on with my life. Stasis.
Your place where they're comfortable overtime and
Yeah, but there's nothing we did.
no control.
No control. Stuff like that. Yeah.
You're sending to your email, right, James?
What?
Are you sending to your email? Are you forward you instructions, or do you want them printed?
You need, what did you say, you need my email?
No, I didn't know if you had it up or not.
I'm looking for it. I'm trying to see if I can
Okay.
find it.
Or do you want me to just print it for you?
You have them? Yeah, all I need is,
12C too?
That's the
Yeah,
text.
just take all
I mean,
of it.
that's the office, that's the cell phone. Get rid of that one. So immediate pause. Myself.
Your Honor, may the family come in?
Both, that's a open courtroom.
Thank you.
right, well, one of their initial questions is they all want their own copy of the jury instructions. So what I suggest is taking the copy that they have, since it's in order, and having Christina photocopy 11 other copies, so they'll each have their own. Now, their 3 instructions are as follows. 1, on each count.
I mean, their questions are.
The questions. On each count, does it have to be unanimous on the degree of guilty? Example, if 11 people say first-degree murder and 1 person says second-degree murder, does that mean they get charged with second-degree murder? Question 2, and I guess they're talking about the other charges. Question 2, if half the people are saying guilty on 1 count, but the other half are saying not guilty, does that make it a mistrial or not guilty on that count? And 3, related to 2 by an arrow, if we even have 1 juror disagree on a guilty or not guilty charge, does this cause a mistrial for the entire case or a specific charge in which we disagree? My initial response to this after speaking with my staff attorneys, obviously question 1, I would just reread returning a verdict. It should be the highest, it has to be unanimous. That's standard instruction. I'll reread them that it has to be unanimous, that all must agree on the charge, and it must be for the highest charge that you all agree on. And if you don't agree on anything, then of course it's not guilty, which is in the standard instruction.
I disagree.
Regarding question 2.
Your Honor, just a correction, if they don't agree on anything, is it hung, not?
Oh, it's a hung, right.
Right, okay.
Or they can find them not guilty.
Correct.
Question 2, regarding if half are saying guilty and the other half are saying not guilty, is that a mistrial or not guilty on that count, or is it the entire case, which number 3 and number 2 are really the same question. So if they can't agree, and it creates I'll read them, I'm going to read them an Allen charge too before I send them back. And if they cannot agree, I'm going to explain to them that any non-unanimous finding on any 1 count will not affect the findings of a unanimous count, and that if a mistrial is granted, it would only be for the charges in which there was no agreement.
I agree, Judge. I think
That's the law.
Judge, my one concern is I believe it's too early for an Allen charge. I believe it's premature at this
They've
stage of the
been
game.
deliberating for almost 8 hours.
Judge, 8 hours in the scheme of things.
They don't agree. They're obviously split on some of these counts that they don't, and then apparently there's a difference of opinion whether it's first or second degree murder. But they'll work something out. But they seems to be pretty deadlocked when half the jury says one thing and half the jury says another. Do you all not? What's the consensus on reading the Allen charge now? Because I'm not married to that idea. I could wait.
Judge, I think it's premature.
Okay.
This could just be a question that they have right now as they're voting with each other. We don't know what stage they're at.
I mean, I initially talked about waiting anyway, like I said, so I'll wait before I do the Allen charge, but I will instruct the others as to how I explained it. If you unanimously agree if you unanimously agree on 1 count, and you cannot eventually agree unanimously to the other count, the unanimous count is not affected. And if 1 or more jurors can't agree and a mistrial occurs, it would not affect the counts in which unanimous agreement was reached.
That's fine, Judge. Can you write it out and then say it so that we can hear it exactly?
That's what I just said.
Is that how it's written
That's
out?
how
Could you
it's
do that,
scribbled
Judge,
down.
please, if you don't mind?
So if you unanimously agree to 1 count and cannot eventually agree unanimously to another count, the unanimous count is not affected. If the jurors are unable to agree on any counts, any of the counts, any unanimous count will not be affected if a mistrial is granted.
It's really convoluted.
Well, that's what it is. I mean, it is convoluted, but
Judge, maybe make it short to say, like, the inability to reach a decision on 1 count will not affect whatever verdicts you find on any
not a
counts.
verdict.
Or whatever decisions you reach on any.
They don't want to know any decision. They want to know if they hang on a count, does it affect an account they unanimously agreed on? And I'm going to tell them no.
Okay.
I'll explain it like that. Okay?
Okay.
Anything else?
Judge, I think it's fair. I think you could, if you could add, if they have any count or any defendant, does that make sense? Like, you're reading
Any
the other
counts on
instruction.
any specific defendant?
I think that's really important, Judge, because obviously we're dealing with, multiple defendants, multiple counts. I think you're already going to read that instruction, are you not?
I'm going to read 312. You may find the defendant guilty as charged of such lesser included crimes if the evidence may justify not guilty. Guilty as charged or lesser. I'll read that entire instruction. All right. Now, we need to bring your clients in if you want to waive. You wanted them here.
Yes.
Now, regarding your client, would a cell phone video, FaceTime, be sufficient for him to hear?
Well, Judge, I obviously think it's important for him to understand what's going on in the proceedings.
Yeah.
I understand that we can't share a TV from the jury room and also in a closed circuit capacity for him in whatever holding cell he's in. So I would think the next best alternative would, in fact, be a FaceTime so that he can understand what's happening in the proceedings.
Okay. Who has an iPhone that they're willing to
We can do that. I can do mine. For in here, and then if Mr. Gonzalez wants to do,
You have an iPhone, Mr. Gonzalez?
I do, Judge.
You two know each other's phone numbers?
we do.
You friends on
I
Facebook?
thought you were asking me if I knew my client's phone
I
number.
don't think Mr. Gonzalez has Facebook.
No, Judge, I have no social media.
But you can video, how would he do that then?
I can FaceTime him through,
Oh, really?
through iPhone.
Okay.
FaceTime is not
iPhone's got their own thing.
I have a spare iPhone
Okay.
with no social media and
I think those would be fine. So we're going to have one deputy to stand there.
So Mr. Gonzalez is going to get his phone somehow to the holding cell. He's going to remain here. Somebody's going to take it.
The deputy will take the thing. So we're going to bring in everybody?
We'll give it to a deputy.
Yeah.
And then I will FaceTime Mr. Gonzalez.
Will the device that goes back with the defendant with the deputy be muted on that end? Can we ensure the deputy has the device muted from
Yeah,
that
we'll just
location,
unlock
that
it.
Mr. Gonzalez can communicate with his client thereafter if
Well,
necessary?
his would only, the only one that need to be muted, so it'll be the only one that's in here.
Deputies can also tell me whether or not he has any reason to want to communicate.
Right. I just don't want that to be going on.
And you can stand close to the bench if you want so he can hear my instructions. And I'll speak loudly into the microphone.
Your Honor, may I confirm the standard instructions that you have indicated you will reread these? My number.
312.
Yeah, and you can meet here. There you go.
It's like the first time I played Monopoly.
Danny's phone.
We did.
Yeah, okay.
And so, Danny, that one just might go like you facing the jury. I think it should. What do you think? Should he be hearing what the jury, what the judge says, or just audio and then looking at the jury, or?
That's fine.
I don't know. I'm just thinking.
I would like him to say,
So it's facing the jury, but he'll be able
to
to
answer
hear what
whether
they're
it would
saying.
be unanimous as to the highest counsel, which they all
You want a book?
Yeah. Right? Because I don't know if still rereading that even answers the question. See? So they agree on one.
I got a book here.
That is correct.
I got this,
They
Brian.
agree on one. Everyone says.
Even if you need something heavier, there's the evidence.
says
Air
second.
marshal is good for
Is it
something.
second? Yes. Are we able to give a definitive answer to that question?
I got it. Judge, Ms. Zismer and I were kind of talking about a little more. I know you're going to read that instruction. I don't know that the instruction really answers the question.
It answers their first question.
I'm not sure because it doesn't say, because basically the answer to the first question is, yes, it can be second if all of you agree. If everyone agrees to first, but if one is second.
Their
then
question
the answer
is, if it's 11 to 1, does the 1 make it the crime? No, it needs to be unanimous. They need to hear that instruction.
But they need to know that the second, that it would be the lesser included offense.
No, it's 11 people are voting for first-degree murder, and one
Correct.
person is holding out for second-degree murder.
Correct.
And they want to know if that's the case, is it second-degree murder?
And the
Right,
answer
and
is
we're not
yes.
saying yes or no. We're just rereading the same instruction they already have. Is it
Yes.
possible to turn that down until we are sending it back to the defendant?
That's why I think the answer should be yes, it would be second.
It's not second. It has to be unanimous. It's 11 to 1.
It has to be for the highest offense.
Prove it. So you got 11 people saying 1.
But that has to be unanimous. It still can't be an 11 to 1 at any point in time for anything.
Correct.
If one guy never comes
But
off,
if
Yes,
11
here's the
are saying
thing.
first, then they also include, that includes the lesser included offense of second. So then it would be second.
is that the way it works?
I mean, that's a lesser.
So if 11 people vote for first-degree premeditated murder, and one person says, no, I think it's second-degree murder,
It's the highest offense for which they all agree.
they
Which
don't
would
all
then be-
agree.
They would all.
Correct,
they would all
but if they
say-
have reached a yes on first-degree premeditated murder, they have reached a yes on manslaughter and second.
Do you agree with that?
Well, we have to presume that there would be a point where the 11 that are stuck on first would all say, okay, we're going to demur and we're going to agree to that it's a second degree.
Doesn't the language of their question specifically say that? Then is it second-degree murder is the end of that sentence, isn't it? The language of the question that was there?
It's not then second degree murder. It requires the 11 to then agree to a second degree murder or they're hung.
They have agreed to first.
They've agreed to
Correct.
first, and they've agreed to
Instruction literally.
manslaughter, they've agreed to the lesser included, then I don't see how you can't, it's a necessarily lesser included, and it's part assumed in the first. So if they've agreed to first, they've agreed to second as well.
Robin? I see the logic. Let me just check something.
I'm just worried they're going to be
Then the only
confused.
change would be that in front of him reading that, or on the end of him reading that would be an actual definitive answer to the question.
Yeah,
Because
I guess-
legally, by law, he can give a definitive answer.
I guess if you have to read it, that's the way you would have to read it. Because at the end of the day, the people that are 11 are the first degree murder.
Had to surpass second.
Thank you.
to get to first.
Right, so then, so I think if you're definitive answer, so at that point, then you would all agree on the second, but not on the first.
But the alternative is that they hang. The alternative is that the people that are stuck first say,
Jen, you want to be a part of the conversation? We're just talking about that. Because you agree with what I'm saying.
I don't,
Wish to put your position on record. Understood.
Clearly,
I
Right.
don't have any for this.
for her not to get involved.
Right.
He understands.
What, my absence of yelling? I don't, it has to be unanimous or whatever.
That's all I'm saying.
Agreed.
But their answer to their question would be example would be, so at
If
that
their
point,
question did not specifically say,
so at that point, their
then
answer would be
if
second.
but they have to get, they, in the group,
What I'm saying to you is to answer this question by law.
It would be a definitive answer to
It is an answer, not just reading the instruction. Ask them, we are entitled to a question.
Can we see the question?
yes, the question.
I would like a copy as well. We need to ask for a copy. Yes. Yes.
We need to come to
Sure, I'm just talking about their question specifically. It could be the same example.
I don't want an answer that is correct and is logical to confuse everyone.
How do I explain that?
It could, and not how it's
Right, so that's why I'm saying in rereading this, it's actually not helpful. Yeah. Agreed. Do you know? I know.
Okay. All right. Yeah. Okay. Well, here's the thing on this.
Can we see the question?
It has to be unanimous.
Can we see the question?
I mean, that's a simple answer. It has to be unanimous. I mean, that's.
I mean, they can't come back 11-1. And do this. They'd have to follow that instruction that says you have to agree unanimously on the highest one that you believe.
Yes, but that's not the way that the instruction actually reads, because those are two separate parts of the paragraph. So the first paragraph does
I
say
understand it
return verdict for the
doesn't,
highest.
it's
But
an
the second-
unusual question.
Yes, which is why I think it needs more guidance than just the instruction.
You might be right on that.
Verdict, like the standard instruction of 3.12 gives us two separate, I guess, explanations if the court's following. So paragraph 2 does say return a verdict for the highest count. And then paragraph 3 says the verdict must be unanimous. So we're not actually resolving any confusion by not including the language. I think if the court's statement that you just made was you need to return a verdict as to the highest charge for which you are all unanimous is legally accurate and follows or tracks the same language included in the verdict form and still at least provides some guidance in answering the question.
Well,
I intend on telling them that.
the question is, on each count, does it have to be unanimous on the degree? Yes, it has to be unanimous, yes. For example, regardless, the answer to the question.
Which is why I think we need to get an answer, not just read a generic instruction.
Yes, it needs to be unanimous.
And then if you read that, the answer to that question is regardless of the example, is yes.
Okay, now question 2.
If half the people are saying guilty on one count and other half are saying not guilty, does that make them mistrial without guilty?
Here's the other problem is we have 5 defendants, and we don't know whether or not they're talking about it collectively or they're talking about individually.
The answer must be
It must be unanimous.
So the answer must be, yes, for it to be a verdict, it must be unanimous. You must consider each count as it relates to each defendant individually.
Because that's another issue.
So that should be the answer.
We have people.
Then make them now, just get them under the original
Not
back.
guilty charge. Does this mean mistrial with the entire case or specific charge?
Same answer. In that one,
It's the same thing.
It's the same
You have to
question.
have, take each
must
one
be given out.
and decide on the
It would be for the
unanimous.
specific charge.
As it relates,
One with the example, because they're not going to debate, just with the yes.
but he says regardless, the answer is yes.
Is yes. And then she can read that.
What we would do instead would say, I cannot give you a response to your hypothetical question. The answer to the question is yes.
yes, it must be unanimous.
Correct, like, still read whatever we need to read, whatever, but like, specify it to each defendant, and specify that it is for whatever, the highest.
To each defendant as to each count.
Correct. Do you want to draft something and provide it, and then instead?
If they make the copy before we're ready to Is there a consensus?
We're coming up with
We'll write it so we can see when we look at it. If it looks right, then we'll ask the court to consider it.
If they have an agreement, so I wouldn't read anything other than things like
Well, I don't know. He's going to read it. I don't think that's all right.
Yes, I'm going to make sure we're on the same
Yeah, I'm working.
You have a sugar box there?
I gotta do a sentencing memorandum
Do you enjoy CJ? No, do you enjoy being on the
sometimes.
What's the downside? Just being on call?
They are fine.
Right.
I mean, the pay is I don't have any need to outside. I'd like to. That's probably my only objection is that I wish they would call you and say,
Yes, sir.
as opposed to.
All right, real quick, there were three questions. First one was, and I'm paraphrasing because the judge read them so fast. So question one was, on each count, does it have to be unanimous? Example, if 11 agree and one doesn't. Question two, if half are saying guilty on one count and half are saying not guilty, will that be a mistrial on that charge or the entire case? Question three, if one is not agreeing, will that cause a mistrial? So those were the three questions. Again, I'm paraphrasing. Judge read them so fast. But anyway, question one was, on each count, does it have to be unanimous? For example, if 11 agree and one doesn't. Question two, if half are saying guilty on one count and half are saying not guilty, will that be a mistrial on that charge or the entire case? And question three, if one is not agreeing, will that cause a mistrial? So, second degree means it's possible to be free again. Yeah, the lower the degree, the better it is. Psychosaurus, those questions shed a lot of light into where the verdicts are heading. Absolutely. Joanne, sounds like the jury is very split. Yeah, they're not even saying if one, well, they're saying if 11 agree and one doesn't, but then they're saying half guilty, half. So now the defense is trying to split it up into, the judge is trying to come up, he's going to read them the Allen charge, but the defense says it's too early, so we still don't know if they're going to do that or not. And then the defense thinks it's premature. Judge is going to basically say if you unanimously to one count, you can't agree on the other counts, so the mistrial will not affect the other charges. And the defense says that's very convoluted. So then the judge says, well,
Copy of it if it's agreed to?
Yeah, we'll email you a copy.
Okay, just email it directly to me and I'll bring it up on my
Do you
screen.
want to take a look at what she's written? Finishing that last one.
Yeah, well,
No, finalize.
Copies made out there. Nice work.
Oh, that's as it relates. No, because that would be as a whole. Yeah, but not as it relates to one count. The question is if they're saying on one.
all right, so now the parties are trying to come up with like a consensus on what the response should be. So he's trying to get the defense and, well, the two parties, the defense and the state, to kind of come up with this similar language. So the defense thinks it's premature to read the Allen charge, which is basically when a jury is deadlocked, the judge says it's okay, go back and continue deliberating. So defense is saying it's very convoluted how the judge was going to say it. So then if they hang on one count, will it affect the other counts? They agree on, then no. Let's see. Then they're talking about, so then Zavante is still not allowed in the courtroom. So then they're trying to figure out how he can be a part of the proceedings. So they're going to FaceTime. So Danny Frasetti and Brian Gonzalez are going to FaceTime each other. And one's going to give their phone to Zavante, and the other phone is going to be, I guess, up by the judge looking out at the jury. So let's see. What else? He's going to read the Allen charge. He's going to explain any non-unanimous findings will not affect a mistrial. It will only apply to the charge. So we saw this with Raul. So if you have like 5 charges, and also Carlos, we saw this with Carlos Dominguez as well. So the jury found not guilty on some and they hung on others. So when you have multiple charges with one client, you can it's not guilty, and then if you're hung on another one, then it's declared a mistrial, right? But with multiple clients, multiple defendants, I don't know, they may find one guilty and the other's not guilty and another hung. I mean, this is such a mine, you know what I'm saying? This is just nuts. So they could very well come back with one's guilty, one's not guilty, 2 are hung. You know, I mean, it's just it's really up in the air right now. This is when you have multiple charges, that makes it difficult. When you have multiple defendants, that just makes it so much more complicated. Yeah, like a jigsaw puzzle, Richard, for sure. Absolutely. 3 questions. It gives a clue on where things are going. Oh, cross-amnesia. Yeah, cross-examnesia. So there were 3 questions. Question number 1 was, on each count, does it have to be unanimous? Example, if 11 agree and 1 doesn't. Question 2 was, if half are saying guilty on one count, half are saying not guilty, will there be a mistrial on that charge or the entire case? That's the key right there. That's the key. Question 3 was, if one is not agreeing, will that cause a mistrial? So to me, question 2 gives the most insight. If half are saying guilty on one count, half are saying not guilty, will that be a mistrial just on that charge, or will that affect the entire case? So the judge has to tell them, no, you can disagree on one defendant and one charge as long as you agree on another defendant and another charge. So that's what the judge has to get. The judge has to get that across to the jury. If you find one defendant guilty, he's guilty. Fine, put him over there. If you find this defendant you're hung on, fine, put him over there. If you find
I think we answered the questions that we have.
I think she answered the questions, so.
I don't know what this is. You know what agent's email is? I can use their email.
The kitchen rice, I'm pretty sure kitchen rice.
Why not? We're trying to get the order of these email addresses.
You need my email?
Yes, Judge.
Robin.Fuson at fljud13.org.
At FL what?
fljud13.org. Org.
Sorry, I had it on my laptop, so I apologize. Thank you.
Would you send it to everybody or just?
Yes. No, I don't know. Can you ask? Can you ask? I don't know if he was going to read the 12 reports and she actually gave an answer. But you all tell us what your preference is on.
I don't know. Did it come to you?
Like reply all. Maybe from a jury instruction.
Gmail should not think come to remember.
This case was
Sure.
United discharge. So, yeah, we did straight to because they wanted to more quickly.
All right, I've read your questions, answers, I should say. I agree. These are fine. Does each defendant and their attorney agree to these questions?
Judge, as to Mr. Sampson, we have reviewed the answers that we intend to provide, and I have no objection.
Shetty?
I agree with Mr. Gonzalez's representation.
All right, Mr. Hernandez?
So do I, Your Honor, on behalf of Mr. Cole.
Mr. Sinoni?
No objection on behalf of Mr. Thompson.
Mr. Evans?
I agree to those on behalf of Mr. Hammond. Are we also reading 312 and 312C, or we're just doing these answers?
I can read the 312 verdict if you want, but this basically covers that. What would be your preference? I can start out and say I have a general jury instruction. We read to you, and then I will answer each question specifically.
That can be fine. I just asked if you're going to read 312 to also read 312C.
I have that with me as well.
Okay.
All right. You may bring the jury in.
All rise for the jury.
Jury has returned. Y'all may be seated. Ladies and gentlemen, I have received your questions. It took a few minutes to round everybody up, and I discussed this at length with all the attorneys on both sides. And I'm going to answer your three questions. I'm going to read you two short jury instructions that you already have, but I want to reiterate these and then answer your questions. A separate crime is charged against each defendant in each count of the indictment. The defendants have been tried together. However, the charges against each defendant and the evidence applicable to him must be considered separately. A finding of guilty or not guilty as to one or some of the defendants must not affect your verdict as to the other defendants or the other crimes charged. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form is prepared, and you have that copy. Now, regarding your questions, the answer to your first question, I cannot provide a response to your hypothetical question directly. You must return a unanimous verdict as to the highest offense on which you all agree, if any. Question 2. You must reach a unanimous verdict as to each count as it relates to each specific defendant. If you are not able to come to a unanimous decision as to any one count, there would be a mistrial as to only that count. And if you are unable to reach a decision as to one count, there would be a mistrial as to only that specific count. It will not affect the unanimous decisions as to the other counts. You must consider all counts individually as they relate to the defendant. And I hope that gives you some clarity. And thank you.
Your Honor, Coach?
Yes. They didn't teach reading in law school. The answer to question 1 is yes. And just to be clear, yes. And I cannot provide a response to your hypothetical question. You must return a unanimous verdict as to the highest offense to which you all agree, if any. But that answer to 1 is yes. All right? I hope that makes things clear. And I now ask you to go back and continue your deliberations. Thank you.
All rise for the jury.
Judge, the only thing the state would request at this time is that a copy of the questions as well as a copy of your answers be sent back with them as well, so that they have them back there in case they need to refer back to what was.
Well, my answer is in the record. You want me to print that out and send it back?
I think that would
Does everyone agree to that?
I don't have any objection to that.
Anyone have an objection?
No, sir. Objection.
All right.
All right. So, excuse me. All right, so the jury comes back in. Judge says, finding one defendant guilty or not guilty doesn't affect the others. Guilty should be for the highest charge. You must be unanimous, and only one verdict must be returned for each decision. Question 2, each specific defendant in mistrial for only that count will not affect the unanimous decisions on the other counts. All right, hold on. Yeah, hold on. All right. So let's see. I cannot provide an answer. Each specific defendant, you have to find a count for each specific defendant. A mistrial will only count, will not affect unanimous decisions on the other counts. Both parties jump up. They definitely are like, can we approach? And then the judge says they didn't teach reading in law school. So the answer to question 1 is yes. So the question was, on each count, does it have to be unanimous? Okay, then yes, that's the answer to number 1. And he sends him back in. So that's that. All right, guys, I'm going to continue playing. We're going to continue on here. I'm going to go back to Jose's trial.
Where we are in the trial, we're pretty much getting towards the end part of it.
Right.
We got a firearms expert this afternoon, as well as Sergeant Van Heist. The only two who could not be here this afternoon are Benjamin Borse, who does the download of the phones, and Dr. Webb. Sure. We plan on having them tomorrow morning available. So I don't know what point we'll be at where we'll be done with our witnesses this afternoon, but they'll probably be close to 5, but anyhow, around that time. And then we just have 2 witnesses in the morning, and we're probably going to rest at that time.
Okay, and then,
Thinking ahead,
then you guys start at
we have to
Monday?
determine whether defendants are going to testify.
Okay.
Once that goes by the wayside, and that's kind of a big deal in and of itself, right? I'm thinking, can we do charge conference and JOA arguments?
Yeah, so I was
and then
thinking they
come back
rest.
Monday?
They rest. You can raise all your motions, JOAs, whatever, and we can do a charge conference. And then we'll just Monday come back and give us your decision on who testifies, who doesn't, things like that. Yeah. Is that what you're talking about? You look
I
befuddled.
almost want to know who's testifying for my own sanity.
Well, then yeah, we can find that out.
Maybe we do that tomorrow.
And then we still do the same thing.
Right, and they just, now we know who. All right, we'll start at 8:30 on Monday morning.
Yeah.
You all right with that, Mr. Fischetti?
I am. As soon as he says I'm right, I would pause it.
So, you start calling around, you start calling around and fill the rest of your week?
What's that?
You start calling around now to fill the rest of your
that's good. We already know. It's a good spot to start.
Let's just make sure this is right. It's in reaction to what he says, so it's like no context. He says, no, we need to make sure it's approved. Again.
Peach flavored water and all these.
No. I mean, play. Okay, it's fine. Okay. Just anything else. I'll turn this over to.
Yeah, you're good.
I think it's fine. There's something here.
No, we'll switch over. Yeah, we'll go back to the Elmo.
Is this on?
Oh, yeah. Wait, why is that? Wait a second, that's weird. Wait. How do we switch it to Elmo? The button. Oh, touch it. Please don't touch it.
I'll do this. Is she next?
Yes.
Stunning. Let me just touch.
They have to get a video ready before they can start.
Oh, do you want to do the stipulation?
Yes, we do stipulation first. And then
Okay.
you let her know what's going on, right?
Yeah, she's fine with it.
Okay.
Okay. Sorry, thanks so much. You're the best. Thanks.
Hey, TJ, stay right there. Can you tell what I'm doing? Showtime. I'm texting my wife. She's watching. Enforce. Okay, thank you all. May be seated. Thank you, ladies and gentlemen. Welcome back. Hope you had a good lunch, and I assume there were no issues with the court's instructions. Perfect. Next state, you may call your next witness.
Your Honor, at this time, the state would move in State's Exhibit 52, which is a joint stipulation between the state and Devontae Sampson.
All right, ladies and gentlemen, the state of Florida and the defense have agreed to a stipulation. You should take the stipulation as true and correct, and it reads as follows. The state of Florida and the defendant, Zontavi Sampson, stipulate to the following. The person who was seen in the Chevron, as well as the East Tampa Pawn Shop videos, ultimately getting in and driving off in the dark-colored Infiniti, has been identified and is in fact Zavante Sampson, the individual named in the indictment in this case. And it is signed with the attorney, the defendant, and the state attorney. And that will be admitted as 52. Very good. Ready to call your witness?
Yes, the state will call Lubac Fortes Rodriguez.
If you could raise your right hand, do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, thank you.
You may begin whenever you're ready, Counselor.
Thank you, Judge. Good afternoon, ma'am. Would you please introduce yourself to the jury?
My name is Lubeth Fortes Rodriguez.
And Ms. Fortes Rodriguez, where do you work?
The Hillsborough County Sheriff's Office,
How long have you worked for HCSO?
18 years.
And can you tell us what your job title is at HCSO?
I am a community service aide too.
So what are some of your duties in that role?
I investigate fraud cases, and I am also the jail calls custodian.
Is one of the functions of the sheriff's office to operate the county jail calls in Hillsborough County?
Yes.
Okay. And is there a system that exists in county jails that allow inmates to make telephone calls out as well as to receive them?
Yes.
Is there also with that system a recording system in order for all outgoing calls and incoming calls to be logged and cataloged in for the jail?
Yes.
Can you tell us what that system is called?
Global Tel Link.
How does Global Tel Link operate?
As soon as the inmate picks up the handset, it starts recording. They select prepaid or collect call. They enter their PIN number and the phone number, and the call dials out.
And so is the PIN number associated with each inmate at the jail?
Yes.
And is this tracked, the PIN number with the caller, in a inmate identification type process?
Yes.
How are these calls, how are they recorded for this in the system for HCSO?
They're stored on the Global Tel Link server.
And do you have access to that recording system?
Yes.
Are the jail calls kept and made in a regular course of business for HCSO?
Yes.
And are you the designated jail call records custodian on behalf of HCSO? I think you already said that earlier.
Yes.
Yes, excuse me, sorry. Can you tell us a little bit what it means to be in that role as a jail call custodian?
I maintain the inmate phone records.
Did you, in your capacity as a jail call custodian, receive a request from the state to access the system and download phone calls for an inmate by the name of Quandarius Hammond with the PIN number of 2021-23167? The call was made on September 2nd, 2021, around 20:03 hours.
Yes.
Were you able to locate and download the phone call that matched the one we asked you to pull?
Yes.
And did the PIN number correspond with the name we asked you to look up of Quandarius Hammond?
Yes.
Were you able to view or listen to this jail call prior to sitting here today?
Yes.
And permission to approach, Your Honor?
Granted.
I'm handing you this pre-marked State's Exhibit 40. Have you had a chance to view this disc?
Yes.
Sorry, give me a minute. And you recognize this?
Yes.
And how do you recognize it?
My initials and the date.
Okay, would you say that this is a fair and accurate depiction of that jail phone call we asked you to listen to before testifying here today?
Yes.
The state would move into evidence what's been pre-marked as States 40 as States 40.
Any objections? Yes. You are about to listen to a audio recording. The court now instructs you that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way you view or listen to and consider this evidence. Thank you.
And Judge, just to confirm, this was going to be admitted, correct?
Yes.
Okay, perfect. And permission to publish, Your Honor?
Granted.
Thank you.
For English, please enter. Please enter the area code and phone number you are calling now. Please hold. Please wait while your call is being connected. Please inform your friends and family. They can now leave you voice messages. They will need to know your 9-digit phone ID. Please hold. Hello, this is a free call from an inmate at the Hillsborough County or Road Detention Facility. To accept this free call, press 0. To refuse this free call, hang up. This call is from a correction facility and is subject to monitoring and recording. Thank you for using Global Tel Link. See, their phone's under investigation.
They took it.
Yes. I said that before they even switched work. They were not their own business.
Before they was to do what?
I said that when they was everybody was, leaving my house, when it first came out, I was trying to grab it. They didn't grab it. Because I had turned back around and grabbed my purse and stuff.
Yeah. Yeah, you play him up right now. And my girl, they always leave.
I didn't say that. You was home. When I get to go with that deep. Good. One of the, I know somebody should. Somebody had to watch the food.
I told them to get on stuff that shit, my drink every day. And like 9 o'clock, I'm like, you gonna say the same thing. So, be straight on this, everything good.
That's not what you, but yeah, but that's not what they, and you got. That's not, they're not talking about that. They just want to know what happened at night, because they know you be up there.
Yeah, so I'm trying to tell you.
That's it.
Yeah. And you said you was home, I was home.
You were home. I was in St. Pete. I was at home.
Thank you, Judge. The state passes the witness.
All right, Cross? Anyone else?
No questions on behalf of Mr. Thompson?
No, sir.
All right, may this witness be excused?
Yes, sir.
You're free to go. Thank you, ma'am. All right, State, you can call your next witness.
Oh, yeah. State calls Detective Scott Barnett. Thank you. I couldn't see you.
Good afternoon. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Whenever you're ready, Counselor.
Yes. Good afternoon, Detective.
Good afternoon.
If you could please tell the jury your name and spell your last name for the court reporter, please.
I am Detective John Scott Barnett with the Tampa Police Department. My last name is Barnett.
And Detective Barnett, how long have you been working with the Tampa Police Department?
I've been with the Tampa Police Department almost 23 years.
All right. And what is your current position with the Tampa Police Department?
Currently, I am a detective in the Delayed Latent Investigative Squad assigned to District 2 in the north end of Tampa.
Back in August of 2021, in what capacity were you working with the Tampa Police Department at that time?
In 2021, I was a homicide detective with the Homicide Squad.
All right. Now, specifically with August 22nd of 2021, were you brought into the investigation into the death of Suni Bell?
Yes, I was.
And what position were you given in the case?
I was given the second position behind the lead detective, Chris Salea.
And so you were the assist, I guess is what they're called?
That's correct.
Okay. And as the assist, what are your general duties with the investigation?
My duties are basically to follow the lead and to assist him with anything that he needs assistance with.
So you're present at most of the things that the lead goes to, most of the interviews, most of the scene evaluations and things like that?
Yes, that's correct.
All right. Were you present with Detective Salea when you all went to East Tampa Pawn and Gun to retrieve a gun?
Yes, I was.
Okay. And did you in fact take that gun into evidence and impound it?
Yes, I did.
All right. Okay, Detective, I'm going to show you what's been marked and entered as State's Exhibit 31A and B. It's already been admitted. Now, the firearm has already been observed by the jury. There was also a second, there was a bag placed in that box. What did that bag contain?
Along with, the bag contained the ammunition that was originally inside of the magazine.
Okay, that's what I wanted to ask. So when you retrieved the gun from East Tampa Pawn and Gun, those live rounds were already within the magazine in the gun?
Yes, that's correct.
Okay, and so when you took it back to impound, you took out the magazine and took out those, you separated basically everything? Would
Yes,
that be
that's
accurate?
correct.
And then you placed it all into that box, so it's all kept together as one piece of evidence?
Yes, that's correct.
All right, and the other two items, we've already seen the gun and magazine. The other two items, can you identify what those two items are? Or the other items, I guess I should say.
This is a rail light and laser that runs on the rail of the handgun to illuminate or sight a target, which was with it. And then the envelope right here is the envelope that has 14 9mm rounds that I removed out of the magazine.
All right, and are they in substantially the same condition as when you received it on that day?
Yes, they are.
All right, and I believe, Judge, it's already been admitted, but I would like to publish at this time the two other items that's on the back.
Great.
So, Detective, this item that I'm placing on the Elmo here, this is the, I guess, the laser sighted thing that was on the firearm?
That's correct.
Okay. And then this would be the live ammunition that was found within the magazine of that firearm when you obtained it?
That is correct.
All right, Judge, I have no further questions of Detective Barnett at this time.
Any cross-examination?
Briefly, Judge. Detective Barnett, good afternoon. The sight or light that you were just describing, those are all lawful additions to the firearm, correct?
Yes, they are.
Okay, thank you, nothing further.
No crossroad.
Anyone else?
No questions for Mr. Thompson.
And Judge, just briefly, just to make sure, if 31B has not been admitted, we would be asking for
All right,
admission.
31B, the magazine and ammo?
Yeah.
That'll be admitted.
Okay, thank you.
Unless there are any objections for legal objections?
No, sir.
All right, thank you. All right. May this witness be released?
Yes, you may, Judge.
Thank you, Detective. State, you can call your next witness.
State would call Detective Mike Lippold.
Leave this down.
Afternoon, if you could raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir.
Counselor, whenever you're ready.
Good afternoon.
Good afternoon.
Would you state and spell your name for the jury?
Yes, it's Michael Lippold, last name Lippold,
And how are you employed?
Tampa Police Department.
What is your title there?
I'm a sergeant.
And what division are you in now?
Right now, I'm the sergeant of the narcotics division,
The narcotics division?
or narcotics squad, yes.
Where were you assigned in 2021, August to be specific?
I was the homicide sergeant at that point.
What are some of your duties as the homicide sergeant?
Review reports, assign them out, review case files, review legal documents, search warrants, maintain the rotation of the detectives, communicate with the other supervisors on any information that might be needed, and obviously communicate with my chain of command.
Now, would you say you supervised the homicide detectives as the sergeant of the homicide division?
Yes, ma'am.
So if we've heard from some detectives, Detective Saleya, Detective Alverson, were those members of your squad in August of 2021?
Yes.
And when you supervise them, tell me how it is that you assign them cases.
It's just a rotating list. Once a detective is at the top of the list, they get the homicide and fall to the bottom for the next one. There's usually 2 scene detectives. They come from the middle usually, and then there's a lead detective, which is towards the bottom to help the detective that's up.
And that list does it have anything to do with their actual qualifications, or when you say rotation, do you mean, the bottom has the last homicide assignment and it rotates in that manner?
Yeah, it's just rotation, nothing to do with qualifications, just a rotation.
They all have the same qualifications?
Yes, ma'am.
And can you tell me how long you've been with the Tampa Police Department in total?
16 and a half years.
Did you have any law enforcement experience before that 16 and a half years?
Yes.
And what was that?
That was St. Petersburg Police Department.
How long were you with St. Pete Police Department?
A little over 2 years.
Now, when you indicate that you're supervising scenes, what does that mean specifically when you actually get there? How does that differ from the detective that's assigned?
Mostly make sure the scene is secure. Make sure if there's any witnesses or anyone needs to be interviewed, that they're where they need to be and lined up for the detectives to get there. Make sure that there's logs in and out, and then usually communicate with my chain above me once I get there.
When the scene is more involved, do you actually get into the assistance of the scene search, the scene, recording, anything like that? Do you kind of go hands-on if there's a larger scene or more involved scene?
Yeah, I can. I would say any scene if I'm not tied up on something else, yeah.
You provide assistance?
Yes.
And when you are called out to these scenes, is that on a rotating basis? So it could be at 10 o'clock in the morning and it could be at 3 o'clock in the morning, meaning opposite schedules?
Yeah, whatever.
Time does not matter?
No.
Okay. And did you have some specific involvement with the homicide investigation into the death of Suni Bell and attempted murder of Mrs. Harrison or Mr. Brown?
Yes, ma'am.
What was your involvement specifically in that particular investigation beyond supervising the homicide detectives assigned?
Well, I assisted reviewing some videos, obviously assisted with search warrants, assisted with reviewing search warrants, controlling or communicating with other squads and whatnot.
As the homicide was being investigated over the weeks or months leading up into the arrest of the defendants, did you have a continuing involvement?
Yes.
So I want to start with the night of the homicide, August 22nd of 2021. Did you respond out to the scene on East Hillsborough Avenue?
Yes.
And what are some of the observations that you made when you arrived on scene?
The scene was secure. There was crime scene tape up. There were several officers along Hillsborough Avenue. Hillsborough Avenue was closed down both east and west from 45th Street to 40th Street. I remember there was a silver Infiniti G35 that was appeared to be crashed into a telephone pole at 43rd Street. It had front end damage, which was consistent with the pole it was kind of laying on. I remember the vehicle obviously had several bullet strike marks or bullet holes in it along the driver's side and rear of the vehicle. I remember multiple casings along the roadway of Hillsborough Avenue.
Do you recall the caliber of the casings that you yourself observed?
Yes, I remember seeing 9mm and either a .223 or .556 rounds, which are the same size.
You say same size, it's a different measurement, but the same caliber of a bullet?
Yes, yeah.
Okay. When you arrived and saw the size of the scene, what did you actually do on scene on the night of to assist?
I helped kind of triage where good video surveillance would be. So I was directed to a couple businesses that had surveillance cameras that were already being viewed.
Did you have an opportunity specifically to review the camera at the principal auto sales location?
Yes, Detective Wolf brought me into the business and showed me the camera on their screen.
Where was that principal auto sales location in relation to the vehicle crash that you already mentioned?
Would have been just a tad east of that location. Pretty much directly in front of it, just a little bit to the east.
Were you able to see from the surveillance that you reviewed the vehicle crash location?
Yes.
And while you were with Detective Wolf in reviewing this video, was there any information or visual that you observed that you then ultimately relayed through to the person you assigned to be the lead detective?
Yes.
Okay. I'm going to show you what has been pre-marked as States Exhibit A through I. Please review proposed exhibit 55A through I, and let me know if you recognize that.
Yes.
And do you recognize what I've just provided to you as at least a relevant portion of the video that you saw from the principal auto sales on August 22nd?
Yes.
Your Honor, at this time, the state would move what was proposed states 55A through I into evidence.
Any objections?
No objection.
All right. It will be admitted as states 55A through I.
As you watched the video, did you have the opportunity to isolate some of the images or slow down the footage so that you were able to see what was going on in that video?
Yeah, I was able to, obviously, inside the business and also after the fact, obviously, within the office at the headquarters.
I'm going to publish for you 55A. If you could look just over your shoulder there for reference here. Is this the view that you were able to see some activity on the cameras that you were watching?
Yes.
And from that, what information was relayed from 55C or 55D as it related to the vehicles that you were observing in the video to your lead detective?
Judge, objection the same. The best evidence is the video and even the screenshots from the video, not his interpretation. Will object.
I'll overrule the objection based on the question. Both objections.
What, if anything, of evidentiary value did you note from the video in principal auto sales?
Same objection.
Same ruling.
I mean, obviously, I knows that to be the victim's vehicle, and then are you going to show different?
Yes, I can. If you want to use, there should be a wood stick up there. I know it's a little bit difficult because these are screen grabs, but if you can point to us and identify the victim's vehicle that you've just mentioned.
There, and then this vehicle here, behind it.
Now I'm showing you 55E. I won't go through all of these photos, but essentially, can you describe for us what it is that you observed that actually made you take note?
Yes, obviously, there in this photo, I noticed there would be a light, which I believe would be a large muzzle flash, come from, obviously, the passenger side of the vehicle, because this is the driver's door. So from the passenger side of the vehicle area, several times I noticed a large muzzle flash coming from that vehicle there.
Okay, so you said several times, and is that what you were looking at while I was there at 55F? So just at the same vehicle, just in these screen grabs, these are in chronological time order?
Yes, ma'am.
Okay, understood. So you provided the information of what you saw from the video as the photos here have depicted to the lead detective?
Yes.
And did you, based on your just training and experience over the last 18 and a half years, I think if I did the math right, provide to him that you believed it to be muzzle flash?
Yes.
Okay. And with that information, were you also able to see that actual area of the roadway? So if I go back and show you 55I, for example, were you out there on Hillsborough Avenue at that location on foot?
Yes.
Okay. Were you able to examine the roadway in that area?
Yes.
And did you have an opportunity to see cartridge cases in the roadway in that area as well?
Yes.
Is there an objection? Okay. Did you have an opportunity to see what type of cartridge cases were there just west of the of the victim's vehicle?
Yes.
What type of cartridge casings were located there?
Both handgun and obviously rifle.
What do you mean by handgun? I presume handguns
Smaller cartridge cases, which I believe to be a 9mm, and then larger ones that believe to be a rifle projectile or a spent casing.
After the conclusion of your involvement at the homicide scene on the night of the homicide, so the 22nd, did you have additional involvement in this particular investigation?
I reviewed some other videos and whatnot, yes.
In addition to the videos you viewed that night. So we saw principal auto sales screenshots. Did you also review the Chevron video?
Yes, ma'am.
Did you see any additional videos on that evening?
Just those two on that evening.
Sure. Could I ask Sergeant Whipple to get a little closer to the mic?
I'm sorry, I have a cold, so I know, I'm trying to speak up. My voice it's out. I'm sorry. Yes, that night, Chevron and Principal Auto are the videos I have reviewed or looked at.
During the course of the investigation, were you privy to additional videos that had been recovered either by yourself or homicide detectives or deputies on scene, et cetera?
Yes.
And ultimately, were you involved in the investigation on August 27th of 2021 as well?
Yes.
What, if anything, did you respond to on that date?
On that date, I responded to a traffic stop of Mr. Bedward and his silver or gray Chrysler 300.
Is that Jalen Bedward, the defendant?
Yes.
And you indicated it was the Chrysler 300. Is that the vehicle that you saw when you arrived on scene to this stop on the 27th of August?
Yes.
And was Mr. Bedward still present at the time of your arrival?
Yes, ma'am.
Did you have an opportunity to, or did the detectives with you have an opportunity to speak to Mr. Bedward there?
I did not. Detectives, yes.
And were you to remain with the vehicle, or did you have some other responsibility at that time?
I stayed with the vehicles.
Can you explain to me what the weather conditions were on the 27th of August when you arrived to the 300?
It's clear when I arrived, and then shortly after, it started to rain really heavily.
And what was your role in staying with that vehicle?
I wanted to preserve any evidence that was in the area that I believed of importance, which is the passenger mirror. So I stood over the mirror above it. I had an umbrella trying to cover the rain.
Why is it that you believe there was some importance on the passenger mirror? Did you make some observation?
There were scratches to the top of the mirror. So, yeah.
And having reviewed the principal auto sales video, why were the scratches on the passenger mirror of importance to you?
Objection, Judge, same continuing objection as to the
Approach. You may continue, Counselor.
Thank you, Your Honor. Detective, without telling me the reason for such, did you document a defect to the passenger mirror on the right side of Mr. Bedward's vehicle?
Yes.
I'm showing you what has been marked as states 25A through F. Do you recognize these images? Excuse me, A through H.
Yes.
And do these images fairly and accurately represent Mr. Bedward's vehicle, the 300, on the date that you responded to the stop location?
Yes.
And do they accurately depict what we had previously discussed was the defect you wanted documented on the passenger mirror?
Yes.
At this time, state moves to admit states 25A through H.
Any objections other than previously noted?
No, just renote our previous objection.
All right, they'll be admitted as 25A through H.
I'm showing you 25B. Can you see that okay, Detective?
Yes.
Is this the vehicle, the Chrysler 300, as it appeared when you arrived on scene to take photographs?
Well, when I got on scene, it was dry, but yeah, I was on scene when it started raining, yes.
Okay, I apologize. Let me go to the dryer. Let's look at 25C. Did you instruct the crime scene tech to photograph this item?
Yes.
What mirror are we looking at in this 25C?
The front passenger mirror.
Of the same vehicle we saw this overall photograph of, 25B, is that correct?
Yes, ma'am.
Now, at some point, maybe we see it in the reflection here, at some point are you holding an umbrella to make sure it does not get wet?
Yes.
All right. And is 25D just depicting another angle of that mirror?
Yes.
Did you have any additional involvement at that particular scene with the Chrysler 300?
No.
Was that 300 impounded from the scene pursuant to a search warrant for a search at your impound lot with the agency?
Yes.
Were you involved in that subsequent search at all?
No.
Did you then have additional involvement in the following month on September 29th of 2021?
The 29th?
Yes. Did you respond to a search warrant that was conducted on Quandarius Hammond's residence?
Yes.
Was that on the 29th? I may.
That was on the 2nd of September.
Okay.
I believe.
The 2nd of September, you're right, the writing on the card. Do you, when you ask a crime scene tech to come to a scene, have them fill out a card which indicates the date during which the search took place?
Yes, ma'am.
Okay. And is that so that attorneys like me cannot mistake the date that the search actually occurred when the videos are subsequently being reviewed?
Yeah, so we know the date of the photos, yes.
And did you ultimately have crime scene techs present with you during the search of Mr. Hammond's residence, or at least were you present for that?
Yes.
And did you have an opportunity to review the photographs that were taken from that search warrant?
Yes.
I am going to show you what's been marked as states 26A through 26M. Would you please take a look and tell me if you identify these photographs?
Yes.
And do you recognize these as some of the photographs that were taken during that search warrant execution?
Yes.
Your Honor, at this time, the state seeks to admit 26A through 26M.
Any objections?
No objection.
Anyone else? All right, they'll be admitted as 26A through M.
And showing you states 26A, is this that card we were talking about to eliminate confusion and give you all some idea of when the search occurs?
Yes, ma'am.
Okay, so you would not have filled this out, but would someone with your agency have completed it?
Yes.
Now, in showing you 26B, were there items of evidentiary value that were collected from Mr. Hammond's residence that you were able to observe? 26B and then ultimately 26C.
Yes.
And did those items include a hat that's depicted here in 26C?
Yes.
Did you also have the opportunity whilst present during that search to observe is this 26D the same hat?
Yes.
Okay. Did you have an opportunity to observe a cellular device or electronic device during the course of that search warrant?
Yes.
In 26F, is this that device?
Yes.
Was the electronic device collected or impounded before you all departed from the scene?
Yes.
Were you involved in any subsequent search warrant for the device from Mr. Hammond's residence?
I'm sure I approved the search warrant. Yes.
When the homicide detectives that you supervised needed approval of warrants, is that typically your responsibility to review and approve those?
Yes.
Okay. And additionally, did you recover some clothing items from the search warrant at Mr. Hammond's residence as well?
Yes.
In looking at 26H, can you direct us to what specifically from this photograph was collected into evidence?
Yes. Blue jeans.
Had you, at the time that you attended this search warrant execution, had an opportunity to review the surveillance footage from the interior of the Chevron gas station?
Yes.
In looking at 26J, after the item was photographed, was there an opportunity to lay the item out and take better photographs of those pants?
Yes.
And were those pants ultimately collected, 26K?
Yes.
Lastly, along with the pants was a top of some kind also collected and retained.
Yes.
And is that what's depicted in 26L?
Yes.
Lastly, did you have an opportunity to review the interior Chevron footage as it related specifically to Mr. James Denson?
Yes.
Did you have an opportunity to view that footage and determine what you believed him to be wearing at the time that he was at the Chevron or the Jet on August 22nd of 2021?
Yes.
I'm showing you what's been marked for identification as states 28A through I. You recognize these photos?
Yes, ma'am.
Do they fairly and accurately depict at least some of the photographs that were taken during the execution of that search warrant?
Yes.
And did that occur on September 28th, 2021?
Yes.
Your Honor, at this time, the state seeks to admit states 28A through I.
Any objections?
No objection.
And permission to publish, Your Honor.
It will be admitted as 28A through I, and you may publish.
I'm going to show you 28B. Was there any object that you were able to also see upon entry into that residence that was of note at evidence marker 1?
Yes.
And having reviewed the interior footage from the Chevron surveillance, I'm showing you 28C, was the backpack at evidence marker number 1 impounded into evidence as a potential item of evidence?
Yes.
In the Chevron video, did you observe Mr. Denson carrying or wearing anything similar to this?
Yes,
And is that why this was also impounded?
yes,
In addition to that bag, did you have an opportunity to see the feet of the individual in the Chevron video?
yes,
And were you able to observe what clothing items were on their feet?
yes,
Was there ultimately the impound of an item at evidence marker number 4, State's Exhibit E, in relation to what you observed?
yes,
And was that as a result of your reviewing the interior, exterior footage from the Chevron gas station on August 22nd?
yes,
Were these sandals also impounded?
yes.
Now, was there something else that actually occurred during the course of the search warrant with Mr. Denson? Was he present when you arrived for the execution of the warrant?
Yes,
Did you have an opportunity to speak with James Denson on that evening?
yes,
Was Mr. Denson under arrest?
no,
Was he being detained?
no,
Did you advise Mr. Denson that he was free to leave?
yes.
What options during the course of the execution of the search warrant were provided to Mr. Denson at that time as far as staying or leaving?
I asked him he could stay if he wanted to outside, or he could leave, and I would make sure either one of the detectives or myself would give him a phone call when we were done.
And did Mr. Denson elect to stay there at the scene?
Yes.
While the search warrant was being executed, where was Mr. Denson?
He was in the parking lot area, mostly standing next to his vehicle,
And where were you?
towards like the sidewalk area, in front of the apartment.
What were you doing?
At that point?
Well, I guess at some point you have a conversation with
Yes.
Mr. Denson.
Yes.
Okay, and tell me about that conversation. Where does that occur?
The same area I just said, sorry. He was standing next to his vehicle. I was standing more on the sidewalk or in front of the apartment complex.
And what's the tone or tenor of that conversation?
He appeared to be pretty relaxed and cooperative.
Would you consider this having to be your formal interview of James Denson about what occurred on the night of August 22nd?
I'd consider it more of like an informal interview.
So you did not sit him down, go through Miranda, talk about the events, anything like that?
No,
Did not go down to the district office
No.
at any point or anything like that? Okay,
No.
so I guess I'm just asking, did you have a conversation with him, or was this like an inquisition?
that was more of a conversation.
Is that a tactic that you were utilizing in order to obtain any kind of information?
No, I would just communicate with him at that point.
And what was the conversation that you were in fact having? Is there some point in which you asked him about a firearm?
Yeah, we spoke about several things, his vehicle, his girlfriend's kid, and yes, we spoke about the firearm that he pawned.
Was it a really structured conversation? Were you staying with him the whole time? Explain to us what the environment was like.
No, it wasn't structured at all. I mean, he was walking to his car. He actually showed me one of the broken windows in his car that he said he had to break because he locked the key in the car. No, it was we were just moving around.
At some point, do you ask Mr. Denson about whether he owns a firearm?
Yes.
Did you bring that up, or did Mr. Denson bring that up?
He brought up the firearm.
And
Well,
what? Oh, I apologize.
I'm sorry. I mean, we talked about several firearms, but he brought up the firearm he pawned.
Okay. You mentioned that he brought up the firearm he pawned. Did you know anything about the pawning of a firearm at that time?
Yes.
Did you ask him specifically whether he pawned the firearm?
No, he just asked when he was getting it back, if he would get it back.
Okay. So can you explain to me just exactly what Mr. Denson said about the firearm that was pawned?
No, he just asked if he was ever getting it back. Stated that it was one of his favorite firearms, his main carry, I think is what he said.
I'm sorry.
His main carry is what he said. And then we also spoke about, he said that he never lends out his firearms and did not lend out that firearm.
Did you specifically ask him if he lent it out or gave it to one of his friends?
I did ask him if he lent it out the firearm, yes.
And what did he say to that?
So no, he does not lend out his firearms. Said because people do dumb stuff with firearms, or can.
Did you speak about whether he intended to retrieve that firearm from the pawn shop?
Well, I mean, yeah, he asked if he was able to get it back.
And initially, when he advised you that he pawned the weapon, did advise or make any statements about wanting to buy it back?
Yes.
What was that?
He said he wanted to buy it back, but he assumed he wouldn't be able to because we have it.
Did he make any statements to you about being able to afford to buy back the firearm from the pawn shop before the date you all actually seized it?
Yes, he made a statement about not being able to, well, no, he said he wouldn't be able to afford a new firearm, not buy the one back.
Did he confirm the caliber of the weapon that he had pawned?
I think he refers to it as pawned firearm. I don't know that he ever says the exact caliber of it.
At that point, based on the tone of the conversation you were having with Mr. Denson, did you believe that to be any of the weapons used in the homicide of Suni Bell?
Yes.
And what was Mr. Denson's demeanor during the course of your conversation?
Like I said, he was relaxed, cooperative, and kind of easygoing.
Did you ultimately, as you've indicated before, advise him before you departed that you would let him know when the search warrant was completed?
Yeah, I told him that someone would call him.
Did Mr. Denson ultimately depart that location where that occurred?
Yes, he eventually left.
Your Honor, may I have one moment?
Yes, ma'am.
I'll pass the witness, Your Honor.
Yes?
No questions, Your Honor.
No questions.
Yes, Your Honor, thank you. Sergeant Lippold, good afternoon. Talking about Mr. Denson, when you spoke to him on September 28th, you said that prior to going to his apartment, that you were already aware that he had pawned a firearm. Is that true?
Yes, sir.
Okay. Why didn't you go to the pawn shop prior to going to Mr. Denson's house to retrieve that firearm?
I believe we already had the firearm.
Okay, well, if somebody testified differently that after you went to the apartment, then you went to the pawn shop, would it make more sense that you learned about the firearm being pawned from Mr. Denson than went to East Tampa Pawn and Gun?
I'd have to review it. I'm not sure.
Okay, but you weren't the one that actually went to the pawn shop to retrieve the firearm?
No, sir.
That would have been Detective Soleil and Detective Barnett, correct?
Yes, sir.
Now, just so I'm clear, Ms. Ismer asked you, based on Mr. Denson's tone, did you believe that was the firearm used in the homicide? And your answer was yes.
Oh, I misunderstood the question. No.
As to the form, I don't believe that was the question, Your Honor.
Well, I'll sustain that objection.
Was there anything, you suspected that the firearm was used in the homicide based on your investigation or based on anything you were getting from Mr. Denson?
Based on the investigation.
Okay, all right, just want to make sure there wasn't, because you said he's cooperative, you said he wasn't overly concerned and things of that nature, so I want to make sure that there wasn't anything where you thought he was being deceptive with you or anything like that.
No, he was cooperative.
In fact, he was so cooperative that he gave you the passcode to his cell phone that you also took into custody that day, correct?
Yes.
That's something that not everybody does, right?
Not all the time.
Okay, because you actually have to go through some other steps if somebody doesn't give you the passcode to review the information on the phone, correct?
Yes.
And as far as him leaving or remaining at his apartment when the search warrant was being conducted, you're not going to allow somebody to remain inside an apartment while you are photographing, cataloging, and impounding items of evidence, correct?
Correct.
So the fact that somebody stays, leaves, you're not going to allow them to sit on the couch while you're doing your job,
No,
right?
stay outside.
All right, and as far as, like you said, you're not going to read anything into whether somebody departs the scene or remains at the scene outside, right?
Correct.
Okay. Thank you. Nothing further.
Anyone else?
Couple of quick questions, if I may, Your Honor.
Yes, sir.
Good afternoon, Detective.
How you doing, sir?
You've described that you were out in the rain taking photos of a Chrysler 300, I believe it was.
I had the crime scene tech take photos, yes.
Right. You were just here. I think you were holding the umbrella.
Yes, sir.
Okay. And do you know the year that you've identified it as a Chrysler 300, the vehicle, correct?
Yes, sir.
You know the year of it?
I believe it's a 2016.
2015?
2016.
2016, and this was in 2021 when you took those photos, correct?
Yes.
And that'd have been 6 years later, 5 or 6 years later, if my math is correct?
Yes.
That's how old the car was?
Yes, sir.
Thank you.
Anyone else? Redirect?
No, Your Honor.
May this witness be excused?
From the state, yes.
Yes, Your Honor.
You're free to go to executive.
Thank you, sir.
I state you may call your next witness.
The state calls Thomas Gonzalez.
Raise your hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, sir.
Whenever you're ready, Counselor.
Thanks. Good afternoon, sir. Would you please state your name for the record?
Yes. My name is Thomas G. Gonzalez Jr. Gonzalez, Gonzalez.
And Mr. Gonzalez, are you currently employed?
Yes, I am. I'm currently employed by the City of Tampa Police Department.
And what is your job title at the Tampa Police Department?
Latent fingerprint specialist.
Prior to being at TPD, do you have any experience in fingerprint comparisons prior to becoming, before working for Tampa Police Department?
No.
And in this role at Tampa Police Department, did you have to receive any training or education in order to be a fingerprint analyst?
Upon being hired in July of 2000, I received approximately 2,000 hours of on-the-job training to learn how to be a crime scene technician / identification technician. I was trained to document a crime scene using photography, collect and preserve evidence, and process evidence for latent fingerprints. As identification technician, I was trained to analyze and compare ink-to-ink fingerprints for the purposes of elimination and identification. Upon being promoted in April of May of 2006, I received additional 1,000 hours of on-the-job training to learn how to analyze and compare latent fingerprints to known fingerprints for the purposes of identification and elimination. I took coursework in rhinology, advanced latent fingerprint comparison and analysis, courtroom testimony.
Okay, I think you answered my next question. You receive on-the-job training in order to keep up to date with the fingerprint and comparisons and if they change or anything like that?
Yes, I do.
Okay. How much time would you say a week is dedicated to comparing fingerprints?
The vast majority of my time.
Alrighty, and in general, in your years of experience, how many fingerprint comparisons do you believe that you have performed?
Many, multiple, hundreds of thousands.
At this time, the state would tender the witness, Your Honor.
Anyone have any questions?
No objection.
No, sir.
All right, you may continue.
Why don't you walk us through exactly what is a fingerprint?
A fingerprint, known fingerprint, let's just go over known fingerprints. If you want to get the known fingerprints of an individual, you take the person's hand, roll it into a thin layer of printer's ink, and re-roll it onto a fingerprint card. Or nowadays, you can do it on a computer scanner, and that's how it's done. It's just the known fingerprints, which is a copy of the ridge detail on the hand.
And so I think by the name of a known fingerprint, that then that basically says that you know who the fingerprints are coming from. Is that correct?
Yes, that is correct.
And would you say that each fingerprint has differentiating characteristics as opposed to another person's fingerprints?
Yes, approximately a dime-sized piece of skin anywhere on your hand is unique to every other piece of skin on your hand and anywhere else.
And does anyone have the same fingerprints, even identical twins?
No, with over 100 years of research and multiple hundreds of millions of fingerprints, we have yet to find two people with the same fingerprint.
If you could, Mr. Gonzalez, can you briefly go over any type of methods you use when comparing prints to one another?
Technically, I use the ACE methodology, which is doing an analysis, a comparison, an evaluation, and a verification phase, comparing the RID system from one fingerprint to another and determine if those RID systems came from the same finger or not.
Were you asked to compare fingerprints in this case?
Yes.
And I'm showing you what's been already entered into evidence as State's Exhibit 34. Do you recognize this document, sir?
Yes, I do.
And how do you recognize it?
I recognize it from my analysis and comparison work in this case, and also my handwriting.
Okay, and so your handwriting is all the red ink that's alongside this exhibit?
Yes, that is correct.
Okay, thank you, sir. And I'm going to be handing you, Your Honor, permission to approach the witness.
Yes.
I am handing you what's been pre-marked, or I think I messed those up. That was Exhibit 33, excuse me. I'm
Okay.
handing you what's been pre-marked as Exhibit 34. Do you recognize this, sir? Would
Yes.
you like me to put the other exhibit?
No, I recognize the date.
Okay.
Okay, and the red mark, okay.
All right, and you're looking at certain things in order to recognize it, is that correct?
I'm sorry, what was that?
Are you looking at certain things on that document in order to recognize it?
Yes, I'm looking at my handwriting and also the red dot I notated on when I did my comparison.
Okay. Would you say that this is the same or substantial same condition from the last time we reviewed it when comparing it to Exhibit 33?
Yes.
State will move to evidence which can pre-mark the State's Exhibit 34 as State's 33.
Any objection? 34 will be admitted.
And when you had the opportunity for this case to compare Exhibit 34, the known prints of Mr. James Denson, to the Pond Form Exhibit 33, were you able to find any conclusions?
Yes, I conducted a comparison and concluded that the same person that was rolled in exhibit, I believe you said 33 was the court rolled prints?
No, I'm sorry, sir, 34 are the known prints.
Okay, so the same person that was rolled in exhibit 34, which is the court rolled print, was the exact same person that left behind the inked impression on exhibit
33.
33, thank you.
Thank you. One moment, Your Honor.
Yes, ma'am.
The State will pass witness. Thank you, Judge.
Any questions?
No, sir.
No questions. No questions.
May this witness be excused. You're free to go, sir. Thank you. State, you may call, you know what? Yeah, we got one time for more witness before we break. Call your next witness.
Statement called Bessie Tapp.
Your Honor, can we approach very briefly?
Yes. All right, ladies and gentlemen, we're going to take our 10-minute break now, so if you all can come back about 5 after, we will see you then. 10 minutes.
All rise for the jurors.
I renewed on the record my objection to the court's pretrial ruling as it relates to the motion to dismiss, first the C4 motion.
That wasn't my ruling.
Correct, Judge.
Right.
It was in pretrial.
But you want to just renew your objection?
I want to renew the
Understand.
objection for that motion to dismiss as well as the motion to dismiss referencing the destruction of evidence.
Okay. Thank you.
All rise for the jurors.
Van Heist.
Jury's back. Y'all may be seated. Welcome back, ladies and gentlemen. Again, I ask, and I assume there were no issues with the court's instructions. Very good. State, you may call your next witness.
State will call Sergeant Gregory Van Heist.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir.
Whenever you're ready, Counselor.
Good afternoon, Sergeant. If you could please tell the jury your name and spell your last name for the court reporter.
Sure. It's Sergeant Gregory Van Heist. Last name is V as in Victor, A, N as in Nancy, space, capital H-E-Y-S-T.
Thank you, sir. Sir, where are you currently employed?
Currently employed with the Tampa Police Department.
And how long have you been working with the Tampa Police Department?
It's going to be almost 26 years now.
All right. What is your current position with the Tampa Police Department?
I'm currently the sergeant of our Internet Crimes Against Children and Digital Forensics Squad, or Cyber Crimes Unit.
Okay. How long have you been working in that position?
I've been there about 5 years.
All right. Prior to working there, where did you work before that?
Prior to this position, I was the sergeant of the Homicide Squad, and I was the sergeant there for also about 5 years.
Okay. Back in August 22nd of 2021, were you still in the Homicide Division, or had you already transferred?
I was not. I had transferred to the current role where I am now.
All right. In your current role, though, do you often render assistance to homicide detectives when it comes to items of evidence with regards to telephones?
I do, yes.
Okay. And is that based on your experience in the past with the use of this technology and your experience right now in the current position you hold?
Yes, it is.
Okay. So in your career with the Tampa Police Department, have you ever had opportunities to work on cases regarding cell phone technology, specifically dealing with cellular record, mobile forensics, and cybercrimes?
Yes, I have, quite a bit.
Okay. Have you had any specific training in those areas?
I have, yes.
What sort of training have you had?
So it's probably been, it's well over 300 hours of varied training. Some of the summaries of the training have been put on by organizations like the Federal Bureau of Investigation, the FBI. They have a technical unit called the Law Enforcement Technical Forum. Twice a year, we'll go and meet other investigators. They'll bring in companies like T-Mobile, AT&T, Verizon, Apple, and they give us updates on their technology. We're able to ask questions, bounce ideas off each other. I've also attended multiple trainings put on by private organizations that give advanced training on call detail records, mobile forensics, things like that.
All right. And what would you say, could you go over just basically your total training and experience in these areas? Like what sort of things you've done?
As far as what I've done in my role?
Just your experience, yes, when it comes to this stuff.
So I've mapped out cell phone records probably hundreds, if not now over 1,000 times. I've written, probably the same amount of search warrants, obtaining those types of records from cell phone companies, obtain data from devices themselves, use them in cases, and then assisted other detectives or officers in their cases also.
All right. And so as a part of this, then you have had occasion to map out cell site records, travel of a cell phone type of instance situations?
I have, yes, quite a bit.
All right. And how is that done generally, if you can explain? Just sort of a general, you don't have to get to technical.
Sure. So we as investigators will obtain data from a company such as T-Mobile via a court process, usually a search warrant. Those records will come to us in an Excel spreadsheet. It'll have rows of data, so rows of the activity that occurred for that phone number. Those rows will have items like the timestamp of when it occurred. They'll also have a cell site location, so which cell site that occurrence associated with geographically. It also could have the numbers that were called or texted, the unique IMEI or device identifier that was used for that event. And then some of the more specialized records could also give an estimated location of that device with latitude and longitude, and potentially an estimated distance from the cell site. Also which side of the cell site it interacted with. So a lot of that type of data will come in, usually in a spreadsheet format.
All right. Have you ever testified as an expert in this area?
I have, yes.
About approximately how many times?
I believe 5 times.
All right. And has that been in this jurisdiction?
Yes, in this circuit.
All right. Judge, at this point, I'll tender the witness if any defense has any questions.
Any questions? All right. You're free to continue.
All right. Thank you, Judge. Sir, now, in preparation for today, did you help prepare an exhibit to demonstrate, in this particular case, your analysis of the 5 phones that were presented to you, or 5 phone numbers?
I did, yes.
All right. At this time, I'm going to approach and show you what's been marked as State's Exhibit number 45 for identification, and have you go through this. Do you recognize that?
Yes, it's a demonstrative that I created.
All right. And does this fairly and accurately depict the testimony you're going to give as far as the information you recovered when it comes to the cell phones you were provided in this case?
The cell phone records, yes.
Okay, cell phone records. Judge, at this time, I would move State's Exhibit number 45 into evidence.
Any objections?
No objection.
All right, 45 will be admitted.
All right. So starting with page 1 of 45, this is just sort of a title page, I guess, of what you're doing in this case, correct?
Yes, sir.
All right. Now, on page 2, Please explain to the jury what this page is trying to demonstrate or explain to them with regards to cell phone technology.
Sure. So this is just to give a little bit of example of a traditional cell tower or cell site, if you will. On my left, there's a picture of a traditional cell tower or cell site. Those are going to be antennas on top of a tower. Generally speaking, not always, but generally speaking, a cell site will have 3 sides. It's going to have 3 sets of antennas, each pointing about 120 degrees. It's not an absolute, but generally speaking, they each cover about 120 degrees of range. This is kind of to show that's how they might be set up. I'm sure all of us have seen several of those around the city of Tampa.
Now, page 3, I believe you have some pictures of particular cell site towers and how they work. Is that correct?
Yes. So these are just some additional examples of how cell sites can appear. They can be on the top of a pole, as is on my left here. They also can be smaller or non-traditional cell sites, can be an antenna just on top of a telephone pole, or they can be attached to the side of a building. So they're not always those 3-sided. They can come in different ways, but generally speaking, there are going to be 3 sets or 3 sides to a cell site having antennas on those 3 sides.
Now, page 4 contains basically a map of some sort, is correct? Now, what are you indicating with this?
Yeah, this is just a disclaimer. As we look into some of the mapping that was done I do for all these cases, but this case also, where those 2 lines, those straight lines meet, that's the location of the cell site. This shaded area in red here, that is at the bottom or where those 2 lines meet, that's going to indicate which side of that cell site that call or text or interaction with the device occurred with. So which side of that cell tower or which antenna. The disclaimer is that shaded area does not mean that the cell phone was inside of that area. It doesn't mean that the cell phone was inside of the confines of those 2 straight lines. It's simply meaning that this is a depiction of where that cell site is, where those 2 lines meet, and then which side of that antenna interaction is occurring with.
And then you also have it on page 5 discussing timing advance. What is timing advance versus the page before, which had to do with the cell site or cell tower location?
Right. So there's 2 sets of records we can get that give some geographic information about a device's interaction with a cell site. Call detail records are the traditional records that occur with a call or a text, or it could be a data, like something, your phone is uploading something to Facebook. It needs to make that connection to the internet to get whatever message across. That's going to create that connection with the cell site that just gives you where the cell site was in the world and which side of the cell site or which antenna it occurred with. Timing advance is a different type of record. It happens without any interaction by the user. It's the companies like T-Mobile describe it as a network event. So it's a connection between the device and a cell site with no control or no input by the user. The company's intended it so that their devices will work perfectly, so that when you hit send, make a call, the timing is just right, that it goes to the cell site, goes through the lines, goes to the other system, and reaches out to their cell site so you can make that call or text. They want to know generally where those devices are so they can get the timing right, thus the name timing advance. So what they do is actually with a search warrant, we can get these records. They will be time-stamped, and they'll have the location of the cell site that I interacted with. They'll have the direction, so which antenna, if it's the north side or the south side or southeast. And then also, the data will give an estimated distance from the cell site. That's that arc that you see there. And then they also will provide an estimated location of the device. Now, they say in the records, and I've learned this from experience, that is an estimation of the location of the device, that dot that you see extending out, that black dot on the top of the map we're looking at. This is just to show that, again, it doesn't mean the device is exactly along that arc. It definitely doesn't mean the device is where that estimated location is, but this is what you're going to see in the slides coming forward.
And then on page, I believe this is page 6, you also talk about, I guess, AT&T's system, which is different than T-Mobile's. So Sergeant, when it comes to each of these cellular mobile companies, they all use different technology, I'm assuming, or different ways of getting their information?
More or less, yes. They all have their own proprietary technology they're going to use. T-Mobile has records they will collect or provide in one way. AT&T will provide them in a different. AT&T has a record called NELOS, or Specialized Location Record, which is, again, an estimated location of that device. They'll actually give an estimated radius of certainty, but they also give a disclaimer on their record saying that it's an estimation, and it doesn't necessarily mean the device was actually in the circle that you're going to see. But I think it's on an upcoming slide here.
Yes, so in this, so AT&T is different than T-Mobile in how they send their information, correct?
Well, yes. In 2021, when this case occurred, AT&T did not provide timing advance records. T-Mobile did. AT&T didn't. AT&T's additional record is this historical precision location information, which gives that latitude and longitude, which in this example we're looking at here would be right in the middle of that circle, that shaded area, and then they'll give in a radius. So that's that shaded area depicting the radius they're reporting where they believe that phone was inside.
All right. So, Detective, having gone through all that information, were you provided telephone numbers and subscriber information regarding 5 different phones in this particular case?
I was, yes.
All right. I'm going to go through those individually, and we're going to start with, well, you go through, all right, so let's start with phone number in red here. It's 813-461-9827. Was that a number in records you were provided?
Yes, that is.
All right. When you get this information, does it also contain subscriber information?
It does, yes. That's one of the items that's requested in the search warrant, and that's what you're seeing here on the right.
All right. So in this particular case, we know through the detective the numbers and who they're associated with in each device. But in this case in particular, or this number in particular, this subscriber information does contain, in fact, the name of Zavante Sampson. Would that be accurate?
Yes, that's correct.
All right. And so the page that I'm going to zoom in a little bit on the page. If you can, please explain to the jury what we're seeing here in the subscriber information page.
So it's going to give a name, subscriber name, Zavante Sampson, a subscriber address, 3112 East Emma Street. It'll give a status, so active, some dates of when that account was opened. And then if you go further down, it gives some more details regarding the MZ is a unique number that's on the SIM cards, that little white chip that we put on our cell phones, and the new ones we don't anymore, but we used to put those little white SIM cards on our phones. That's that unique number there that's associated with the phone number. It gives the phone number, the MSISDN is the phone number that's in question here. And then it also will give, in this case, a date of birth, a social security number if the user provided that upon signing up for the account.
All right. Now, just because a person may have a phone on them does not necessarily mean that that the subscriber information will be that person's information. Would that be accurate?
Correct.
All right. For instance, we have a phone number that Detective Salea attributed to Andrew Thompson, which is 813-499-4882. This is the AT&T phone. Is that correct?
Yes.
All right. And this one has subscriber information, does it not?
It does, yes.
And who does it have as the subscriber for this telephone number?
So the financially liable name is Ferris Gilmore. It looks like also the billing party and the user information is Ferris K. Gilmore.
All right. So the subscriber information doesn't always indicate the individual who owns or has the phone and is using the phone.
In my experience, no.
Okay. For instance, if my son has a phone, but I'm the one who takes the phone and purchases the phone for him and I pay for it, it will probably be in my name versus my son's name.
That's correct.
Okay. And the next one we have is phone number 813-534-8321, which in this particular case, we know from the testimony of Detective Salea that this phone belonged to or was taken from and in the possession of Jalen Bedward. Oops, hold on, I have that here. So, with regards to this subscriber information, if you could explain to the jury what we're looking at here as far as the subscriber information.
So this subscriber information is showing as in prepaid or non-customer. This is likely going to be a type of phone that, well, prepaid, for lack of better words, where a subscriber information or an ID was not required in order to get service. So they're prepaying for the service. They're using T-Mobile's network for this phone number, but they haven't provided a name, date of birth, or address or whatnot.
Okay. All right, and then we have phone number 813-953-6476, which was taken from Quandarius Hammond. And this one does it not indicate that the subscription info belongs to a Quandarius Hammond?
It does. In the account billing address, it lists Quandarius Hammond with an address on Flatgate Mark Drive.
All right. Now, this T-Mobile subscriber information page looks slightly different than some of the other ones we've seen. Do you know why that is?
Yeah, at this time, 2021, T-Mobile had purchased Sprint. If you remember, Sprint used to be another mobile provider. So they're going through a merger here. So the records for about a year or so were merged, so to speak, and that's why it's noting Sprint now part of T-Mobile. So sometimes we call this a legacy Sprint number, but it is operating at this time was on T-Mobile's network.
Okay, thank you. And then finally we have 813-408-2912, which Detective Saleh has indicated was a phone that was provided by James Denson. And who do we have as the subscriber information for this particular phone number?
Okay, the subscriber is Boat Denson.
Okay. Now, could Boat just be a nickname, or what? How do they get these subscriber names?
My experience with T-Mobile, at least, is it can depend on which store you go to, I guess how much information you're willing to provide, but you can give generally any name, and there's not, especially at this time, ID was not required to get a T-Mobile service.
Okay. So I could walk in and just say John Smith, and they would say, okay, I'll type in John Smith, and that's going to be the subscriber on this.
That could be, and depending on which store or whatnot you get that T-Mobile service from, yes.
All right, now, so that's the subscriber information that you receive. With that, you were also given other records that come with it, correct?
Yes.
All right. And is one part of that called detail records?
Yes.
All right. So I'm going to show page 10 of your exhibit here, and it shows, is this an example of what you would call detail records that are provided by T-Mobile?
This is, yes, and this is actually one row of activity. I had to break it up so it fit on a slide. So all this would actually be in a line or an Excel spreadsheet. This is what I was describing before, where this is called detail records, where you have a timestamp, it gives a call type, which in this instance is describing an SMS, which is a text message. It's giving the numbers that were involved, the IMSI number, the IMEI, that's that unique identifier for the device. And then it also will give the identifier for the cell site, that's the LTE site ID. It gives an azimuth, and azimuth is the direction of that antenna, what we talked about before. A latitude and longitude of where that cell site is in the world. If you remember back to that map where those two lines are meeting, that's that latitude and longitude. It'll resolve it to a physical address in the world. And it will do that depending on the record that's provided, but sometimes it'll do it for the beginning of the call and the ending of the call. So you may have the same information if your call starts on one cell site and ends on one, or if you're on the interstate, you may be starting on one cell site and 10 minutes later when your call's done, you're 10 miles up the road, it might be a different cell site that call is connecting with.
Okay, so it'll give you both cell sites then?
Yes.
All right. So for instance, in this particular case, you indicate the latitude and longitude of the last tower, which is 27.98901 and negative 82.4. So if you were to go in this world and have a latitude, longitude, and were to go to exactly to that particular spot in the world, this cell tower that we're talking about should be right at that spot.
Yes.
Okay. And of course, it also gives an address of 4406 East Osborne Avenue, but the latitude and longitude is what is actually the location of the cell tower.
That's what we use to map, and that's what is the most reliable piece of data, yes.
Now, you also give an example from data that gives time in advance. So I'm going to take you to your slide number 13 of your exhibit. What are you talking about here when it talks about time in advance? If you can explain that to the jury, please.
Sure. So this again is actually one row of activity. At the start of this row of activity, it gives a latitude and longitude, end latitude and longitude. So that's the estimated location of that device at the end of that network event or that connection with the cell site. It's going to give your MZ, which is identifier for the SIM, associated with the phone number, and IMEI. That's a unique device identifier. In this case, it'll give actually the type of device, a Samsung Galaxy S8. It gives start date and time, end date and time, so some timestamps. And then it will give identifiers for that cell site that it was associated with. And then kind of the important piece of data is the distance, the start timing advance miles, the end timing advance miles. So in this example, it's 0.53 for both. So that 0.53 is the estimated distance from that cell site that network event or that transaction occurred with.
All right, now, Sergeant, do you take this information that's provided in these timing advance and in these cell site data that you receive, how do you turn that into a map form or a form in which that it can be presented to a jury or to anyone to explain where the phone may be located?
Sure. So we have a mapping tool. It's called CellHawk. There's several other tools available. That's the one that I prefer to use. I also can use things like Google Earth. But for the purposes of this demonstration or this demonstrative I created, I use a tool called CellHawk.
All right. And then for that CellHawk, you input the data that you're receiving, basically, and it will put out on a format for you so that you can review it on a map.
Yes.
Okay. So let's start first with the phone number that's been associated with Zavante Sampson. Did you, in fact, do that same sort of information with Zavante Sampson's phone?
Yes.
All right. And were you able to obtain both the cell site activity as well as some timing advance records with the phone number associated with Zavante Sampson?
Yes.
Okay. So I'm going to start with what's page 14 of your exhibit that we have here. Explain to the jury what we are looking at with regards to the cell site activity with Zavante Sampson.
So this is a map depiction of activity between 9 p.m. and 9:10 p.m. on August 22nd, 2021, for the phone number ending in 9827. There's activities occurring with two different cell sites, one at 9:08 p.m., and then there's activities between 9:07 and 32 seconds and 09:08 p.m. Again, where the two lines are meeting is the location of the cell site. The shaded area is the direction of that interaction, or which side of the cell tower it interacted with. And then the pins there are just representing two locations that were provided to me by Detective Slay as being relevant in the investigation. East Hillsborough Avenue and North 33rd Street being the red pin, and then 4412 East Hillsborough Avenue being the blue pin.
Okay. And you don't know specifically about the facts regarding this case per se, you just know that those are relevant areas to the crime or to the charges?
Yes.
Okay. And so I'm going to zoom in a little bit here, and so maybe we can get a better idea. So US 92, what road is US 92?
That's Hillsborough Avenue, or there's East Hillsborough Avenue.
Okay. And so these locations, Hillsborough Avenue and North 43rd Street, which the jury has heard about, that's where that red pin is located, correct?
That's correct.
And the blue pin is 4412 East Hillsborough, which is just a little bit down the block.
That's correct.
All right. So based on this information, at the time between 9:07 and 9:08 p.m., where would you estimate that the cell phone belonging to Devontae Sampson was located, generally?
Generally, I would say consistent with being in this,
You can use, there's a stick beside you, or the thing if you want to use it.
yes. Based on these records, I would say generally, it's going to be in that area.
Okay.
Again, and I say generally.
Now, this is not the timing advance records, correct?
That's correct.
All right. You also obtained timing advance records with this phone. Would that be accurate?
Yes.
Okay. So moving on to page 15, again, sticking with Devontae Sampson's phone number of 813-461-9827. Is this an example of timing advance records that we were talking about?
Yes.
Okay, explain to the jury then, what is the difference between this one and the last one that gives you any indication, or better, maybe a better indication of where the phone may be located?
Sure. So the data here that gets a little more granular and gives us as investigators a better idea of where that device was, or a lot of times the most helpful, this is very helpful in looking for video surveillance. If we have, if we're trying to find a phone, we can use this type of data. You see those arcs. So those arcs that are occurring in this set of data between 9:07:30 p.m. and 9:08:34 p.m., those are the estimated distances from that cell site. They're interacting with the side of the cell site, which is just the shaded areas representing, which is generally going to be the north side of the cell site, generally arcing for that distance. So it gives a lot more granularity than the previous slide we looked at, which is simply the side of a cell site that it was interacting with. Now this is actually giving an estimated distance.
Okay.
The dots, coming off are the estimated locations that T-Mobile provides. Again, they preface that in their record saying this is an estimated location. But when you kind of get them in congestion, I've learned that sometimes it's a good idea if you're trying to find that cell phone, I'd probably go look in that area.
Okay. So when you see, so the more times where it's hitting kind of in the same location, you would, as a detective, and you were out to have, and you had to find that phone, and you were said, and they gave you this, where would you go first?
Can I use the stick?
Yeah.
If that were a scenario, I would draw a box, a block north of Hillsborough. I'd probably go 2 or 3 blocks south of Hillsborough, between 4,300 and maybe 4,600, and I would look all around that area.
Okay. So according to these timing advance records, between 9:07 and 9:08, that phone was probably somewhere in that area that you have just described.
I believe so, yes.
Okay. Okay, now we're going to go to the phone that is associated with Andrew Thompson. Let me get to phone number. Now, this is the phone where the records come from AT&T, correct?
Yes.
Okay. So as far as the CDR with cell site activity, what does this show as far as the phone belonging to Andrew Thompson?
There was no activity between 9 p.m. and 9:10 p.m. for that phone number ending in 4882 on August 22nd, 2021.
All right, so during that time period, during those 10 minutes, by saying no activity, that means that the individual who had that phone was either not texting or not calling or not using any sort of internet-type activity on that phone.
Correct. No calls or texts. There was no records created on AT&T's network for user interaction. Yes.
Okay. So for AT&T, normally you would need some sort of something to, in order for them to put up the situation where it might be.
Correct. Most commonly a call or a text.
Okay. Now, it also has, AT&T has some what's called historical precision location, is that correct?
Yes.
And what is that?
That's their estimated location of device at a specific timestamp.
Okay. No, go ahead, I'm sorry.
Nope, that's what it is.
Okay. I just wasn't sure if you were done,
Yep.
I apologize. So going to page 17, did it give at 9:09, almost 9:10 p.m., did it kind of give a general location or where it thought the phone might be?
It did. So at 9:09:55 p.m. on August 22nd, 2021, it gave latitude and longitude, which is going to be depicted right in the middle of that shaded area, that shaded green circle you're looking at, with a 1,500 meter accuracy, which is quite large.
Okay. Now, Detective, you're not aware of what time this shooting or the circumstances surrounding this actually occurred, other than it was somewhere between 9 and 9:10. Would that be right?
I believe it was provided to me at some point, but I don't recall it at this moment.
Okay. So at 9:00, so if the shooting occurred at 9:04, at 9:09, the phone's here, it could be that he has moved to that location at that point, or this could be maybe slightly inaccurate, or one combination of both of those.
I think a combination of both could occur, yes.
Okay. Moving to the phone associated with Jalen Bedward. This is 813-534-8321. Let me just confirm that with my notes here to make sure I've got the right phone. I believe I do, but. Yes, so this is the phone number associated with Jalen Bedward, which also had a T-Mobile, right? So the only one that had AT&T was Andrew Thompson.
Correct.
All right. So with this T-Mobile, did you receive or were you able to map out the CDR cell site activity with this phone?
Yes.
Okay, I'm going to show you page 18 of your exhibit and ask you, is this in fact, with Jalen Bedward, explain if you could to the jury what this is showing.
Yeah, so this is going to be similar to the previous record. This is going to be activity, call detail records, so calls or texts generally, between 9 p.m. and 9:10 p.m. on August 22nd, 2021, for this phone number ending in 8321. There was an interaction that occurred at 9 o'clock and 42 seconds. Occurring with the cell site, you'll see there where those two blue lines are meeting, generally with the north or northeast side of that cell site. The antenna is facing that way.
Okay. And so both the pin locations that are located here are within that range of that cell tower?
Yes.
And so if someone was in either one of those locations using that phone, it would make sense that it's hitting that spot on that cell tower?
That would be consistent with, yes.
Okay. Did you also receive time in advance records for this phone also?
Yes.
All right, I'm going to go to page 19. All right, Sergeant, if you can, please, because this one seems a little bit more complicated than some of the other ones we've seen, explain what we're looking at here so that the jury can understand what this map is showing.
Yeah, so again, this is activity between 9 p.m. and 9:10 p.m. on August 22nd, 2021, phone number ending in 8321. This is a timing advance record, so where all of our straight lines are meeting, that's going to be the location of the cell site. The shaded areas are the direction of that cell site's antenna that is interacting with, so the north side maybe, or maybe the east or west. And then those arcs that are lines by itself, those are the estimated distances from that cell site. Then lastly, we have a lot of those pins shooting up from the cell site location. That's T-Mobile's estimated location of that device at that time. So here we've got interaction with 3 different cell sites in that 10-minute time span. Over on the west side of the map, which is going to be the left side, my left side, around 9:05 p.m., there's activity towards the bottom of the southern cell site between 9 and 24 seconds, 9 o'clock, 24 seconds, and 9:08:05. And then there's interaction with the cell site on the eastern side between 9:04:27 and 9:09 and 0 seconds.
All right, and what do the lines and the curves and the dots signify in this particular case?
So it just shows that device was interacting or was estimated to be that distance from those cell sites. What's, I guess, unique or significant with this record compared to the previous one is when you have interactions with more than one cell site, it often gives you a higher reliability. So you have distance from one cell site that matches up or crosses with a distance from a different one. I think a previous question you asked me is if I were to go look for that cell phone, I would go wherever those arcs intersect. Because now you've got 2 different cell sites giving similar information or the same information.
So let's say at 9:05 p.m., if you have to find that phone where it was at 9:05 p.m., what would be the area you would look at that time period?
Can I use the stick again and get
Yes,
it?
please.
Yeah. I'd say at 9:05, I would draw a square around these 2 pins, probably go 1 block north and 1 block south, and I'd start there.
Okay. Now, if an individual had left, say, at this location, kind of in the middle of Hillsborough, and had headed east at 9 2:03 p.m., let's say, was driving the normal speed. At 2 minutes later, would you anticipate that that phone would be hitting anywhere around in that area?
I would not, no.
Okay. So in 2 minutes, it would probably be hitting by towers further off this location. Would that be accurate?
Well, it'd either be hitting cell sites further to the east or to the right-hand side of the screen, but most importantly, we would see our distances or our arcs would also be showing on that eastern side or on the right side of the screen.
All right. So, okay, thank you, Detective. I think that explained that. All right. Moving on now, we're going to go to the phone number that has been associated, let me make sure I got this one right, with Quandarius Hammond. So again, Mr. Hammond had a T-Mobile, correct?
Yes.
All right. So going to page 20 here, during the time period between 9 and 9:10, again, this is showing no activity.
That's correct.
Okay. So at that point in time, so between those, for those 10 minutes, that phone that's associated with Quandarius Hammond was not making it, or was it making any phone calls, any texts, any using the phone for internet service or anything like that?
Not that were reported to T-Mobile. There could be activity that may have occurred that's not a call or text that didn't show up on the network, potentially like an iMessage or something like that. But generally, that would use T-Mobile's network did not show up on those records.
All right. Now, did you receive, again, with this phone number, time in advance records?
Yes.
All right. Going to page 21 of your exhibit, this is in fact the time in advance records you received with regards to Quandarius Hammond's telephone?
Yes.
All right. If you can, again, once again, explain to the jury what we are looking at with regards to this phone.
So here, a little bit different, and this is due to that merger between T-Mobile and Sprint. So their cell sites they were using, they started to merge and share their cell sites. So some of the information about which side of the cell site was not provided or not available in a cell site list. But again, we're seeing interactions between 9 o'clock p.m. and 9:10 p.m. With the cell site located where the two lines are meeting. That's that cell site in the bottom on the north side of that cell site with estimated distances that kind of go up to the Hillsborough Avenue and then extend down. The two circles you're seeing, right in the middle of those circles, those are locations of cell sites. And again, that's because on the records, we're not able to determine which side of that cell site it occurred with. So that then larger circle that's around it, that's your estimated distance. So what's interesting here is you've actually got estimated distances, kind of a area that's encompassed between the outer rims of those two circles and then the other arcs that are coming from that southern cell site.
So does this give it almost a more refined location, if you will, for the phone?
It does. Most notably is that the activity at 9:04:47 p.m. gives, again, it's a 360-degree distance. So it's saying somewhere in that 360 degrees around that cell site. But then at 9:04:12, so just before that, you've got a distance just to the east, which means that cell phone wasn't moving from one side all the way to the other. It's going to likely be right near where those two arcs are on the interior of those circles.
So if you could, as you've done previously with the other, can you show kind of the general location that you would expect that phone around 9:05, I'd say, or 9:04, between 9:04 and 9:05, where that phone, if you had to go look for it, where it would be located?
If I was asked to go look for that phone, I would, again, I'd go 1 or 2 blocks north and south of Hillsborough Avenue. I'd go just on the left-hand side or west side of the red pin. I'd come down, go across, and then go up 1 or 2 blocks to the right or east of the blue pin, and then make a rectangle right there. I'd look right in that rectangle box.
All right.
Sorry, rectangle.
So based on these records, you would estimate that that phone was somewhere in around that Hillsborough area and around those dots during that time period?
Yes.
And again, as with the other phone, it did not head to the east. It did not go anywhere different. It stayed in that general vicinity during that time period.
It appears that way, yes.
And finally, the phone number that has been associated with James Denson in this case We have, it's 408-2912. Again, with the cell site activity, there was no activity as we've seen with a couple of the other phones. Is that right?
For the call detailed records, correct. Calls or texts, no activity.
All right. Did you also obtain timing advance records for this phone?
Yes.
Showing you what's page 23 of your exhibit, what does this timing advance record indicate to you?
It indicates to me there's several records that occurred in that 10-minute time span. And again, they're occurring with cell sites that generally provide coverage to that area. That would be where the blue and red pins are, with several arcs or estimated distances from those cell sites that are crossing over or in that area.
All right. And again, under these timing advance records, some of these dots are almost correlated with those dots. And that's the estimated spot that T-Mobile's giving, but it doesn't necessarily mean it's right there.
That's exactly correct. T-Mobile prefaces and said this is an estimated location, and I've known from experience too that does not mean the device was there. That's what T-Mobile is reporting to us, saying this is our estimated location.
But you would agree, though, that that's a pretty good indication that it's somewhere in that area?
Again, well, I would say if I was asked to look for that device, I would go right to that spot.
Judge, if I may have one moment?
Yes, sir.
All right, Your Honor, at this time, I will pass the witness.
Cross?
Good afternoon, Sergeant.
Good afternoon.
So there were several phones looked at. I think I'm going to try and keep it simple by referring to some of the phones by color. Specifically looking at, we'll say, the light blue phone, I believe you identified belonged to a Jalen Bedward, correct?
I believe that's what was relayed to me, yes.
And a black number linked to, a James Denson?
That's correct.
And lastly, the green number you stated was linked to an Andrew Thompson?
I believe that's correct, yes.
And look at page 18 of your composite exhibit 40, which exhibit is this? 45. All right. So I believe you stated the arches point in a northern direction. Typically the phone would be within those arches.
No, for this record, so this is going to be a cell site activity, so general calls, texts. This is simply stating that that device interacted with the cell site located where the straight lines meet, with the antennas facing in this direction, the north, where that shaded area is. That's the interaction occurred within that range or in that cell site's coverage.
Right. So somewhere within where that cell site covers that area, the cell phone was interacting with that tower, correct?
Correct.
And typically cell phones interact with towers that usually are more closer to the cell phone due to the stronger strength, correct?
Generally speaking, yes.
excluding other situations such as weather or any factors that may impact tower coverage, right?
Yeah, there could be weather, there could be overload of use, there could be a tall building right next to you and the cell phone's there, so it's going to a further one. There could be different things that affect it.
Okay. But those things that would affect it are pretty rare, you would say?
I would say generally rare, yes. Generally, the cell phone for calls and texts always will pick the cell site with the best signal.
Okay. Looking now at page 19, again, the blue phone tied to Jalen Bedward. And correct me if I'm wrong, typically with the timing advance records, when there's overlap, would it be fair to say that where the overlap is likely, more likely than not, where the cell phone is?
It's a very high indicator that's where the device is or was.
Okay. So based on the mappings and the overlap, would it be reasonable to say that the cell device was on Hillsborough Avenue between 9 p.m. and 9:08 p.m.?
I would say it'd be consistent with, yes.
Okay. I'm going to show you page, what is it? 23, which is previously identified as the phone tied to Mr. Denson. Again, based on the timing advance, you stated where the overlap is usually where the phone is. Would you say that that phone would likely be on Hillsborough Avenue as well?
I would say yes, very consistent with.
I'm going to try my best here. Looking at the phone tied to Mr. Denson and now referring back to the phone tied to Mr. Bedward, would you say that the mappings of these records are quite similar to one another?
I'd say they are, yes, similar. I believe Denson, the slide you showed just previously, had a little more granularity or some records that were maybe closer to Hillsborough Avenue, or the timing advances were.
Okay, but based on your extrapolation of the data, observing the data, interpreting the data, it would be reasonable to say that those phones were likely close together or near to one another?
Well, I guess it depends. Are you mean like in the same car, or you mean like on the same block, or would you mean in the same neighborhood? Because I think that, I want to make sure I understand you correctly.
Well, you tell me.
Oh, I would say along the same block, in the same area.
Okay.
So if we're saying the 4400 block of East Hillsborough, 4300 block, I would say consistent with that, yes.
Right. But you can't pin it down to say, being side by side, say, by myself and Mr. Terry, based on the mappings, correct?
Definitely not.
Okay. Now, I'm going to show you what was identified as the green numbered, again, linked to Mr. Andrew Thompson. Now, you stated that because this phone utilized services from AT&T, the mapping was slightly different, correct?
That's correct.
Okay. And based on the mapping, you stated it'd be reasonable to assume that within that green radius, the phone would somewhere likely be within there?
So again, this is where AT&T prefaces it, and my experience has shown this, is that if you ask me to go look for that phone, I would start there, but I know that that doesn't necessarily mean the phone is going to be inside that radius.
Is it more likely than not to be within that radius, though?
That's a good question. I'd say there's a decent possibility is how I would describe it, yes.
Okay. And I can zoom in. You familiar with Tampa?
Generally, yes.
Could you identify to the jury what that large red, I believe it may be a highway is?
I believe that's Interstate 4.
Okay.
Yes.
So based on the mappings and based on the cell phone data, would it be possible for the phone to be traveling on Interstate 4?
Yes.
And kind of going back and forth here again, quickly looking at Mr. Denson's phone, page 23, based on the way that the wedges are facing, looking at, I guess, the latest times from 9:04, 26 p.m., 9:08, 40 p.m., and 9:08, 49 p.m., would it be reasonable to say that the device may be traveling westward?
I think it's difficult because the different interactions, I probably wouldn't be able to give a travel opinion necessarily with these records.
And the same would apply to Mr. Bedward's phone?
That's correct, yes.
No further questions? Organize this.
Sergeant Van Heist, good afternoon.
Good afternoon.
First, I want to talk to you a little bit about coordinated universal time. Could you explain that to us?
Sure. So most records from cell phone companies and other providers like Google, Apple that we get come in coordinated universal time, or also known as UTC. We have to make an adjustment to either Eastern Daylight or Eastern Standard Time to put the records in our local time.
So if you're adjusting right now for this season, let's say, going through November, we always talk about falling back sometime, right around that time. So what would we be now as far as UTC goes?
I believe we're 4 hours. I always double check it to make sure that I'm right. It's 4 or 5. It flips to, I believe it goes to 5. I believe we're in 4 now. So.
Okay, all right. Now, talking about Mr. Denson and the analysis of some of the records that you had with him. So there's no call activity during that time frame, but you're still able to get from the timing advance records, activity with the cell phone towers, correct?
Correct.
And in your particular analysis, there were 13 such events that occurred during the 10-minute time frame that you were given by Detective Celaya?
I believe so. I'd have to look at the exact spreadsheet, but that sounds about right.
And some of those events could be somebody going on a website or checking a social media page or using an app or something along those lines, correct?
Are you referring to the timing advance records?
Well, what you're using, correct.
Right. So the timing advance actually have no, they're network interactions between the phone and a cell site. And they're really the cell phone company or the cell site initiating it just to know where that cell phone is at certain times so it can make sure all those things happen at the right times. So there really is not even an interaction like going on social media or things like that. It's just an interaction.
But the phone would have to be powered on, correct?
Yes.
And it wouldn't be like in airplane mode or anything along those lines, right?
Correct.
Okay, thank you, sir.
Anyone else? Mr. Hernandez?
I don't have any questions.
Okay.
Good afternoon.
Good afternoon.
Sorry.
You became involved in the case essentially as a supervisor first, correct?
No, I was not in homicide at this time.
Okay, so you weren't in homicide, you weren't called out originally to the scene or anything like that, you just assisted once records were collected?
That's correct.
You don't end up seeing any of the physical phones themselves or, authoring search warrants, things of that nature?
No.
Detective Celaya is the one that brought you in to do that?
Yes.
And you're relying, with these pinpoints that you have in the maps as far as areas of significance on whatever investigation has already been conducted, is that right?
That's correct.
Okay. The records that you receive, do you ask for anything additional, or are you just taking what Detective Celaya gives you?
Taking the records, again, ask for locations of significance so that I could use them on the map, and that would hopefully be helpful to him.
Okay. And you end up, I'm sorry, go ahead.
I'm sorry, and then generally, obviously, at times of when things occurred, so we can look at those times on the records.
Right, you're targeting specific areas and timeframes that the detective, the lead detective on the case is giving you to kind of guide your evaluation of the evidence.
That's correct.
And the mapping that we're seeing is basically like a 8 to 10 minute time frame.
Yeah, I think I used 9 p.m. to 10, or 9:10, so a 10-minute time span.
Okay. And that specific time frame, who came up with that?
So that was probably in discussion with Detective Saleha, or I believe he had given me times where gunfire was either observed or reported or he had information about. My recollection is that 10-minute time span gave minutes before and minutes after, generally maybe 5 or so minutes.
And obviously, the records that were available to you were more voluminous than just that time period.
Yes.
And so you concentrate on that, and you're mapping the activity itself, like we talked about, whether it be calls or text messages, and then you're doing this timing advance mapping.
Correct.
And you said the timing advance mapping is strictly kind of cell provider driven.
Right.
Not based on any activity or connection that the cell phone itself is making at that time.
Are you referring to like a call or a text?
Right.
Generally, yes. I have received some training where you can be making a call and that may trigger a timing advance record, but it's also very common where that timing advance record occurs completely independent of the user's interaction with the device.
And the cell phone companies are the ones keeping track of that. Like you say, it's more of a business situation, that they're trying to see where towers are necessary.
Generally, I think mostly for timing advance, they want to make sure that call or text is going to go through, so they have to know generally where that device is.
When you get the records, you receive records, as you testified, from Jalen Bedward, right?
Yes.
And you receive records from Zavante Sampson,
Yes.
Quandarius Hammond,
Yes.
Andrew Thompson,
Yes.
and James Denson.
Yes.
And those are all the maps that we saw.
Yes.
You also receive cell phone records from an individual named Devin Sampson, is that correct?
Yes.
And you ended up mapping his phone as well.
Yes.
And his phone was in that same area that you were seeing these other phones.
I believe so. I'd have to go back and look at those records to verify that.
If you have one moment. Do you have your records with you?
I do not, I'm sorry.
Okay. Permission to adjourn.
Granted.
Would it refresh your recollection, see the maps that you did?
Yes, and I think actually I stand corrected. I do have my report I could refer to, which may give me an idea of it.
Okay, sure.
Would that be helpful? Okay.
And I was referring to pages 8 through 10 of your report.
Thank you. Yes, so I'm reviewing the map that I did create regarding a phone number for Devin Sampson ending in 3443. Is that the number you're referring to?
Yes.
Okay. Yes, generally I would say it was consistent with being in that area also.
Okay, and that's from that same type of record, the timing advance that you were seeing with the other phones.
Yes, ma'am.
Did you ever receive any phone records from an individual by the name of Cedric Brown?
I don't believe so.
Okay, and did you receive any phone records from an individual named Maxwell Bedwell?
I don't believe so.
And what about Kamani Bedward?
I don't believe so.
I'm sorry, the other one, I meant Maxwell Bedward.
I don't believe so, no.
Okay, nothing further.
Anyone else?
Good afternoon, Sergeant.
Good afternoon.
Sergeant, when we talk about timing advance, and on direct examination, you looked at bear with me. Page 12, which is called an example of data provided. And you said that this comes to you in an Excel spreadsheet, correct?
Yes.
And does this Excel spreadsheet, how is it detailed? What I mean by that is, if this is an example, does someone ask for a date and then it produces data for that date in an Excel sheet?
So if I understand your question correctly, when law enforcement requests records from T-Mobile, how does T-Mobile know which records to provide?
No, is this page 12, this T-Mobile call detail, I'm not looking at this one, excuse me. Timing advance. Same premise though. When you get these records, they're provided to you by T-Mobile, correct?
Yes.
And they're regarding timing advance.
Yes.
When you get it, is it providing you these records in this Excel sheet for a date?
So the search warrant would have listed a time range requested, authorized by the judge. So I think in this scenario, it was maybe 2 or 3 days of records, maybe a day before, the day of the homicide, and the day after. So if T-Mobile had those records available, then they would provide those chronologically in an Excel spreadsheet.
Did you, instead of showing us an example, did you get an actual data for the days for which you requested records?
The Detective Saleha did, yes.
Okay. Did you get them?
Yes.
Okay. And in discussing this example that you're giving me, and if you don't mind turning around for 1 second.
Sure.
It talks about what the confidence level is. Do you know what that is?
Generally, yes.
Okay. Can you tell me what confidence level means?
So for T-Mobile timing advance records, they'll give a confidence level, if available, for an estimated location of that device. So that's going to be that little dot that extends out from the cell site. Generally, they will give it, I believe, low, medium, or high.
Okay.
These are classifications.
Do you know, can you tell us what medium means?
I believe I'd seen on some of their explanation, around 200 meters is what they estimate.
Okay.
I'd have to look back at the records to see, but that's a general recollection I have.
All right, and you said it would also range low and high.
Correct.
Okay. High would be what?
I believe under 100 meters.
Okay. Low would be?
I believe above 300. Again, without me looking at their definitions, that's my recollection.
Okay. And when Mr. Terry was asking you on direct examination where you would expect to find a phone, you used your pointer and you told us that you would start in a range and a location based on A, the pins, and B, what your records are telling you, correct?
Yeah, specifically the distances from the cell site is what I would go after.
And if you told us that you would have started in this particular situation with the 4400 block of Hillsborough Avenue, Mr. Terry said this is probably where the phone was at and asked you if you thought that it would be in that general area. And you said, I believe so.
Correct.
And I assume what you're telling us is that that's where you would first look for the phone.
Right.
And in the event that you did not find the phone there, you would expand your search for that phone, correct?
Yes,
Until you either found that phone or you didn't.
right.
I don't have any further questions. Thank you.
Redirect.
No, Your Honor.
May this witness be excused?
Yes, sir.
You're free to go. Thank you. Thank you.
Thank you, sir.
All right, State, call your next witness.
Bessie Tate.
I'm sorry.
Bessie Tate.
Thank you.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you.
Counselor, whenever you're ready.
Good afternoon. Would you state your name?
Hi, my name's Bessie Tafe.
And how long have you been employed with the Tampa Police Department?
I've been with Tampa Police for 13 and a half years.
What is your job title?
I am currently a forensics shift supervisor.
And were you working in that same position in August of 2021?
No, I was a crime scene technician too at that time.
Did part of your roles include the photographing of potential items of evidence?
Yes, ma'am.
And were you involved in the homicide investigation regarding Suni Bell?
Yes.
Did you have the opportunity to document a vehicle on August 27th of 2021?
Yes, ma'am.
And what was your role in documenting that vehicle, or at least responding to impound on that date?
I responded to the impound lot. I took photographs of the vehicle as is, and then once we opened the vehicle for the search warrant, I documented the interior of the vehicle.
I'm going to show you what's been marked as State's Exhibit 24A through LL. Do you recognize these photographs?
Yes, ma'am. Yes, I do.
Do these at least in part include some of the photographs that you took of that vehicle on that previously discussed date?
Yes.
And do they represent, or do they fairly and accurately depict the vehicle as you did when you photographed it?
Yes, they do.
At this time, Your Honor, I would move to admit States 24A through LL.
Any objections?
No objection.
No objection.
States 4A will be admitted.
24A, Your Honor.
24A through, what is it?
LL.
LL, yes.
Now, did you take some overalls of the vehicle in advance of actually completing a search?
Yes, I did.
And is that what we're seeing here in States 24B?
Yes.
When the vehicle arrived at least to impound, or at least when you arrived to photograph it, was the vehicle still sealed, showing 24D?
Yes, it was.
And how is it that you were able to tell if a vehicle is still sealed?
They're still intact. They're not broke. We place them specifically that if the door or the trunk or hood opens, the seal will break, so they are still intact.
And when you're talking about the seal, is that depicted here in this image somewhere?
Yes.
Where is that?
Would be this right here.
Thank you. And are those placed all around the vehicle, at least when you arrived?
Yes, they are.
Now, if you are able to search a vehicle or are arriving to search a vehicle pursuant to a search warrant, at some point, do you or the detectives actually break that seal so that you're able to complete a search of the interior, showing 24F?
Yes, we do.
Okay, so at some point, you actually open those?
We do.
Do you take full overalls in advance of doing that of the vehicle?
Yes.
Did you have the opportunity in this particular case, showing you 24G, to photograph the interior of this Chrysler 300?
Yes.
And what are we looking at here?
This would be the interior front driver's side of the vehicle.
24H, did you also obtain photographs from the back?
Yes, that's the interior rear driver's side.
And in lieu of going through all of the photos, do you do this same process, moving around the vehicle, photographing overall as you move in closer and closer?
Yes, I do.
Did you have an opportunity to document from the passenger side of the vehicle any mail items inside of the car showing 24I?
Yes.
Did you also document those in 24J?
Yes.
Once you have completed the processing, or at least a preliminary overview of the interior of the vehicle, do you also give a preliminary overview of the trunk area?
Yes, I do.
In 24L, is that what's depicted here?
Yes, it is.
And when you open the trunk, tell me about how you actually process the items therein.
On this one, I initially took overalls as is when the trunk was open, and then the actual detectives are searching through the trunk. And as they find anything of value for me to document, then I take photos.
Were you asked by the detectives in this particular case to document what we're observing here in this photo any closer?
Yes.
And specifically the box 24M?
Yes,
Is this a photograph that you took of that box?
it is.
Were you able to actually obtain additional information of the label of that box in 24O?
Yes, that was a close-up of the information.
And were you asked to document whether there were any contents to that box itself?
Yes, it was actually just a partial piece of the box.
There was no Zastava Arms AR 5.56 rifle located inside of this box?
There was not.
Was there an AK assault rifle located in the vehicle at all?
Not at all.
In your continued search of the trunk of that vehicle, did you photograph after that box had been removed?
Yes.
And do you ultimately also photograph the interior of the vehicle after the items have been removed? Do you continue processing even when you empty it?
Of the trunk, yes.
Yes.
Yep.
All right, you guys, I'm going to end this here, and I want to jump over to closing statements. Because this is almost over. I want to get over to closing statements.
TV.
Let's get over to closing statements. Let me pull this up here. Because this is where Zavante has a bit of a meltdown in the middle of it, like 45 minutes in. So let's get into this.
It's closing. State whenever you're ready.
Your Honor. Two minutes and 6 seconds is what it took to end the life of an innocent child and change the life of her family forever. 2 minutes and 6 seconds is what it took for the defendants seated before you, each and every one of them, to play a role in this case in the murder of Suni Bell and in the attempted murder of her mother and of her uncle on Hillsborough Avenue on August 22nd of 2021. 2 minutes. The defendants, for 2 minutes before that, lie in wait, arm themselves with firearms, put on masks, wave each other on to enter the vehicles, before jumping in to all of the cars depicted in the video that you've seen and chasing down the victims. They're charged with first-degree murder. They're charged with conspiracy to commit murder. The court will read to you the jury instructions that are applicable to the charges, each and every charge that you need to look at the instructions for, to determine whether the state has met its burden in proving to you that each of these defendants, regardless of who pulled the trigger, have blood on their hands in the death of Suni Bell. Throughout this trial, we've seen a lot of evidence. It's our job as the state to hold the burden to put that evidence together for you. We've presented to you experts. We've presented to you the testimony of the medical examiner to establish that Suni Bell was the person killed. But we have not had an opportunity to actually introduce to you 4-year-old Suni Bell. Just starting school.
Overruled.
She was the backseat passenger while her family was attending a celebration of life. But they made a mistake. They violated the rules. According to these defendants, you can't get lost around their neighborhood. You can't drive too slowly near them. You can't stop to look for directions, and you certainly cannot be lost. Because for the less than 2 minutes that Willie Brown was parked in that field, waiting, trying to reach his cousin, the defendants prepared. They got masked up, they got armored up, and they got ready to go to war. Unfortunately, their common enemy was an innocent child and her innocent family members. Each of the defendants is charged in this case, and each of the defendants is guilty. Each played a role in the crime that was committed, in shooting repeatedly into this vehicle. You do not discharge a firearm one time at another human being with the expectation that things will be fine, with the expectation that that person would live. You do it to kill. In looking at the surveillance footage from the gas station, the utter excitement experienced by everyone running around, picking up guns to hunt down this car and shoot at it, is indicative of their plan to kill the occupants inside. The number of shots fired at this same individual car is indicative of their intent to kill. It is not the state's job, obligation, burden to jump into the minds of any defendant. It's impossible. We talk about motive to say, what is the motive? Why isn't it an element of a crime that we have to prove? Because we can't 100% ever tell anyone what is in the mind of that person when they commit this act. We heard in jury selection from a juror in the back who was working as a receptionist of some kind, and the man came in and kind of destroyed the place a bit. His intent was to destroy the place. Walked in, threw, items all over the floor, destroyed the inside of the reception area at her business. None of us will know the motive. Was he upset with an employee there? Did he have a mental health issue? That is the difference between motive and intent. We don't know what your motivating factor is in committing this crime. But you don't shoot into a vehicle this many times with the intent that anyone lives. Starting first with the passenger of vehicle number 1 that we see on these videos. This is Quandarius Hammond. He's the only occupant that you see enter the vehicle with Zavante Sampson. The photo in the center here is what we showed you from Mr. Hammond's social media. He likes to match these items or pair these items together. On either side are the same outfit that he was wearing on the night of the homicide. This is Quandarius Hammond. Quandarius Hammond is the person who walks to the white fence line and crouches down there for just under 2 minutes waiting for James Denson to come back from his lookout point across the street. Just after the victim's silver vehicle passes, he exits the frame and then re-enters crouching down in that same spot. When you watch the video of him getting up from that crouched position, what do you know? The firearm that you have in your cell phone evidence, depicted in the image on the right, photographed the day before, is in Mr. Hammond's hands. Here's Mr. Hammond. There's no point that the state will concede that there is audio to what the defendant's actions were from this video from the gas station. But what the state does assert to you is that it is plain as day what their intentions are. Mr. Hammond is pointing. Mr. Hammond is clearly communicating with the others nearby. And Mr. Hammond is clearly waiting to ambush. At least at this time, fortunately enough for the victims, they don't come back down Giddens on the other side of these defendants. They head to Hillsborough because we heard from Willie Brown he saw the defendants pointing at him and decided not to stay there. Everyone in the videos you see walking around with guns, some masked, some not. The driver of the vehicle that Mr. Hammond gets into is Zavante Sampson. You have to watch him in the video independently. In the video that we showed to you all, which depicts each of the defendants zoomed in on them, has been admitted as an exhibit if you wish to watch it. Because there was a lot of evidence in this case, and it is difficult to ascertain when you watch this. I mean, I watched the video dozens and dozens and dozens.
Sustain.
It's difficult to ascertain who was doing what. So an exhibit that has been admitted for your consideration is that which depicts each of the defendants, follows them through the frame, so that you are also able to focus on what did this person do in the parking lot. Why has the state charged them as a co-conspirator? Why has the state charged them as a principal to all of the crimes charged? You'll see Mr. Sampson pointing, you'll see him talking with others, and you'll see him lead the charge when they exit that gas station. Here's Mr. Sampson with the gentleman in red, who the detective testified was Mr. Sampson's brother, Devin Sampson. Devin Sampson's pointing towards the direction of the vehicles that were passing behind the gas station, their targets. There goes Zavante Sampson pointing towards those same individuals, and the moment that Jalen Bedward enters and trips. Quindarius Hammond enters his position to crouch down and hide, lying in wait. And Zavante Sampson returns to his vehicle. In the video, which follows Zavante Sampson, you'll see while he's at the video, while others are trying to track the car and locate the car, he's pointing, he is waving them on to get into the vehicle, and he takes off. How do we know that Zavante Sampson knew of the common scheme of all of the others? Because he is driving the first shooter. Because all three vehicles target the same victim, the same car. At this exact timestamp, you'll see from some further slides, the victim's vehicle is crossing the boundary of the chevron on Hillsborough Avenue. Looking now to Andrew Thompson.
Yes. Continue.
Andrew Thompson, who by the end of the videos you see entering the passenger seat of the Chrysler 300 with Mr. Bedward as the driver. Now we all know that all of the defendants have admitted or identified themselves from the video surveillance from the night of the offense. They've identified themselves as drivers of the vehicles, etc. But what's interesting about Mr. Thompson is that the minute that Jalen Bedward trips over that rebar and gets back to the vehicle, he rips his shirt off and ties it around his face like a mask. I don't know what they're saying to each other. I won't assert to you that I know what they're saying to each other, but I get the gist. How does Zavante Sampson tie into what Mr. Thompson and Mr. Hammond are doing at the bottom left of the screen? Well, Mr. Bedward and his brother go out into the field to watch the car ride by, and right in the middle of the frame, Mr. Sampson makes some kind of hand gesture to Mr. Thompson and Mr. Hammond, at which time they return to their vehicles and arm themselves with firearms. Mr. Thompson has repositioned himself behind the dumpster. Watching, waiting. Mr. Bedward, gone to the vehicle, changed from a handgun now to his AR. Mr. Thompson returns to Mr. Sampson's vehicle. We have footage that Mr. Thompson enters the passenger seat of the Chrysler 300. When we get to the timelines, you'll see there was no opportunity for anyone other than Mr. Thompson to be in the passenger seat of that Chrysler 300. Jalen Bedward identifies himself as the driver of the Chrysler 300 that night. He's there in the frame, standing just behind on the left-hand side here, his brother, person who at least brings their attention to somebody driving on the back road.
Like the size, is it a great size to where it just
Mr. Bedward, after changing from a handgun to an assault rifle, pointing out to the others from behind the dumpster there, right in line with our timeline of the victims driving up 43rd to head on to Hillsborough. Giving directions to everyone else as to where their target is. All because at the start of this video, the victims depicted in the top right here drive on the road that, according to these defendants, they're not allowed to ride on. As you play back these videos, you'll see the victim's headlights just opposite the street of Giddens, which is the street that they're just nearest to, having turned down the other road to come up and park into the field. We know Jalen Bedward has admitted to possessing this AR, and we know that there is an empty box in the trunk associated to an AR-15 that was not recovered in this investigation, belonging to Mr. Bedward. I've told you that the first time he passes after he trips on the rebar, he switches out his weapon. Mr. Bedward has a handgun when he runs back to his vehicle. And when he comes out of that same vehicle after his exchange with Mr. Thompson, he now has an assault rifle. Now, James Denson, also identifying himself in the footage, does the same as Mr. Bedward and Mr. Bedward's brother, watching the vehicle. If you look very closely, you can actually see the vehicle turning right onto this roadway before it turns right again, coming back the opposite direction. Mr. Denson actually runs across the street, disappearing from view for 2 minutes before running back to join Mr. Hammond and Mr. Thompson at the cache of guns right behind the dumpster. And before they leave, in his excitement, he is sprinting to the back seat of that Chrysler 300. Everything starts out as normal until he joins all of the others. But Mr. Denson's role, at least preliminarily, is to stay across the street for an extra 2 minutes before he runs back over and gives updates. Just before the vehicles depart the gas station, Mr. Bedward enters the driver's side of his vehicle. Vehicle 1 leaves. Vehicle 2 leaving just behind them. And here comes James Denson. He doesn't want to miss out. Everyone's jumping, running to get to the cars because they don't want to be left out. Here is the exhibit that we've also admitted into evidence for you all, because I certainly understand, given the volume of evidence, how difficult it would have been to document each of the witnesses' statements regarding how far off the videos were from real time. So this is an exhibit that you will be able to have with you back in the jury room. It is a summary of the timestamps and their accuracy, fast, slow, etc. For purposes of this presentation I'm giving to you, I have adjusted the timestamps according to this summary I've provided to you to reflect exactly when we see the vehicles on the videos. Starting first with the victim's vehicle passing the chevron, which occurs at 9:03:26. The defendants are running in the top left corner to enter the vehicles to drive out after the victims. 9:03:48. Vehicle number 2 exits, 9:04. Vehicle number 3, 9:04:09. Now, the focus is vehicle number 1 and vehicle number 3. Because as you've heard testimony of, the state must have proof beyond a reasonable doubt in bringing charges. And at this time, there are not sufficient charges against the occupants of vehicle number 2. Because for us, we have evidence that vehicles number 1 and 3 discharged their firearms towards the victims. What that means, though, is you must consider the evidence of the crimes we have against these defendants. There is no law which indicates you don't have enough defendants. There were too many shooters. There was too much evidence of ballistics at the scene. You don't get away with murder because you had too many accomplices. There's no law which supports that these defendants would not be held responsible because everyone responsible was not also tried with them. Now, we know from the video surveillance that the defendants all leave the Chevron gas station with this red arrow in the center of your screen. They head up just past Power Electric Services, heading east on Hillsborough Avenue, and immediately make that U-turn. The first camera that we pick up is that Power Electric Service camera that gives us audio from both shooting vantage points. So you hear one round of shots, a break, you see vehicles number 2 and 3 passing, and you hear yet another round of shots. So I'm going to give you timestamps because when we play it all together for you out of context, it gets pretty convoluted. You don't know which videos are overlapping with which. But ultimately, from this diagram, the yellow spot is where the vehicle first stops and Willie Brown jumps out and runs north towards Mr. Coberly's residence, where we catch him on camera with all the cobwebs around it. You still hear ballistics. You still hear shots ringing out as he's running. You barely see him on the footage because he's a blip, he's running so fast, but that's the first stopping point for that vehicle. There goes the victim's vehicle, and vehicle number 1 just after it. Before vehicle numbers 2 or 3 at the Power Electric location. So we're looking at video from the location all the way to the right on your map, the red pin all the way to the right. Before vehicles number 2 or 3 even pass that camera, shots ring out from vehicle number 1. Vehicle number 2. And finally, the 300 vehicle number 3. So we first see on this vantage point the victim's vehicle at 9:04:27 p.m. It has driven past the Chevron coming east and made a U-turn and is now headed west back the other direction. 1 second later, we see Zavante Sampson's vehicle with Mr. Sampson as the driver passing this camera angle. Quandarius Hammond is the passenger of this vehicle, 1 second after the victims. Timing-wise, given they've made a U-turn from the location that's also depicted of the Chevron just up the road, there's no opportunity with a 1 second gap in the manner with which they caught up to have changed a thing. The defendants exit the gas station, and as Willie Brown testified, got right behind him before the U-turn. He did not think anything of it at that time. Zavante Sampson admits to being the driver of that vehicle, and Quandarius Hammond has given a version of events, which is that he was let out. You heard a jail call between he and his girlfriend, during which he's trying to convince her, essentially, to say she picked him up. And she says she can't. She already told the police. She's in St. Pete. You see, at the end of this frame, all the way down the roadway, the brake lights coming onto Zavante Sampson's vehicle as he's catching up with the victim's vehicle. The gunshots begin at 9:04:38. In lieu of leading you with the following vehicles after this, I'm going to keep you with vehicle number 1, driven by Zavante Sampson and occupied by Quandarius Hammond, at the next view of the camera. That's your first round of shots. They go off before vehicles number 2 and 3 enter the frame. And as a result of those shots at the exact same timestamp on the Lorenzo's garage video camera, you see the victim's vehicle coming to a halt. The screenshots from the Lorenzo's garage camera reveal at the same exact second that the shots start, according to the last video we saw from Power Electric. The victim's vehicle is coming to a stop in the far right lane, and the defendant's vehicle is shooting into it, consistent with the audio we hear from Power Electric. Michael Coberly's residence, before it actually depicts the victim, Willie Brown, running onto screen, also captures those shots. And at 9:04:38, you actually hear a gap in between the first round of shots and the second. And it's so hard to see, but as you take this video back with you, you can actually see Willie Brown sprinting to this door. We heard from Mr. Coberly, whose home this camera is attached to, that he ran to his house, that he said someone's trying to kill him. He's running house to house to try to get help. You heard from the law enforcement officer who made contact with him, who he said the exact same thing to. We know that the ballistics evidence from Mr. Kwong also indicates that group number 1, firearm number 1, is the only gun whose casings are between 45th, which is where Lorenzo's garage is. So a vehicle moving at any rate of speed, discharging a firearm out of the window, drops casings from 45th up to the marker of 12. The only gun with casings which are limited to the first half of the roadway All of the other guns go beyond 43rd Street. And we know from the DeLand trucking video that Zavante Sampson and Quandarius Hammond turn left onto 43rd Street. All of the other guns have a casings beyond 43rd. Gun number 1 belongs to Quandarius Hammond. Because when that vehicle turns onto 43rd Street, there's no other mechanism for shots to have been fired. In fact, the fact that the vehicle stops at Lorenzo's garage and the casings stop halfway down the roadway are indicative of the fact that Quandarius Hammond thought he was successful. The vehicle stopped. But unfortunately for Mary Bree Harrison, when she got into the driver's seat in an attempt to save her life and her child's life and stepped on the gas, the vehicle starts to move again and the shots also start back up. When you look at the key provided with all of the shots divided by color, again, those in red are limited to vehicle number 1. All of the other 2 vehicles pass 43rd Street. We know that the defendant, Zavante Sampson, turns left onto 43rd Street because the vehicle is tracked on DeLand trucking video, turning left onto 43rd, driving around another vehicle in the opposite lane of traffic, turning back left on Frierson again, and turning up 44th to make it back to the Chevron gas station. At the time they finished shooting, the vehicle was left at Lorenzo's garage and Miss Harrison's getting ready to jump into the driver's seat and drive it away. Power Electric Services, all the way to the right of the screen though, also captures a few seconds later vehicles 2 and 3 entering the frame. And vehicle 3, the Chrysler 300, is occupied by Jalen Bedward, Andrew Thompson, and James Denson. Andrew Thompson is your front seat passenger in the Chrysler 300, Jalen Bedward is your driver, and James Denson is the back seat passenger. That vehicle passes into the frame at 9:04:49 p.m. Here comes the Chrysler 300. And we have Bay City Cabinets footage, which also captures that second round of shots at 9:05:05, just across the street from those school buses. It's so very fast, but when you watch back at a slower speed, you see the victim's vehicle entering the frame. Here in the center, followed closely behind by vehicle 2, and then the Chrysler 300. So we did what we spoke about with many of our witnesses, which is slow down that video and try and watch it frame by frame. What happens when that Chrysler 300 actually passes through frame by frame? Victim, vehicle 2 on her left, and vehicle number 3, the Chrysler 300. We're looking now at the driver's side of the Chrysler 300, but even then we can see the power of that muzzle flash. Wasn't enough that the vehicle was already stopped the first time. It wasn't enough. They kept shooting at the vehicle. Looking now, 2 seconds later, at the auto upgrade, just across the street. So we've passed Bay City Cabinets. It took 2 seconds for that vehicle to discharge on this roadway and keep discharging until we intercept auto upgrade and Principal Auto Sales. The crash location, the pole with which Miss Harrison crashed into, is right here. We know auto upgrade doesn't capture the actual crash location, only the vehicle's approaching, but it does assist us because it actually captures 43rd. Then Principal Auto Sales has two views, one facing northeast and one facing northwest. For auto upgrade, 2 seconds after the Bay City Cabinets shots, we see the Chrysler 300 enter the frame again. On Principal Auto Sales, 1 second later, so just as the Chrysler 300 passes through that intersection as described for us by Detective Alverson, this is the same intersection as this, from the opposite side of the roadway. And there's the Chrysler 300 continuing to shoot into the vehicle. The victim's vehicle that is ready to crash into the pole, the victim's vehicle that ultimately does. More shots. From this angle, you see even after the vehicle has crashed into the pole, there are shots coming out of Jalen Bedward's vehicle. The vehicle in which James Denson and Andrew Thompson are also riding. The vehicle which we know James Denson doesn't have an assault rifle because he shot his own 9. The same one he pawned a month later for whatever reason. While the vehicle's crashing into a pole, vehicle number 1 is returning to the Chevron gas station because you can't leave your bag of guns at the gas station. You have to go back and pick them up. So Zavante Sampson returns with Quandarius Hammond, Their windows are down, they're talking, they're hanging out. They arrive back. You have the videos where their vehicle's returning to the Chevron. Quandarius Hammond, his specific video, we've already seen, has him going behind the dumpster and then walking back to the houses in the back to meet back up with Mr. Sampson. Impossible that they would have shot rounds other than the red grouping number 1 because they turned left onto 43rd. We see those screen grabs from after 43rd where the vehicle crashes into the pole, which is again the black, either rectangle or the rectangle with a triangle on top, whatever it is, but the circular area never changes across any of these scene diagrams. The only vehicles that passed the victim crashed there in that vehicle. The only vehicles that passed 43rd are those occupied in vehicle 2 and Jalen Bedward's vehicle with Mr. Denson and Mr. Thompson inside. These are the charges that you will all be asked to make a decision as to the guilt of these defendants. The state has proved that the defendants acted with a premeditated design in the killing of Suni Bell and attempted to murder Ms. Harrison and Mr. Brown when they shot into that vehicle. They're all charged in count 4 with conspiracy to commit murder. That means they all came together, combined, confederated, conspired. They all came together in some way, by word, by act, with the same goal in mind, which was shoot as many times as humanly possible into this silver infinity. The judge will instruct you, you're permitted to use your common sense. 40 shell casings collected, at least that many rounds going off into the same target vehicle. They're also charged as principals to shooting at, within, or into a vehicle. You have to determine whether they acted together to commit what was the ultimate goal, shooting into this car. And lastly, discharge of a firearm from a vehicle. Only the person that has been charged with actually pulling the trigger or pulling a trigger has counts of discharge of a firearm from a vehicle. So we'll go through those so that it makes more sense as to who is charged with what. All of the defendants are charged with first-degree premeditated murder. You say to yourself, how, when there's nothing, no evidence to support that they even knew Suni Bell or Mr. Brown or Miss Harrison, none. How are they charged with premeditated murder of someone they don't know? Unlike what we might see on Dateline or, the news stories that are really, really salacious. Your typical murder doesn't occur by sitting down at the dining room table and writing out a contract to do it. That's not what's required by premeditation. That's not what's required by the law. You don't even need to know the victim's identity. Remember, Mr. Terry spoke about what happens in a mass shooting, for example. You're in the car and you make sure you have all the weapons and you're going to go into a mall. You don't know the name or identity of your victims, but you planned to do an action. You had an forethought to commit the act that you committed. Each of the defendants, by act, by word, in that parking lot, acted in a manner consistent with them all being on the same page. Principles by act, conspiracies by act. You don't need to know what they said to know they had a common scheme or plan to commit this crime. It's not, did they plan to kill a 4-year-old child? It is, did they plan to open fire on a vehicle in the middle of the road over and over and over and over again?
Overruled.
And each of these 5 defendants achieved that goal, regardless of whether they pulled the trigger. I will give you specific examples because only Mr. Hammond, Thompson, and Denson have firearm discharge language, and actually no one is charged with shooting the bullet that actually killed Suni Bell. Because with a through-and-through wound, it's impossible to tell whose bullet did it. But it would not have been accomplished without the actions of every single person depicted here. In count 1, these are what your instructions will have. Suni Bell is deceased. That death was caused by the criminal act of the defendants, and there was a defendant or defendants, and there was a premeditated killing of Suni Bell. So we saw an instruction from Ms. Bradley about multiple defendants and considering them independently. You do need to look to each defendant to say what is the evidence against this person. But you have the benefit of having a principal instruction that you carry with you through all of your counts, right? So this is a charge, premeditated murder. Principal to a crime is an instruction that you are given based on the facts that you look to say, if this person didn't pull a trigger, did this person aid, assist in this goal being accomplished? You'll have instructions on premeditation, and you'll have to consider what was the conscious intent of the defendants as they gathered, as they prepared in that parking lot. The court will give you a significant amount of instructions. You will also have a paper copy of those to refer back to because there's a lot of legal language included therein. But this principal instruction, did the defendant intend for the crime to occur? Did the defendant do some act, say something that intended to help the others? Encourage them, aid them in committing this crime. They don't need to know, in being a principal to a murder with a firearm, whether any of their other defendants were armed. In this case, they're all in the parking lot with several individuals running around with assault rifles and handguns. I do not assert to you that they didn't know that, but that's not even what's required. Was the common goal to go after these victims, after this vehicle, that of which the defendants had? before they started shooting. You'll have specific instructions as it relates to principal to murder as well. So principal is just the instruction you carry with you through the charges, and there are specifics as to the murder itself. This is what the verdict form that you will receive from the court will look like as to each one of the defendants. So you will have a section which indicates count 1, murder in the first degree. And as to each of the defendants, you will have to make a finding. We've charged 3 total defendants with the possession of a firearm during the commission of this crime and the discharge of a firearm during the commission of this crime. No one is charged with shooting the bullet that actually killed Suni Bell, causing her death, because it was a through and through wound. So your findings must be, or are limited to, did Quandarius Hammond, did Anthony Thompson, and did James Denson, under these instructions, actually carry, display, use, threaten, or attempt to use a firearm? It seems duplicative, but did he actually possess a firearm? And during the commission of this offense, did he discharge his firearm? When we talk specifically as to whether the defendants have this firearm discharge language, you will see this type of wording underneath, for example, count 1 as to Quandarius Hammond, the passenger of the vehicle number 1 driven by Zavante Sampson. Did he have a firearm? Did he discharge the firearm? When it relates to the remaining defendants not charged with actual possession of a firearm during the commission of the offense, so Zavante Sampson, the driver of vehicle number 1, he doesn't have those special findings underneath his counts because he hasn't been charged by information with possessing a firearm during the commission of the murder. He's charged as a principal, as an aider to ensuring it happened, as the driver during the course of the murder, as encouraging the other defendants, telling them before they jump into the vehicles and chase after the victim's car that's just passed by the chevron. He doesn't have special findings, but he has the same result. He's guilty of murder just as are his co-defendants. We talked about motive versus intent. Motive is not what needs to be established. There are counts for which the intent of the defendants needs to be established. In principles to a crime, did the defendant help another person?
Somebody shot at me, somebody shot me.
Take him.
Somebody shot at me and somebody shot me. It's simple as that. Oh, she picked this thing past me. Somebody knew that shit gonna happen, somebody shot. I feel sorry for that little girl, but somebody shot her. It's the truth. Y'all can be quiet.
All right, ladies and gentlemen, the court's going to take about a 10-minute recess while we take care of some obvious issues. We'll be back when we can.
All rise for the jurors.
Do you need to step up for a minute? I'm sorry? Well, I was going to talk to you folks about some remedies. You know, so Mr. Sampson, my understanding is you don't want to be here anymore? You don't want to participate in this trial? You know, you have a right to be here and go through the whole thing, and I would prefer you did that, and I'm sure your attorney would. But if you don't want to, we're going to put you in a holding cell, and we're going to set up a TV out there so you can watch if you want. You understand that? But if you're going to stay in here, you can't be doing what you did. And if you did it, and if I did allow you to stay, and you did it again, then I would have you exit it again and not allow you to come back. You'd have to watch it on TV. But if you don't want to come back right now, that's fine. They're setting up the TV right now as we speak. Is that what you want to do? That's a yes?
Yes, sir.
All right.
Judge, can I put some things on the
Yes,
record,
sir.
please? I had an opportunity to speak with Mr. Sampson and certainly underscored, his due process rights during the course of a proceeding and a trial, certainly one so meaningful. I expressed my desire to have him join us for the rest of the process, understanding that he would keep his emotions intact. He has indicated to me that he does not want to return. I certainly do not think that that's in his best interest, but in the same respect, if his emotions are going to get the best of him, that certainly is not in his best interest as well.
I understand.
He did also...
It's not gonna get the best, I'm just tired
You're just tired?
I won't clear out no more, but I'm tired.
Judge, I guess what Mr. Sampson is saying is just he's weary and tired of the process, and he doesn't want to be present.
I understand. All right. Well, we'll accommodate him by putting that TV up for you so you can watch it if you want. You don't have to watch it if you don't want. Thank you, sir. So, one of two things. One, I can just tell the bailiff to tell the jury that we're going to be in recess for an hour, or I can bring them in and I can put it on the record.
The court's preference, I actually didn't realize we weren't on the record.
No, I sent them out for like a 10-minute break to see what we were going to do, and it's going to take an hour to set that TV up.
Oh.
So, and they're starting it already, so.
Judge, the state is, I understand the court's ruling is not going to allow us to open and introduce this as convictions. However, I would request a curative instruction.
All right, so I'm going to bring them in, give them a curative instruction, and then release them till, then it's lunchtime.
Can we discuss what the curative instruction will be?
Well, we'll get to that, for sure. But, so then, why don't I just tell them to come back at 1:15?
From right now, Your Honor?
Right, I mean, because if they come back in an hour, and that's if they get it done right on an hour, it's noon. And then you still have some work to do on your closing.
Yes.
So why don't we just tell them to come back at 1:15?
I'd like them to have a curative instruction before taking a significant.
We are going to do that. So, well, we're going to let them break to 1:15, but before we do that, I'm going to give them a curative instruction that they're not to listen to what the defendant said. What he said is not evidence. You should not consider as any evidence. And what else can I tell them?
That the defendant has elected to abstain from attending the rest of the trial.
I can say that.
At this point, it's an abstention.
And Judge,
At his choice.
that there is no evidence of self-defense and that they will not be receiving any sort of instruction on self-defense whatsoever. Because he's basically was screaming out that he was being shot at and they were just shooting back. There is no evidence of self-defense. There's no evidence of that.
You can make that argument in closing. I'm just going to tell them that what he says is absolutely not evidence and not to be considered as any evidence of such. It's just, and that he has elected to absence himself from the remainder of these proceedings. Anything else?
Judge.
No, I'm not bringing them back in. My mind's not going to change. Yep, so we'll do that. Yes, ma'am?
Can I just address one matter on behalf of Mr. Hammond? We would, based on Mr. Sampson's actions and him absenting himself and his outburst in court, we would move for a mistrial. This is a case where we did move to sever all the defendant or ourselves from the other defendants in this case. specifically Mr. Sampson, and the court denied it. That was Judge Rice who did that. Based on this, the events that happened and the fact that Mr. Hammond is alleged to have been in the car with Mr. Sampson, and anything negative that might be associated with Mr. Sampson would then get also associated with Mr. Hammond based on the association in this case. We would move for a mistrial.
All right.
Your Honor, on behalf of Andrew Johnson, we'd also move for mistrial.
Same with, I would also join in, Your Honor, on behalf of Jan and Denver.
I understand. I'm going to deny that request for each defendant, the request for a mistrial. There's a jury instruction in here that I'm going to be reading, the jury word that talks about, if you find one person guilty, you have to find them guilty, and you have to decide for each one individually. And I think that,
Which is the instruction that's already in the packet.
right, so, and they'll be reminded of that. So I'll deny the request for mistrials.
Thank you.
Anything else? All right, I'm going to bring the jury back in, give them the curative instruction, and dismiss them to 115. Whenever they're ready. And I want to caution the other folks, you all have been conducting yourselves like gentlemen during this time. I hope that continues. Otherwise, as you see, it's not going to result in anything except you making a fool out of yourself in front of the jury and having to sit in a holding cell and watching the rest on TV and not participating in your defense, which I think is very important that you continue to work with your attorneys as you have been. And I thank you for your conduct up to this point, and I hope it continues.
So 115.
115. Well, actually, since they're going out, I'll just say 1 o'clock. That way everything will be done.
All rise. Jurors are entering.
Jury's back, y'all may be seated. Welcome back, ladies and gentlemen. I take it there were no issues with the court's instructions. All right, ladies and gentlemen, Mr. Sampson has chosen to absent himself from the rest of this proceeding, so we will continue in his absence, and there are some matters that we need to arrange for that to be done. That'll take about an hour. So I'm going to release you until 1 o'clock so you can have lunch. But before you go, I want to tell you to disregard everything that he said during that outburst in court. Nothing that he said is evidence, and you are absolutely not to consider it as any sort of evidence whatsoever. All right? Having said that, I will now dismiss you until 1 o'clock. Thank you.
All rise. Jurors are exiting.
Court will be in recess till 1 o'clock. Those left, y'all may be seated or enjoy your break.
January 19th date that you gave. So she said we can do the 20th.
See? You have one opportunity.
Is this what you're looking for?
All right, so we're still in verdict watch here, you guys. Still in verdict watch. 13 and a half hours. Now, I kept it, actually, I stopped it when the jury came back in to read the questions. I stopped it, and I checked over on another channel, and they still have it going, but there's like a 6-minute difference or so, so I'm going to keep it going. Well, actually, no, I'm sorry, I stopped it. So there's a little discrepancy, but it's only like 6 or 7 minutes. So still 13 and a half hours. That's a long time. Now we're getting into that point of like, wow, are they trying? Well, we go back to their questions, and I'm paraphrasing, but I think I got the gist of it pretty well. Question number 1: on each count, does it have to be unanimous? Example: if 11 agree and 1 doesn't. So again, we're trying to read the tea leaves here. We're trying to figure out what are they trying to trying to interpret what they're saying. So on each count, does it have to be unanimous? That's pretty obvious. But example, if 11 agree and 1 doesn't. So that's kind of interesting. Then question 2 was, if half are saying guilty on one count and half are saying not guilty, will that be a mistrial on that charge or the entire case? So to me, that's pretty telling, right? I think that one's pretty telling. Jennifer's asking, how long was the Ollie deliberation? Let me look that one up. Let's see. Where's Ollie? That's Dominguez. Hold on. Raul's was pretty long. Raul Valle, I'm looking back, he was 6.5 hours on day 12. I'm sorry, day 11. Almost 6 hours on day 11. Day 12 was 6.5 hours, and day 13, 4.5. So that's 10, 11... 16, almost 17 hours. So Raul Valle went almost 17 hours. Ali was, I don't have it written down. Let me see if I can find how long was Ali. See if I can find that. More than 19 hours over 3 days. So over 19 hours over 3 days. Really? I'm just trying to get my book. Why? I'm just trying to get my notebook, dude. Settle down. So over 19 hours, for more than 19 hours over 3 days. Why? So, and Raul, what did I just say? Raul was like 17 hours. So 13 hours, 13 and a half hours. It's, it's a long time, but it's not, it's only been 2 days too. So, yes, meow. I was trying to get my notebook. She's sitting right here, so my notebook was right there. She was sitting on it, and I was trying to get it. And she gave me what for. She gave me what for. Too many charges to go over. Ellen could have sworn it was 4 days. Let's see. No, I have it the 29th, 30th, and 31st. Those are my notes. Verdict watch. Oh, I guess day 9. Okay. I guess if you go with day 9, Ellen, see day 9. I'm sorry, see day 9. So day 9, I guess they started, but it was only 15 minutes. And then day 10, 11, and 12. So I guess if you want to count day 9 with closings and then they went to verdict, I guess you could say it was 4 days. So, and then Raul was day 11, 12, and 13. So yeah, Ellen, yeah, it was, yeah. So it was 4 days, but that first day was only 15 minutes. I guess that's why AI didn't include it, because it was only 15 minutes. And Carlos Dominguez, let's not forget Carlos Dominguez. That was like, whew, that was epic. Carlos Dominguez, they deliberated for like months. Hold on a sec. Carlos was crazy. Carlos was like day 23 to day 26. I think we stopped posting. We even just stopped. I think it was like over 18 days or something like that. Finally, okay. On the 6th, they started to deliberate. It's the 27th, they finally came to a verdict, and they were hung. So Carlos Dominguez, yeah, that took a long time too. All right. I don't like that my notes are out of order. Oh, Karina Cooper, you guys remember her. Cindy, thank you for reminding me. She was supposed to be sentenced on the 5th. It got pushed to the 19th. So we have a Karina Cooper sentencing to watch as well. That's coming up the 19th. All right. Let's get back to closing arguments. Zavante just got let out. He's was told that he cannot participate anymore. He's going to have to watch from the sidelines. Whew.
Not there. There's been no evidence that there was any shooting coming from the vehicle driven by Willie Brown. There's been no testimony from anyone that there has. The only people that are talking about what happened there was Willie Brown and Mary, and neither one of them indicated anyone had a gun in their car. So there's absolutely zero evidence to show anyone from that vehicle shot at any time. And if they suggest that or argue that, we are going to be objecting, because there is no evidence to support that whatsoever.
Judge, let's just hash it out right now.
Right.
There's picture and evidence with Willie Brown holding an object in his hand. There's a 45th Street Coverly video where it appears that Willie Brown has something in his hand. The state introduced a couple of photographs of something on Willie Brown's wrist. Okay, the fact that Mr. Sampson had an outburst.
What, like a wristwatch?
Yes.
It's an Apple.
An Apple Watch.
Okay.
So the point being is that my argument doesn't need to be buttressed on self-defense. Okay. First of all, my client was the driver of this car. I don't even know if he'd have standing for self-defense, but that's not the point. There's no instruction for self-defense. I'm not suggesting there was self-defense. I'm suggesting that the evidence and the jury can consider whatever it is that is in Mr. Brown's hand. And if the state wants to argue it, and the state...
I don't know how you talk about what's in his hand without any evidence that it was any self-defense.
Judge, I'm not suggesting it's self-defense. I'm suggesting that the jury can make a determination based on what's in evidence. The videos and the picture that's in evidence, okay?
Well, what are you going to argue that it is?
I'm going to argue that it's up to them to determine what it is.
Are you going to make any suggestions to what it is?
No, I'm not going to.
Okay.
I'm going to argue that the law enforcement did a search out there on one small area of a backyard of a single residence on 45th Street without doing a complete and total search.
But if he had shot his firearm in the area where he was running through the homes, it would have showed up audibly on the sound.
No, Judge, we're not talking, first of all, there was audible.
I'm not going to allow any arguments about self-defense. Then what are we arguing about?
I'm not arguing about self-defense.
Okay.
I'm asking the jury to make a determination as to what they believe and what they think could be in Willie Brown's hands.
And what would that matter? What's the relevance of that?
The relevance is because we don't know what occurred. We don't know whether or not.
And you want them to infer that all these guys shot all these guns at this moving car in self-defense?
You're missing the point, Judge.
I might
All
be,
these
so
guys-
enlighten me, because
all
I don't
these-
want the jury to be misled, so I need you to enlighten me.
Judge, the fact that all of these guys allegedly shot guns is not the basis for allowing the jury. Why can't the jury believe, or why can't the jury determine whether or not something caused those gunshots, the first set of gunshots, to be?
Because there's no evidence that anything caused those gunshots.
He's got something in his hand.
That's
when
not
he leaves
evidence.
the car.
What you say is not evidence.
Judge, it's in evidence.
Let me see it.
It's in evidence without objection.
There's no instruction for what's the end goal.
You're going to say there's something in his hand? I can't even see a human being in that circle.
Well, Judge, it's not for you to decide what is in his hand. It's the jury to
It's not for
decide.
you to decide what's in his hand.
It's in evidence.
There's
Judge.
nothing in his hand that I can see.
Well, Judge.
I don't see anything in his hand.
Judge, you're not the trier of fact.
I have to control what's admissible and what's not admissible as far as what probative versus prejudicial.
Judge, that should have been an
And you
argument.
can't argue anything.
That should have been an argument made before the entrance.
Did you argue it during your case in chief?
I'm sorry, Judge?
Did you argue that he was holding something in his hand during the trial?
Judge, I didn't put on a defense.
Well, then, I know, so now you can't bring up, there's no evidence for them to consider, because what you say is not evidence. And that's not evidence of anything.
Judge, the court cannot make a decision what is evidence. The jury can look at this, and the jury can say, I don't see anything.
What if you said, look, there's a flying saucer in there, ladies and gentlemen? There's no flying saucer in
This
this video.
is a flying saucer. Then the jury would have to determine if it's a flying
No, I
saucer.
wouldn't allow you to say, make things up.
Judge, I'm not making it up. It's here.
There's nothing
You can
there.
see it.
I can't see it. Does anybody else see it? Mr. Terry, what do you see in
Well,
that
I
picture?
don't know, Mr. Terry allowed it in without objection.
It's evidence of other things, not of anything in Willie Brown's hand.
Mr. Terry,
You're not bringing that
Judge,
up.
Mr. Terry entered into evidence pictures of Mr. Brown.
You can't fabricate in your own imagination what you believe those pictures depict.
Judge,
You could tell the jury, look at this picture and decide, but you can't suggest to them that he's holding something in his hand when I can't even see if there's a human being in that circle.
Judge, is the court telling me you can't tell there's a human being in that circle?
To me, it looks like a picture of Bigfoot.
Judge,
You ever seen
they
that on the
have-
internet?
they have
That's a
already-
Bigfoot representation.
They have already argued that this is Willie Brown running from the car.
All right, but I don't see anything,
so-
you see a shape of somebody running from the car.
Yes, Judge. I
Now,
see a
what's in his
person
hand?
there. And the state argued it was a person.
Okay.
They showed a video.
Well, then that's in evidence, and whether, but there's nothing in his hand. Was anything argued that it was in his hand?
Yes, Judge.
Let me see
It's in
it.
evidence.
Again, let me see it.
And it's, I don't believe it's the court's venue to decide what's in his hand. That's the jury's ability to make those determinations. It's in evidence. So you're going to send it back now, and you're going to have them have this picture and say, what's this picture in evidence for? If the state didn't believe it was worthy of argument, they wouldn't have put a picture of Willie Brown.
Fleeing from a car that was being shot at?
No, Judge, a picture of Willie Brown with an Apple Watch on his wrist to suggest that that is what the object is that is shining. They put their own version of this in, anticipating that they were going to argue it.
Did somebody mention an Apple Watch during the case?
Yes.
And just that we had on an Apple Watch?
Yes, sir.
Okay. So that's a better picture of him running from the car? Is that
No,
before
Judge,
it?
this is when he's on Coverly, when he's with
Looking
law
for the,
enforcement.
right.
Okay, which, by the way, if you look at the Coverly video, you will see the same circumstance when he's running across the street. You will see a silver thing near his arm. I think we're invading the province of the jury to determine what.
I think
is
we're going
evidence.
down some dark rabbit hole that invades no one's province.
Judge, it's in evidence. It's in evidence. It's been
This
admitted.
picture's in evidence. Are you going, you could argue that he had an accomplice hiding in this car, ladies and gentlemen.
No,
If
Judge.
you look really close, that looks like there's a person in this car.
No, Judge, this
So
is.
why couldn't you argue that?
The court-
Just as caveatly, why couldn't you just argue that?
Judge, the court indicated that you couldn't even tell if there was a person here.
I can't really tell if there's a
The
person here.
state's already submitted.
Because
that
it looks better on the videotape than it does on that picture.
The state's already admitted that this is Willie Brown running.
Could you argue that he had an AR-15 strapped to his back too?
When we.
I'm asking you a question. Could you?
Could I argue that?
Yes.
No, I wouldn't attempt to argue that.
Okay, but you're
But
gonna,
I would argue that there's a silver object or a white object in his hand.
okay. State?
Again, Judge, especially in light of the testimony from Mr. Sampson, I think that can mislead the jury. There's no evidence as to what that is. It just as easily, that's the difference, so it could just as easily be an Apple Watch.
Then have him argue
reflection.
that.
But in light of that, what Mr. Sampson just did, in light of the fact that self-defense is not a defense in this case, is not being argued as a defense in this case, there wouldn't be any relevance to it whatsoever.
Let me see that picture.
Self-defense does not play a part here, Judge. It is what happened. Okay? It's in evidence. The court can't make a determination as to what the picture shows.
Reiterate exactly what your argument in closing will be. You said you wanted to hash it out. What is it?
Judge, the jury's allowed to make reasonable inferences.
Reasonable inferences.
That is a still picture of a video that is in evidence.
Right.
Okay? And there is also another video in evidence on 45th Street near Mr. Coverly's house.
Right.
Both would indicate that the jury could make a determination as to whether or not there is something in Mr. Brown's hand, and could that something be a weapon? That's their province. If they want to reject that idea, if they want to determine that that's not what that picture shows, or that couldn't possibly be the circumstance, they can choose to do that. It is a picture that's already in evidence without objection. It's a
As you said in your first sentence, it has to be reasonable.
Judge, it's a reasonable inference to look at that picture and look at the video that's already in evidence, okay? And determine whether or not there is some object in Willie Brown's hand and whether it could be a weapon. They have that right.
But there's been no, why would it be relevant if there's no claims of self-defense?
Because Mr. Hammond doesn't have to make a self-defense claim. He's not charged with shooting out of the passenger seat. This is what it is. He is the driver here.
Right.
He speeds away. He goes up to the car. He doesn't discharge a gun. The state certainly is operating under a principles theory here, which the jury also has to determine and make a finding.
I understand that. Let's not get on that part. Let's just talk about this.
So my point, Judge, is that I don't believe anything in the law requires me to make a self-defense argument. I think that is misplaced. I think the jury, in a piece of evidence...
If you're arguing that he had a gun in his hand, he being the person that was in the car when they were shooting it up, why would you bring up the fact that he had a gun in his hand if you didn't want the jury to think that your clients were acting in self-defense?
I believe... well, it's not my client. My client wasn't acting in
Well, as a
self-defense.
principal.
My client happened to be the driver of the car.
How about as a principal?
So the purpose here is to allow the jury to have the full view of what the evidence is. And the evidence that has been accepted, the evidence that has been admitted, okay, part and parcel is that picture, that still picture.
If you want to make that argument, go ahead. Go right ahead. You can argue that that is a gun, if you want.
That is defense exhibit number 1.
Has it been admitted?
It has.
Okay, yeah. Anything else along those lines, or before we move on to any other new lines? No? All right. Bring in the jury.
All rise for the jurors.
Jury's back, y'all may be seated. Welcome back, ladies and gentlemen. Once again, no issues with the court instructions, I take it. All right, very good. Is this, you may begin. Or, excuse me, you pick up where you left off.
Thank you, Your Honor. Welcome back. I hope you enjoyed your lunch. Very, very briefly, I want to go over this process itself. When you all came for jury selection, we didn't talk a lot about the facts, if at all, of the case. Just told you what the charges were. We didn't go into specifics. We didn't dig into anything, or at least tell you what you were going to see. When you came and you were selected and listened to opening statements on the case, you got essentially a preview or an overview of what we expected the evidence would show to you. But at that point, you come and you see it, and you're not familiar with the facts. You haven't lived with the case up to that point. So then we put on evidence, which is bring in witnesses that legally we are required to bring in to testify, because testimony is considered evidence, or to introduce physical items of evidence, etc. And during that process, it can feel probably overwhelming in that we are just putting exhibits into evidence and maybe they don't come together to make sense. These closing arguments are our opportunity to tell everyone what the state's case and what we've established by introducing all of that evidence to you is. It's our first opportunity to put up the actual evidence, although it's come in droves through different witnesses and, different crime scene techs or different detectives and things like that. And it may not make sense because it doesn't always come in the chronological order in which it happened or in which it was collected. So this is the first time we're putting everything together for you. That means it's the first time we're actually presenting the videos to you to establish that vehicle 1 is 1 second behind the victim's vehicle before those gunshots ring out. It's the first time that we're showing you the videos back to back, which establish before vehicles 2 or 3 even get there. Vehicle 1 with Zavante Sampson and Quandarius Hammond has already opened fire on the victims. It's the first time for us to put that to you. It is a lot of evidence and can be overwhelming to see and experience all of that. But as we go through these jury instructions, it's important for each of you to note, Florida law allows for a self-defense instruction if appropriate. That means, by law, if there's a scintilla of evidence to support such, that would be provided to you in the packet of jury instructions that we're going to read here in a bit, that are very, very long, and it's a lot of legalese, but it's essentially your definitions, what we were going over before we took a break. You will not receive a self-defense instruction in this case for your consideration. Self-defense is not an issue that has been presented to you, and self-defense is not supported by the evidence of this case. There is a lot of evidence that has been provided to you, but self-defense has not become an issue because there is no evidence to support you all receiving that instruction. What there is evidence of is these defendants hunting down the victims and opening fire onto their vehicle. It is on video. It happens seconds apart. It happens over and over again. First with vehicle number 1, and again with vehicles number 2 and 3 after they realize that vehicle isn't stopped for good in front of Lorenzo's garage. That vehicle starts to move again. And it's at that exact moment that, absolutely captured on video, is vehicle number 3 firing into the vehicle now occupied only by Mary Harrison and Suni Bell before it crashes into that pole. There is no evidence that anything else other than that occurred. And we are in a position where we are able to provide to you video surveillance evidence. That's not always the case. So you all will have that video evidence, you all will have the events which have occurred, and you all will be able to see for yourselves through the evidence when you go back. Second by second is accounted for the victims and for the defendants. In fact, you have videos that overlap with each other to ensure you have captured what happens between the defendants and the victims. And the facts are the facts. The victims do not know these people. And the defendants made a choice to excitedly jump into their vehicles armed and gun them down. So the court will give you jury instructions here after the close of all of the closing statements. So where we left off was talking about the principal instruction, because there is no requirement that we establish who's shot a gun and struck Suni Bell, killing her. But this principles to a crime instruction is the instruction that you bring with you. It's the one thing that you take when you look at every single count that you have to consider in this case against the defendants. So when you look at first-degree murder, you say, is the defendant guilty with the elements that I see? Now, considering the principal instruction, is the defendant guilty as a principal for having intended to do the criminal act, shooting into a vehicle? Understanding the potential outcome of shooting into a vehicle, which is the death or expected death of the persons therein. So principle is an instruction that you carry with you. The reason that that's different, did they do or say something to encourage the others? You have the videos as to each defendant, waving each other on, gearing up, using the same bag of guns, jumping into the same vehicles, targeting the same victim. Did they do something to encourage or assist or advise, whether they pulled the trigger directly or drove the persons pulling the trigger? That differs from conspiracy, which we'll see here just in a few minutes. But let's go in order of the counts that you have to consider beyond what we've looked at, which was first-degree premeditated murder on Suni Bell. All of the defendants are charged as principals in the attempted murder of Mary Harrison. She's the passenger of the victim's vehicle. She's the victim's mother at the time that the defendants start following their car. Once Mr. Brown is able to escape the vehicle in front of Lorenzo's garage, she jumps over into the driver's seat. So on the Lorenzo's garage video, you see this pause. And if you're asking what's happening, the vehicle you'll see just at the edge of the video starts to move again. Well, when we pick that vehicle up on the subsequent videos, just across the street from that, it kind of takes off and jumps on the curb and runs into a pole. The attempted premeditated murder of Mrs. Harrison means that did the defendants again intend to or plan to shoot into this vehicle? Were they acting in an organized manner? Did they accomplish the goal that they sought out to do? Why Zavante Sampson and Quandarius Hammond are also charged with the attempted murder of Miss Harrison, even though they are driving off by the time that she subsequently drives away, is twofold. Number one, when they first begin shooting into that vehicle, it's occupied. Mr. Brown is driving and she's in the passenger seat with Suni in the back. At that point, with that first round of shots, there's an attempted murder of Miss Harrison. But also consider, when you're looking at these facts in the principal instruction, without the actions of Quandarius Hammond repeatedly shooting out of the passenger seat to stop the vehicle in front of Lorenzo's garage before Willie gets out, the others aren't caught up. The reason they're stopped there before she has to jump into the driver's seat, before the second rounds of shots keep going again because now the vehicle's moving again, they're not dead inside. They have disabled it in this location. Vehicles 2 and 3 are then able to catch up to vehicle 1. There is an audible gap when you listen to the audio. First round of shots with vehicle 1 right by the victim's car. Gap. Second rounds of shots. Shots that are fired when Willie's already running down near Coberly's residence. They start the ball rolling. They are the first domino, essentially, to fall, which puts our victims in a vulnerable position of being stopped in a car, Ms. Harrison having to jump into the driver's seat and attempt to drive again. But unfortunately, as soon as that vehicle starts moving, as soon as there's a realization that it's going again, it's not stopped, it's not over, the second rounds of shots start up again. You saw the crime scene photos of their vehicle. There are dozens of shots more into the victim's vehicle. I won't ask you to be an expert as you look at those photos, but I will ask you to look at the impacts from the ballistics evidence in that car. There's no evidence of casings in that car or that there was any kind of violence or anything from anyone inside that vehicle. There's no evidence other than that these 5 people came together to attempt to kill the passenger, the driver, and did actually kill the child in the back seat. The third count that you have to consider is going to be the premeditated murder of Willie Brown. You may ask yourself, why in this instance are we looking only at Wandarius Hammond and Zavante Sampson for purposes of this charge? Why isn't this also a principle? The attempted murder of Willie Brown occurs, as we can see from the video footage, before the other 2 vehicles arrive. So while maybe they intended to catch up and also engage with Mr. Brown, he has escaped the vehicle before vehicles 2 and 3 arrive. The only persons that we would charge or could charge with his attempted murder are the individuals who directly can be linked to that shooting. Once he runs from the vehicle, there's no way for us to say beyond a reasonable doubt that the other shots were directed at Mr. Brown only. We present to you we present to you facts which can support the state's position of what the defendants are guilty of. They took fire or fired down on that vehicle alone, vehicle number 1. They started out by themselves. So the attempted murder for Willie Brown, as it relates to that vehicle before the other vehicles caught up, are only as to these 2 defendants. When you look at the verdict form, you'll just see options for these 2 defendants on this count, because by the time Willie is running away, the other 2 vehicles are catching up to Mary and Suni Bell. That's why the occupants in everyone's vehicle are responsible for what happens after Miss Harrison takes off. Looking back to count 4, again in conspiracy, everyone's charged. So when we talk principle, that's the overarching instruction that you get to take with you and you look at all of the others. Look at the elements and say, does this apply as we're reading it, and then does this apply when we add principle? Conspiracy to commit murder is its own charge. The language within the conspiracy count is different. So you'll look at, did they confederate, did they combine, did they work together essentially in committing these acts? Now the conspiracy itself is not the physical act of what you're doing, right? It is the portion of talking about, acting in a manner consistent with, it is conspiring to commit that crime. So when you're looking at this count of count 4, conspiracy to commit murder, you actually are looking at, did they conspire to commit the driver of that vehicle? Did they conspire to commit murder of everyone inside the car? Was it just as to Mr. Brown? Was it just as to Miss Harrison? Was it to everyone? So you'll have an and or option when you look at that, right? You ask yourself, they don't know each other. So is there a conspiracy to commit murder against whomever the person is that's driving the vehicle? But for this, you are able to consider each of the victims. Was there a conspiracy to commit murder, on an occupant of that vehicle? When we talk about conspiracy, the court's going to give you the same instructions that you'll see here. So the language is a little bit different for conspiracy because it's an actual count. Did they conspire or agree or combine amongst themselves or other diverse persons? That's what we were talking about just a little while ago when I'm asking that you consider the evidence against the defendants here before you. It's not necessary that we too present every other person from the gas station, for example. But it could be amongst themselves. It could be that 2 of them have more knowledge about what's going to happen, but that a third has agreed. It could be any combination of the defendants. But did, overall, some or all of the defendants agree to what would occur? That's why when you're saying, let's look individually at each of the defendants, you say, was this an agreement between the 2? Was this an act that was committed by a combined group of individuals? When you're looking at each of the defendants, you have to say, did they play a role in this conspiracy? And I assert to you that they each played a role, particularly when you look at the video directed specifically as it relates to each defendant. Looking at shooting at, within, or into a vehicle, this is a count for which we're asking you to bring the principal instruction along with you. We're not asserting to you specifically that all of the defendants discharged firearms from their vehicle, but whether they acted together to accomplish the shooting at, within, or into a vehicle as a group. These are the instructions that you'll be provided, again, as it relates to each of the defendants in determining whether they acted at, shooting at, or within, or into a vehicle, or whether they acted as a principal to the same charge. The court, again, will read all of these to you, so I don't want to spend too much time going through or reading them to you, but essentially we're asking that you apply the principle specifically as it relates to this shooting at, or within, or into a vehicle charge as well. And lastly, count 6. This charge is unique in that it only is applicable to those who did discharge a firearm. So we're not asking you to bring in or take with you the principal instruction as it relates to Mr. Hammond, Mr. Thompson, and Mr. Denson, the 3 that have that firearms discharge language on their verdict form, because each of them have some piece of evidence supporting the fact that they did actually discharge a firearm from those moving vehicles as they attempted to gun down the victims in this case. Very briefly, I will go through these lesser included offenses. You will receive in your packet what is essentially the primary charge. So take first degree murder, for example. You will receive instructions on what are called lesser included offenses. So when the court's instructing you on these are the instructions, these are the definitions for the charges that you will receive, you'll be sent back and start your deliberations. You could be in this stronghold with someone else who absolutely agrees that we have met all of the elements as it relates to second degree murder in lieu of premeditated first degree murder. So say you're split in that. The court's instruction to you will be that you must return a verdict for the highest count that you all agree on. So if you all agree as it relates to second degree murder, even if several of you indicate that you believe it is in fact first degree murder, there was a sufficient time for that premeditation, then it has to be a returned verdict for the highest count that you all agree to. It has to be a unanimous verdict as to the count that you believe was satisfied. Specifically about second degree murder, you will be instructed that the victim has died. You will be instructed that that death was caused by the criminal act of a defendant or these defendants acting together, and that there was an unlawful killing of the victim by an act that was imminently dangerous to another person. So was there an imminently dangerous act? There is an instruction for imminently dangerous as well. I have provided it very, very concisely here, but you will also be provided this instruction from the court. When you actually read through this instruction, the part that can get confusing is prong 2. Is this done from ill will, hatred, spite, or an evil intent? The act of shooting a gun at another person is inherently done with ill will, spite, or an evil intent. That is what I will assert to you about this second degree murder definition and instruction included in imminently dangerous to another person. You also, as to the lesser included offenses, will have manslaughter and attempted manslaughter. What happens with these lesser included offenses is, so you say first degree murder, second degree murder, has that been met, or alternatively manslaughter, has that been met. And for manslaughter, that is a lesser included offense as it relates to first and second degree murder. And the only elements therein are that the state has established that the victim is deceased and that the defendants intentionally committed an act that caused that. It is somewhat different in the attempted manslaughter by act because the person is not deceased. So did the defendants intentionally commit an overt act that would have resulted in the death of the person that they committed the act upon, but they were not successful? This is Suni Bell. This victim was hunted down by the defendants because they wanted to accomplish one goal, and that goal was to kill the occupants of the silver Infiniti they saw driving behind the jet. It was driving too slow. It was parked for 1 minute too long in the field. Whatever their motivation, they targeted this vehicle, this child, this family.
Overruled.
The defendants in the video treat the Jet, the Chevron gas station, like some kind of a bunker in a war zone. They hunker down, they take cover, they get armed, they put masks on. And the only enemy that they encountered was Suni Bell and her family. There's no excuse for what happened. The defendants acted together with a joint goal, and they've accomplished that goal. At least one person inside of that vehicle was killed, and the other two victims of that attempted murder will never be the same. The evidence supports a finding of guilty as charged as it relates to all of the defendants seated before you. Because you don't need to be the sole person to pull a trigger for this death to be on your hands. Thank you.
Defense?
May it please the court, counsel, ladies and gentlemen.
You can use that.
Good afternoon, ladies and gentlemen. I'd like to take a moment to thank you all on behalf of Zavante Sampson for your patience and your attentiveness over the course of this several-day trial. I'd also like to apologize on his behalf as well to you. This, to put it mildly, has been a very emotional process for everyone, and it has taken its toll on Mr. Sampson as well. You know, all of us have our commitments, and all of us have our jobs and our families and our personal obligations, our work. And as we sit here for these days listening to this testimony, the evidence, the admitted documents, the videos, I think that we all understand how important this whole process is. It goes without saying that I strongly disagree with the state's assertion and their view of what's seen in these videos, which are critical pieces of evidence for you to digest. After however many times they're reviewed and what they're alleged to show. It's pure speculation. I urge you to look very closely at all of these videos. They all bring something to the table, but I would suggest that you focus certainly on the Chevron videos, the East Tampa gun and pawn video, which shows the parking lot of the Chevron, the Lorenzo's garage video, specifically as it shows the interaction with Zavante Sampson's car and Willie Brown's vehicle. because I believe that the evidence has shown you that it contains a great deal of pure speculation. I'd ask you to pay attention to it in its entirety, and certainly you have the option, as I suspect you will, to view this video in slow motion, to view it regarding Mr. Sampson and Mr. Sampson's actions, which I think are important. But when you start talking about what someone thought, what someone said, what someone did, look at it in real time too. Because as the state has indicated to you, and I don't have the numbers, and presumably someone has written it down, this happened in a very, very short period of chaotic time. You can and you should have sympathy. So sympathy is an emotion. Sympathy is sometimes something that you can't just work around. But verdicts in this case must be based on the law, not based on any sympathy for victims under the law, Suni Bell, Willie Brown, Mary Harrison, or based on any anger that you may have toward any one of these defendants, in particular in my circumstance, Zavante Sampson, over the horrible outcome that happened here, or even his outburst in such an emotional state this morning. I told you that much of the week during our jury selection that you would hear the state and many of its witnesses say they did this, they said that, they did this. I asked you and you promised me to separate these defendants and the evidence set forth as it relates to each of them. This would include a determination as to whether or not they are principals, and whether any of them, in particular Mr. Sampson, conspired so that a particular crime would be committed. The judge is going to instruct you on conspiracy, and Ms. Ismer talked to you a bit about that, and I just want to make sure we're all understanding criminal conspiracy. Because in order to find someone to be in a conspiratorial capacity, there has to be two elements. Remember how we talked about elements in jury selection. We talked about some crimes and some theories have two, some have three, some have four. Whatever the case may be, the elements is that the intent of Zavante Sampson was that the offense of murder in the first degree be committed. In order to do that, Mr. Sampson had to agree, conspire, combined and with a confederation among themselves to cause the murder in first degree to be committed. Understand that it's not necessary that this be expressed in a particular word or particular set of words. And those words don't have to pass between conspirators. Be mindful, and we're going to talk about principles a little bit later because it's another very, very important theory that we've been discussing throughout. Be mindful of what each lawyer has elicited during the course of this trial from the witnesses. Not just myself, and as well in their arguments. Be mindful of the evidence that applies to each of them individually, and whether it shows guilt beyond to the exclusion of a reasonable doubt. Be mindful of the proof the type of proof, what is the quality of the evidence provided to you by the state for your review. Your deliberation is multifaceted. We talked about that in jury selection. It has to be segmented, and it has to be specific as to Zavante Sampson and what he did and how the facts apply to him. The judge is going to instruct you that when you have multiple counts in an indictment and multiple defendants, a separate crime is charged for each defendant in each count of that indictment. And the evidence applicable to him must be considered separately. A finding of guilt or not guilty as to one or some of the defendants must not affect your verdict as to other defendants or other crimes charged. Let's talk for a minute about direct and circumstantial evidence. Direct evidence is evidence that tends to prove a fact directly that is in question in a case without the necessity of reliance on the inference of proof from other facts. Circumstantial evidence, on the other hand, is evidence that first, in and of itself, has to be relevant, and second of all, it has to be of a quality that leads to an inference that an event occurred or didn't occur. The quality of the evidence is important in circumstantial evidence as well. And that circumstantial evidence, in and of itself, needs to be proved beyond a reasonable doubt. Things that lead you to other things are dangerous, and they need to be looked at very, very closely. The state is asking you to rely on circumstantial evidence in a number of ways. Certainly, as we look at the underpinning of this case, and we will talk about it a little bit later, there is the principles theory. And I'm not suggesting that you throw it in the garbage can. I'm suggesting that you look at it very closely as to its application as it relates to each and every one of these crimes. Leap number one, they're asking you to make a determination that Zavante Sampson intended that a killing take place. That Zavante Sampson conspired and had an agreement with other people to do so without any evidence as to what was said at the Chevron during the time that he was hanging out there for those hours, while he was in the parking lot, or while he was in a vehicle with Quandarius Hammond. Leap number two is that the state is again asking you to infer that Zavante Sampson intended the killing of Suni Bell or the attempted killing of Willie Brown and Mary Harrison to occur. And that he did so by intentionally doing some act that incited, caused, encouraged, assisted, or advised someone else to commit the crimes he's charged with. Having said that, I want to talk to you a little bit about the evidence that we heard during the course of the past several days. We weren't there, ladies and gentlemen. We must search for cooperation in order to render a fair and impartial verdict. We heard from Willie Brown. Willie Brown told you that he didn't intend to go to the memorial service at DeSoto Park that day, and he got there late. He talked about the fact that when he got there, he parked in his car a little bit away from what was going on, and he saw Mary Harrison. Mary Harrison is someone that he was going through with it at the time, along with some other family members that appeared to be having some issues. After smoking some marijuana, they set off down East Hillsborough Avenue. Something just doesn't seem right as it relates to his testimony, ladies and gentlemen. He alleged that he didn't know anything about going to the gravesite for a balloon release. Mary Harrison told you that that was the intent. He never had any substantiated conversations with his cousin, Charles Dozier, Squeak, or Corey Brown about this salon after party. But when prompted, what he did tell us is that he buys marijuana from Corey Brown. There's no evidence of any other family members going to Corey Brown's salon or shop. And I'd ask you to consider Willie Brown's real connection to this trip and what he was trying to accomplish. What Willie Brown does say, which is very important, as you consider the evidence in this case, is he said that Suni Bell was screaming when he got out of the car after the first set of gunshots are discharged. He told you that the shooting stopped momentarily and that the car continued to drive forward as he got out. It's also important to note that there was only one set of shots prior to him running away, and it was those initial shots that got him out of the car. At this juncture, I ask you to look at Willie Brown a little closer. I'd ask you to look at the object that appears to be in Willie Brown's hand in Defense Exhibit number 1, inside that circle and with the arrow. Take it back, look at it closely, consider it in your deliberations as to what Willie Brown may be doing. He told you that he didn't carry a gun. He told you that he didn't discharge a gun. But to corroborate this object, I urge you to take notes and go look at the 45th Street Coberly video, which is State's Exhibit number 13, and watch it at 21:05:46, and you'll see this same object in Willie Brown's hands as he is crossing the street, crossing the driveway into the roadway. Please look at it. Detective Saleha testified that he didn't see a muzzle flash from Willie Brown's car, but that would have been very difficult to do based on where the camera in Lorenzo's garage was positioned, because it was on the other side of the driver's compartment of that vehicle. It was on the passenger side. Review the Lorenzo's garage video as many times as you feel it necessary. Willie Brown told you that he ran down 45th Street and he continued to hear gunshots and believed that someone was chasing him and shooting. He ultimately located Michael Coberly to contact 911. Ladies and gentlemen, recall that Zavante Sampson was arrested on September 30th, 2021, and Detective Saleha testified that he took Mr. Sampson's statement. After being apprised of his arrest for premeditated first-degree murder and conspiracy to commit first-degree murder, he told you that Zavante Sampson, after originally requesting a lawyer, decided to speak with him.
All right, we're getting word there's a verdict, you guys. Getting word there's a verdict. So hang in there. We're getting word there is a verdict. Just give me a second. Hold on, we're getting word there's a verdict. We're getting word there is a verdict. So hold on. Hold on. We're getting word there is a verdict. Give us a second. We're getting word there is a verdict. Just bear with us while we get a feed. We're getting word there is a verdict. Judge is going to give about 5 minutes to have everybody get to the courtroom. So just give us a second. Let's try and find a feed for you guys. No feed yet. Let's hang tight. Hang tight while we get hang tight. We're getting word there's a verdict. Getting word there is a verdict. Checking out two sources. So hang on. Hang with us. Hey guys, whatever does happen, I know it's going to be emotional, so we'll just try to be respectful. All right, we have both sides in our chat. Just try to be respectful of both sides. All right, this is about Suni, and we have both sides in our chat right now. So just be aware. That's all I'm asking. Just be aware. We don't need to. Let's just react with some compassion. Because we have both sides in our chat, let's just be aware of that. Still waiting to catch the feed. Feed still isn't up yet. Judge is going to give about 5 to 10 minutes. So yep, keep it civil. Just keep it civil. Just be aware. We have both sides in our chat, so just be aware. That's all. We're all on Suni's side, exactly. Do I like muffins? Sure. Hey, Gordon, good timing. Thanks for coming in. Sorry, guys. Sorry. Okay. All right. I'm sorry, I just had to do that. I think that's where it's going to come up, so sorry to blast your ears, sorry. It'll be a few minutes. All right, 316, the word came down. We have a verdict, Ellen. We have a verdict and we're just waiting for somebody to pick it up and stream it. We do ask that you guys just be respectful. We have both parties in the chat right now, so let's just be respectful of each other, regardless of the outcome. Just be respectful of each other. It is incredibly sad. I agree, Kelia. It is incredibly sad. Legal-minded friends, looking forward to hearing from Sam. Me too. Me too. Tammy, you came back just in time. Yep. So apparently we have a verdict. We're just waiting. We're waiting for... Just waiting for somebody to stream it. Just hoping for somebody to stream it. Yeah, okay. Or, yeah, okay. Prayers for everyone. Baby Sunny. Again, I just ask you guys, we have people from both sides. BJ, you got it, man. Thanks for covering the trial. Thanks for being with us. Appreciate it. Appreciate you. I know, Gordon. I know. We have intel from inside. We have intel from inside. So we're going with our inside. So guys, again, we have people from both sides in our chat. So just be respectful. That's all I ask. Just be respectful. Yeah, it's going to take them about 5 or 10 minutes to get everybody in. It's going to take them about 5 or 10 minutes. The judge wanted them within 5 or 10 minutes of the court, so. Judge says, Judge told him don't be more than 5 or 10 minutes away. Don't go further than 5 or 10 minutes. So I'm just trying to find trying to find a feed, you guys. All right. Trying to get a feed here for you guys. Just hang tight. Hang tight. Yep, that's me typing, Virtuous. That would be me typing. I'll admit when I'm typing. That was me typing. We have two sources that we've been watching the whole time, and I've got eyes on both of those sources, and nothing yet, but our intel is inside the courtroom, so we're going with that. If anybody would know, they would know. So we're waiting for one of those streams to kick in. All right, they have to be brought up one at a time because they can't have any contact with each other. That's why it takes a while. So they have to be brought in one at a time. They can't have contact with each other. So that's why it's taking time. I just want to get to a seal. So they're each of the defendants have to come up one at a time. So that's why it's taking time. What is that? Still no feed. Still no feed. Yep. All right, hold on, guys. I think our feed's coming in. All right. I think our feed is coming in. All right, I think our feed's coming in, you guys. Just give it a second. All right, so just hang tight while this feed sorts out. Chief Judge is there. It's gonna be a big deal, you guys. All right, I just ask that you be respectful. We have both sides in the in chat. All right, we got a feed. All right, we got a feed. All right. Again, I just ask that you guys just be respectful. We have both sides in our chat right now. If you're coming in fresh, just be respectful. If it gets too emotional, just we may have to delete your comment. I'll just say that right off the bat. Let's just be respectful of each other. Yep, I hear you, BJ. I'm nervous for both sides too. So please be respectful. Please be respectful. All right. So we just had James walk in. That's James there. James just walked in. The elected public defender is there. They're bringing in everybody. This is a big deal, you guys. This is a big deal. And I say, please be respectful, chat, no matter what. We are family. So just be respectful. That's all I ask. Hold on a sec. All right, if you guys are coming in fresh, just be respectful. We got people on both sides on this, so in the chat. So just be respectful. Be respectful of the verdict. Be respectful of the families. Be respectful to each other. That's all I ask. Let's just be respectful. All right, Jalen. It's Jalen. Jalen's just brought in. So far we have James and Jalen. They're sitting there at the desk. Sure Life, if the verdict is as confusing as the trial, I may need help. You're not the only one. You're not the only one, Shore Life. You are not the only one. So 267 votes. How long will the jury deliberate today? They started at 8:05. So they stopped at 14:30, basically. So 8:05, 8 to 14. It's over 6 hours. So 14:29. 14 hours, 29 minutes is my unofficial clock. So 14 hours, 14 and a half hours roughly, again, unofficially. Verdict is in again. Verdict is in. Verdict is in. We have 2 of the 5 defendants. Oh no, wait, is Quandarius there? Is that Quandarius standing up? That may have been Quandarius. I think that was him. That said 6 plus 2. Oh yeah, so let's see. We said, how long will the jury deliberate today? 29% said 6 plus hours. So that's where we went. We went from 8 to 6.5. 2 to 4 hours, 29%. 6 to 4 hours, 28%. And 14% of you said 0 to 2 hours. Putting on a shirt and tie. Yeah, was that Quandarius? I just got a quick glance at him. Well, Zavante is not going to be. Will he be there? I don't know if he'll be there or not. They may keep him out of the courtroom. No, okay, who's that? Somebody else is coming in. Is that Andrew? I think that's Andrew. Yeah, I think here comes Andrew coming in. All right, so that's Quandarius to the left. That's Andrew. So here comes Andrew. So that's 4 out of the 5 now. So Andrew's on the right. Quandarius is on the left. Oh, don't freeze on me now. Yeah, don't freeze on me now. Don't you dare freeze on me. And there's James and Jalen. So James is on the right, Jalen's on the left. I think they have to be present in person for verdict. What about Daryl Brooks, right? He had to be present no matter what happened during the course of the trial. He had to be present. So Zavante's the last one. He's the last one they have to bring in. I'm going to go grab some water real quick. All right. So 4 out of the 5 are there. Everybody's there except Zavante. Let's see. Can we do a quick poll? Let's see here. Let's see. All right. Got a new poll there for you guys. All the bailiffs are there. Let's put it that way. All the bailiffs are there. So we got a new poll for you guys. What will the verdict be? Not guilty for all 5, guilty for all 5, hung on some, or mixed verdict? I count 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, at least 10. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, maybe 11. We got 11 bailiffs, I'm counting. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, possibly 12, 13. Well, they probably have to have like 2 or 3 per defendant. Right, I would say like 3 per defendant, so you probably, yeah, they need at least 15 bailiffs. Just on that side, just on that side of the room. Oh, 25, we have 25 bailiffs. 25 bailiffs is the word from inside the court. And a nun. 25 bailiffs and a nun. So there's a nun there. 25 bailiffs and a nun. Go figure. Oh, here, I can bring myself down now. I don't need to be big anymore. Bring myself down here. Turn off the clock. Turn off the clock for the actual verdict. Do you want to turn off the clock? Who asked for a nun? I don't know. That's what our intel is telling us. There's 25 bailiffs and a nun. 25 bailiffs and a nun walk in. Altercation took place during the trial. That's why it's heavy bailiffs. Sorry for the caps. It's all right. No worries, BJ. We'll let that one fly. We'll let that one fly. Okay, turn off the visibility. Okay. All right. Hello, Ann. Good to see you. Darlene, thank you. No spoilers. We're watching this as live as it can get, so we're even going to find out before you guys find out. Joanne, that would be Zavante. One accused missing. That would be a Zavante. During the state's closing, he got up and he was saying that he got shot at first, and they escorted him out, put him into another room, and that's where he stays. What if one of the bailiffs is a nun? Could be. Oh, is that Zavante? I think they're bringing him in now. I think Zavante's coming. Yep. Yep, so Zavante is coming. So we do have Zavante's out there. So Zavante's coming out. So they do have him. Bridget, I think we may be shocked at some of the verdicts.
he's back. You all may be seated. Thank you. All right, ladies and gentlemen, my understanding is that you all reached a verdict?
Yes, sir.
And you are the foreman, sir?
Yes, sir.
If you could hand that verdict form to one of the deputies. Thank you, sir. Yes. Madam Clerk, if you would publish the verdict form.
State of Florida versus Quandarius Hammond, Zavante Sampson, Jalen Bedward, Andrew Thompson, and James Denson. Verdict form: we, the jury, find as follows as to count one of the indictment as to Quandarius Hammond. The defendant is guilty of the first-degree premeditated murder of Suni Bell, as charged, and did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We, the jury, find as follows as to count one of the indictment as to Zavante Sampson. The defendant is guilty of first-degree premeditated murder of Suni Bell, as charged. We, the jury, find as follows as to count one of the indictment as to Jalen Bedward. The defendant is guilty of the first-degree premeditated murder of Suni Bell, as charged. We, the jury, find as follows as to count one of the indictment as to Andrew Thompson. The defendant is guilty of the first-degree premeditated murder of Suni Bell, as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We, the jury, find as follows as to count one of the indictment as to James Denson. The defendant is guilty of the first-degree premeditated murder, as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. Count two, we, the jury, find as follows as to count two of the indictment as to Quandarius Hammond. The defendant is guilty of the attempted first-degree murder of Mary Harrison, as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We, the jury, find as follows as to count two of the indictment as to Zavante Sampson. The defendant is guilty of attempted first-degree murder of Mary Harrison, as charged. We, the jury, find as follows as to count two of the indictment as to Jalen Bedward. The defendant is guilty of the attempted first-degree murder of Mary Harrison, as charged. We, the jury, find as follows as to count two of the indictment as to Andrew Thompson. The defendant is guilty of the attempted first-degree murder of Mary Harrison. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We, the jury, find as follows as to count two of the indictment as to James Denson. The defendant is guilty of the attempted first-degree murder of Mary Harrison, as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. Count three, we, the jury, find as follows as to count three of the indictment as to Quandarius Hammond. The defendant is guilty of attempted first-degree murder of Willie Brown, as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We, the jury, find as follows as to count 3 of the indictment as to Zavante Sampson. The defendant is guilty of the attempted first-degree premeditated murder of Willie Brown as charged. Count 4, we, the jury, find as follows as to count 4 of the indictment as to Quindarius Hammond. The defendant is guilty of conspiracy to commit first-degree murder as charged. We, the jury, find as follows as to count 4 of the indictment as to Zavante Sampson. The defendant is guilty of conspiracy to commit first-degree murder as charged. We, the jury, find as follows as to count 4 of the indictment as to Jalen Bedward. The defendant is guilty of conspiracy to commit first-degree murder as charged. We, the jury, find as follows as to count 4 of the indictment as to Andrew Thompson. The defendant is guilty of conspiracy to commit first-degree murder as charged. We, the jury, find as follows as to count 4 of the indictment as to James Denson. The defendant is guilty of conspiracy to commit first-degree murder as charged. Count 5, we, the jury, find as follows as to count 5 of the indictment as to Quindarius Hammond. The defendant is guilty of shooting at, within, or into a vehicle as charged. We, the jury, find as follows as to count 5 of the indictment as to Zavante Sampson. The defendant is guilty of shooting at, within, or into a vehicle as charged. We, the jury, find as follows as to count 5 of the indictment as to Jalen Bedward. The defendant is guilty of shooting at, within, or into a vehicle as charged. We, the jury, find as follows as to count 5 of the indictment as to Andrew Thompson. The defendant is guilty of shooting at, within, or into a vehicle as charged. We, the jury, find as follows as to count 5 of the indictment as to James Denson. The defendant is guilty of shooting at, within, or into a vehicle as charged. Count 6, we, the jury, find as follows as to count 6 of the indictment as to Quindarius Hammond. The defendant is guilty of discharge of a firearm from a vehicle as charged. We, the jury, find as follows as to count 6 of the indictment as to Andrew Thompson. The defendant is guilty of discharge of a firearm from a vehicle as charged. We, the jury, find as follows as to count 6 of the indictment as to James Denson. The defendant is guilty of discharge of a firearm from a vehicle as charged. So say we all, dated this 17th day of September 2025, signed foreperson of the jury.
Would the attorneys like the jury polled?
Yes, Your Honor.
Yes, Your Honor. Madam Clerk?
Juror number 1, is this your true and correct verdict?
Yes.
Juror number 2, is this your true and correct verdict? Yes. Juror number 3, is this your true and correct verdict?
Yes.
Juror number 4, is this your true and correct verdict? Yes. Juror number 5, is this your true and correct verdict?
Yes.
Juror number 6, is this your true and correct verdict?
Yes.
Juror number 7, is this your true and correct verdict?
Yes.
Juror number 8, is this your true and correct verdict? Juror number 9, is this your true and correct verdict?
Yes.
Juror number 10, is this your true and correct verdict? Yes. Juror number 11, is this your true and correct verdict? Yes. Juror number 12, is this your true and correct verdict? Yes. Thank you.
All right, ladies and gentlemen of the jury, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by a court order. For many centuries, our society has relied upon juries for the consideration of very serious and difficult cases, and we have recognized for hundreds of years that a jury's deliberations and discussions and votes should remain their private affair so long as they shall wish it. Therefore, the law gives you the unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone you would like to about your work and your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious. It could come from those who might seem to find fault with your decision, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a jury. And with that, I now release you from your services in this case with a thank you.
All right, the verdict.
Jury select, may be seated. All right, is there any consensus on when you would like to have sentencing, if not today?
Your Honor, Mr. Denson is entitled to a pre-sentence investigation because he has no prior felony convictions. I would request that the court order
All right, we can do that even though he's entitled to a pre-sentence investigation. Count 1 carries a mandatory life imprisonment.
Understood.
So, for the sake of housekeeping then, I would just carry everyone along to that same day so that we can get the score sheets together. The points on the score sheet are going to matter as to how I fashion my sentence in this case, even though count 1 is a mandatory life. On say October 27 at 8:30 for sentencing on all 5 defendants, unless there's a major conflict with some or more of the attorneys.
That's fine for me.
All right?
That's fine, sir.
All right, October 27, 8:30 in the morning for sentencing. They'll be remanded to the custody of the Hillsborough County Jail. I will adjudicate them all guilty on all accounts, and they will be held without bond.
Court stands in recess. Please exit.
Make sure we have our lockers.
My client is younger than Mr. Denson. He may be entitled to
He's entitled to a pre-sentence investigation, but he has no prior record. Any prior felony record? Does he have any prior felonies? Well, if he doesn't, I mean, anyone is entitled to a pre-sentence investigation.
I would ask the court of that.
And so your client and Mr. Fichetti's client?
Mr. Bedford.
Mr. Bedford and Mr. Denson. The court will be in recess.
All right, we're going to try and find if there's any press releases, because there was a lot of bigwigs there. So we're going to see if there's going to be there's got to be a press conference. So just to recap, guilty across the board. There was no not guilties. Everything was guilty, guilty, guilty. Yes to possession, yes to discharge, yes to shooting at, within, or into. Just anything that you can think of, they were found guilty. Yeah, there was no hung, no, not guilty on this. Even the drivers were found guilty on possession of a firearm and discharge of a firearm. Even the drivers were found guilty of that. So, and yeah, it sounded like there was at least 3 women. I always want to hear what the makeup of the jury is, and I got to it too fast. But so sentencing is going to be October 27th. We're going to try and find a press conference next. But count 1, all guilty. Count 1, all guilty. Now we're going to go and try and find a press conference. Just hang tight. So count 1, first degree, and possession of a firearm, all guilty. Count 2, which was Suni, that was for Suni Bell. Count 2 was Mary Harrison, attempted, all guilty. All yes to possession and discharge of a firearm. Count 3 was attempted on Willie. That was Quandarius and Zavante only. So count 3 was Quandarius and Zavante, because they were the ones that. So Willie ran away. By the time cars 2 and 3 came, Willie had already gone. So that's just count 3 was just Quandarius and Zavante. Count 4 was conspiracy, guilty across the board. Count 5, shooting at, within, or into a vehicle, guilty across the board. Yeah, they got Zavante on that as well, and and Jalen. They were the drivers, and they got them on that. Count 6, discharge, and that was just Quandarius, Anthony, and Jalen. So those were just the 3 that shot at. So it's funny that. So count 6 was. Okay, you have shooting at, within, or into was all 6, but discharging was just the 3 that actually shot. All right, so that makes sense. All right, let me see if I can find see if we can find a press conference. If you guys find one, please go out, hit the YouTubes, guys. If you find a press conference, let me know. And just let me know where it is, and we'll try and pull it up. This is where we help each other. If you guys find a press conference somewhere, let us know. We're going to look on some local channels. We're going to keep it. Yeah, that's the old adage, Lily Wayne. Yeah, bank robber, driver. Yep, driver's guilty. Even if you're not holding the gun, you're still guilty. I'm just surprised at the shooting at. I'm surprised that they got the drivers for shooting at, within, or into a vehicle, as well as the possession of and a discharge. That's what surprised me. That's all. Was that they got the drivers for discharging or shooting at. They got discharging. They got the discharging for the 3 that actually just shot the firearms, but they got shooting at for everybody that was in that vehicle. So think about Car 2. We know Car 2 is out there. We know there's at least 2 other 9mm firearms that were found. Casings were found on scene. So Car 2, if you're listening, I don't know what to tell you, but I don't know. Did you dodge a bullet? Is that proverbial? Did you just dodge a bullet? Cars 1 and 3 are on the hook, and they're going away for life. Car 2, what are you doing? Car 2, what are you doing? Are you breathing a sigh of relief? Are you upset? If you're in Car 2, what are you doing? What are you feeling? Because Car 2 was just as involved with this as Cars 1 and 3. All right, waiting for possible press conference. We'll stick around for at least a half hour because these things take time. So let's see what we got here. Wondering if they are still investigating Car 2. Amy, they said, the lead investigator said that there's not enough evidence. They think they know who got in the car. They have a pretty good idea who got in the car, but that's as far as they go. They can't identify. They don't see muzzle shots. They can't. That's as far as it goes. So they don't have enough evidence. That's from the lead investigator. So Car 2 moved to Venezuela, right? Yep, Car 2 got lucky. Yep, same, Ellen, same. We reached out to a source, so we're hoping that we hear back from them. We'll try them again. That's all I can tell you is that we'll try them again. All right. Sherry says, I don't agree with that particular verdict about the drivers, but I understand. Yeah, I wonder if these 5 now will. I mean, do you have anything to lose at this point? I guess you could. Yeah, I mean, if you snitch, you're still gonna get it, even if so. Millie says, I live in Hillsborough County. I've been on that road a million times. I don't understand why the gas station let them hang out there. Well, Millie, there's one scene where the looks like the owner gives a fist bump, and I think it's to Zavante. I think it's Zavante. I could be mistaken, but I think it's him. He gives a fist bump because the guy, he fist bumps, then he walks into the back room. So I thought the same thing, but also according to some people in chat that they're they just hang out there on their way to go do something else, go out to a bar, restaurant, dancing, whatever, to another party. So it's just kind of a meeting spot. Car number 2 has now been classified as a UAP. Ellen, I have this feeling we don't know the whole story, also because the defense said nothing. This is incredibly sad. I totally agree with you. We do not know the whole story. We did not hear the full story. Pammy, I can't tell you how many times I've been pulled over, been in the wrong place. It's scary for this kind of reaction. Oh, so many times you had to. Pammy, I agree. I've been in situations where after dark you don't stop at the stoplights. You just go through. I mean, I've been in those situations too. Best not to put yourself in those situations, but if you are in those situations, UAP is an unidentified, it's a UFO basically. They've changed it. It's no longer aerial phenomenon because it goes into water too. Unidentified something phenomenon. It's basically it's changed from UFO because of the stigma. Now they're calling them UAPs. So that's all. And Shirley's telling you, aliens. Yeah, it was real quick. It was real quick. They were showing, they were identifying the defendants, and I'm pretty sure it was Zavante, but whoever did a fist bump with, and it looked like it must have been the owner because he does that, and then he turns and he walks to the back room. So I'm like, oh, that's the owner. Because I thought, is this like some kind of protection thing? Like, hang out here and protect me from the rest of the, I thought maybe it's a protection kind of thing. But apparently he's cool, and nothing, we've had people in chat, nothing bad happens at this place. This is the first time this has happened. So even though by a couple people in chat, this is not the best part of Tampa. So otherwise that guy'd be robbed out of business. If he was robbed and it was a bad part of town to the point where he's robbed out of business, he's not going to be there anymore. And that's just going to be a vacant lot. Patsy, you missed the verdict. You missed the verdict. Legal, in South Africa, we had a friend shot at a red stoplight. Very sad. Car hijack. Yep. Anomalous. Thank you. That's what it is. Unidentified anomalous phenomenon. You really enjoyed that live. Thank you, Cross-Examnesia. Yeah, because it used to be aerial, but then now they're talking about under the water. So it used to be flying, unidentified flying objects, and unidentified aerial phenomenon, but now it includes water as well. Phenomena. Yes, I like saying that word, phenomena. All right, waiting for any kind of press conference. Probably not going to get one, but you never know. You never know. Let's see what else we can find. Let's see. It might be one of those things where they talk and then we don't hear, they'll put them on the 6 o'clock news or something like that. It might be something like that. Crossing. I think the same thing when I think phenomena. Do, 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 do. Phenomena. Do, 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 do. Phenomena. Do, 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 do. Phenomena. Phenomena. All right. If you guys find anything, let me know. I'm on Fox 13, FLA. Let me know if you guys see any press conferences or anything. Phenomena. Do, 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 do. Phenomena. Do, 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 do. Phenomena. Do, 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 do. Phenomena. Oh my God! Sometimes you have to take light in really sad situations. You know what I'm saying? Sometimes you just have to make light. Let's see. Well, it's only been like 15 minutes, so I'm going to give it a little bit more time. I do, Ed. I used to watch that with my brother. We'd watch, I think, Johnny Carson and then Benny Hill. You'd love a concert by me? Richard, you've been... let's see, hold on. Hold on. Richard, you've been shot at for no reason, not fun? Yeah, I'm sure. Jennifer, I've had 3 people gunfire in your neighborhood within 20 yards over the past 10 years. Yikes. Yikes. Kathy, my son would talk about Nami when he was really little. We finally realized it was an animal. You need to make it into a blues song and play it for us. Chris says, Angelique, yes, you missed the verdict. If you want us to tell you, we will. If you don't want us to tell you, we won't. No, not really. I can howl. All right, I'm just waiting for a press conference, any kind of press conference, anything. Tell us, okay, the verdict was guilty across the board. So count 1, all 5 were guilty, and all were found guilty of possession and discharging. Count 2, so count 1 was Suni Bell, first degree. Count 2 was attempted on Mary, all guilty on that. Count 3 was attempted on Willie, all guilty on that. Count 4, conspiracy to commit first degree. That was all 5 guilty on that. Actually, count 3 was just Quandarius and Zavante. So let me start over. Count 1 was first degree for Suni Bell. All of them were guilty. Count 2 was attempted on Mary Harrison, Suni's mother. All guilty on that. Count 3 was just Quandarius and Zavante. That was attempted on Willie Brown. All those 2 were guilty on that. Count 4 was conspiracy of first degree. That's all guilty on that. Count 5, shooting at, within, or into a vehicle. All guilty on that. Count 6 was just Quandarius were the shooters, the three shooters, Quandarius, Andrew, and James, all guilty on that. So, to recap, everything. They were guilty on everything. Anything and everything they were guilty on. Jennifer, thanks for the recap. I misunderstood. I thought each count was a different defendant. Yeah, no, it was count 1, count 2 were all of them. Count 3 was just car 1 because they said by the time cars 2 and 3 came, Willie had already left. So you got count 1 is Sonny, count 2 is Mary, count 3 is Willie. So count 1 and 2, because Mary and Sonny were in the car the whole time, that's everybody. Count 3 was just for Willie, so that was just car 1. Count 4 was conspiracy, that's everybody. Count 5 was everybody, because that's shooting at, within, or into a vehicle. And then count 6 was actually discharging a firearm, so that was just the 3 shooters. So that's how that broke down. Spectrum 9 has completed story and verdict. Well, do they have a press conference? Do we have a press conference? Let's see, is there a press conference? Still doesn't bring us Sonny back, I know. I know, Barry, I know. It's okay. Will they receive life without parole? Yeah. Yeah, and you know, it's mandatory life, and life in Florida means life without parole. So there is no parole for them. There will be no parole. So they're they are now they are going to get some pretrial PSIs, I should say, pre-sentencing investigation, because they are young. James and is Andrew, right? Andrew is 22, I think, right? And James is 24. Yeah, Andrew's the youngest. He's 22. Oh, I'm sorry, Jalen. Jalen's 22. So Jalen and Andrew are 22. So they're going to get some pre-sentencing reporting and investigating. So they're going to try and get some mitigating factors, meaning, you know, these guys are young. You know, Jalen was just the driver. Andrew's phone pinged outside the area. So I don't know. The judge, I'm not sure what the judge is going to do. We'll have to see what he's going to do. But they're definitely going to get some mitigating factors, saying, you know, these guys, they're young, they've never been in trouble before. You know, can you give them like maybe 25 years, give them some sort of hope that they'll come out, maybe when they're 60 or something like that. So there's that. All right. Oh, let me end the poll. What do we think the poll was going to be? Hold on. All right. Let's see. 184 votes. What will the verdict be? Guilty for all, 45%. Mixed verdict, 40%. Hung on some, 11%. Not guilty for all, 4%. I thought it was going to be I think I went with mixed. No, did I go hung? I think I went with hung. I think I did hung. Not sure. I forget now. All right, nothing's going on there. Let's see. All right, not finding any. All right. Got a little Suni Bell blues. Can you guys hear that okay? Let me know if you can hear that okay. Can you hear that okay? Just let me know if you can hear that okay. Can you hear that okay? Let me know if you can hear that okay. And I have Richard in the kitchens. Hear that okay? Okay. I'm going to call this the Suni Bell Blues. I'm not going to sing though because I don't have lyrics, but. All right, you guys. That's a little something for Sunny. So, with that, I will say goodbye. Suni Bell, I hope you rest easy. And whether you agree with the verdict or not, I hope this helps you find peace. So, all right, guys, thank you for joining us for Suni Bell's shooting trial. I know it was a difficult one. It was emotional. I appreciate you guys being with us and being the chat that you are. So, with that, we will see you tomorrow. We're going to pick up on Florida versus Jose Soto Escalera. That's also out of Florida. That's also a difficult case. But thank you for joining us. I always leave you with kitties, so let me leave you with some kitties. We got little kitties. Kitties over there. So, all right, guys, thanks for joining us. And think about Sunny tonight. Hopefully she's finding some peace. All right, guys, we'll see you tomorrow. Thank you to our mods. Thank you to Erin for all that she does. And thank you for joining us, chat. And we'll see you tomorrow. Bye.